My Lordship, this is regarding emergency parole, my Lordship. Emergency parole.
What is
The
the
mother of the
emergency?
convict has passed away, my Lordship. Mother of the convict has passed away. 2:30, my Lordship.
My lords, this is that surfing matter, my lords, wherein my lords on the last date has asked us to serve on all the respondents, my lords. My lords, we are challenging the candidate not being selected in the Asian Games, my lords. Even though he has a better ranking than the candidate who has been selected. On the previous date, my
Service
lords,
is complete
we have served everyone, my lords.
tomorrow.
May be taken tomorrow, my lords.
Yes, tomorrow.
Great.
It's one matter for the end of the list, please, wherein a couple, both of them being major in age, have married and being residing in Bangalore. The girl's parents, not liking the same, have preferred an FIR. It seems that they have preferred an FIR in the jurisdictional Tumkur police station, and they are being called there to give statement. They have threat to their life, please, once they go there. I'm asking also for police protection. And it has happened here in
It
Bangalore.
come under 528 or GM police barata 528 barata.
GM police, because we don't know which FIR they have filed. We have not asked for quashing.
Post before the appropriate bench. 2:30.
I'm a student here. I have a scholarship exam in the month of November, for which passport is a mandate. The Lordship was pleased to issue notice to the regional passport officer. This will be kindly taken up tomorrow, Your Lordship, because there is a timeline for which the passport has to be submitted for the scholarship exam.
Friday thoroughly.
Please, Your Lordship.
Matter to the yesterday, the Lordship gave date for police for today, but still it's not extended. For recalling the orders.
Yesterday we did not give you any date for today.
Even memo book mention ಆಗಿದೆ. Memo book ಕೂಡ mention ಆಗಿದೆ. Memo ಕೆಳಗಡೆ ಹೋಗಿದೆ.
ಮೆಮೋ ಅಲ್ಲಿ ಇವತ್ತು ಅಂತ ಕೊಟ್ಟಿದೀವ. ಮತ್ತೆ ಯಾಕೆ ಬಂದಿಲ್ಲ? ನಾಳೆ ತಗೊಳ್ಳಿ, ಅದು ಯಾಕೆ ಬಂದಿಲ್ಲ ಚೆಕ್ ಮಾಡಿ.
Because it will affect me at the NCL.
It's a pending matter. It cannot be taken up at 2:30. That much you should know. Yes.
Pending. The civil matter police has issued the notice to the bank has seized the account. The Lordship has ordered to issue notice to the respondent. Sir, post it on 22nd. Yesterday it was posted in B group. That is the real my bank account has been seized. Lordship
Is it from outside state or within state?
Within state.
Within state. Then you have the crime number. It's on the instruction.
Police has issued the notice.
Correct. The police must have issued on the basis of a crime number which has been registered. So you'll have to go there for lifting of it, not before this.
The fact is pending before this court. Has ordered to post on 22nd. But
Mr. Counsel, there are two sets of matter. One is outside state and one is within state. Outside state, you can go to the cyber command. They are trying to help you out. If it is within state, if there's a crime number which has been registered, you'll have to approach that court. This court cannot do anything in that. If you want it to be still here, it can be here. It will come in the regular course.
Yesterday it was posted in B group.
Mr. Counsel, we'll only have to dismiss it. Please understand. You are not availing of the proper remedy. Don't come before the High Court and say that it is urgent. Go before the proper court.
Even the summons is not issued. But theft has been committed in an 82-year-old house.
82-year-old house. So, Nade, tomorrow. Whatever date has been given, it will come on that. We are not going to extend any time. We are not going to extend any time. Mr. Srinivas, we are not going to extend any time. We told you clearly, categorically on that day that is the date. You asked for some day, we gave you 2 more days extra also. We are not going to extend any date. When is the election? Tomorrow? Society Registration Act, you can't have that society.
Point here is that they that release some protection in terms of not to develop that or abolish that laws. Now they approached this High Court. This High Court said no further proceedings. Stay on further proceedings. They're going on demolishing these laws. That's where the issue is.
A society registered in Societies Registration Act cannot claim any right. That is what the division bench has said. So that is what we'll observe and dismiss it. Kodi. Cooperative society is not before this court. ಇವತ್ತಿದೆಯಾ ಡೇಟ್ ಇದೆಯಾ ಹಾ ಬರುತ್ತೆ ಕೋಆಪರೇಟಿವ್ ಸೊಸೈಟಿ ಇಲ್ಲಿ ಹೆಂಗೆ ಲಿಂಕ್ ಆಯ್ತು ಸ್ಪೆಷಲ್ ಆರ್ಡರ್ ಆಗಿದೆ ಸ್ಪೆಷಲ್ ಆರ್ಡರ್ ಆಗಿದ್ರೆ ನಾವು ಮಾಡಕ್ಕೆ ಜನರಲ್ ಆರ್ಡರ್ ಅದು ಕನೆಕ್ಟ್ ಹೆಂಗಾಯ್ತು How did it get connected? ನಾಳೆ ತಗೊಳ್ಳಿ ನೋಡೋಣ. Yes. Land acquisition matter doesn't come before this court. Tomorrow. What is regular course? What is it? Kodi. Yes, it will come in the regular course. DRT matter. DRT is not before. Nammunde alla. GM DRT is not before us. Very GM res. Not listed today. ಯಾಕೆ ಇದು ಮೂರನೇ ಮೆಮೊ ಇದು all compliance have been done. We listed 2:30 for only purpose of listing and we'll adjourn it to tomorrow. Because the pending matter we can't take it up. 2:30 third. Just a moment, please.
Well, I'm a quarry lease holder. The local villagers are coming and sitting during the blasting operations in my mining lease area, my lords. As of now, we are unable to conduct any operations in the lease area, my lords. Because we have sought police protection in the writ petition. That's in this WP.
You have to file a suit, not here. Regular course.
My lords, this matter is already disposed. My lords, we have filed application seeking extension of time to comply with the court order.
Extension of time for what?
My lord, 4 weeks time was given to comply with court orders. Petitioner could not do so.
What were you to comply with, Mr. Counsel?
He had to submit few documents to the court.
Already next week after.
My lord, petitioner has received the notice for Gadipar, my lord, so kindly take the matter to.
Notice only you will have to go and reply. Kodi.
My lord, the connected matter to this writ petition is already listed on 7th August for preliminary hearing. And I'm requesting the honorable court to enlist this matter
7th
on
August.
7th August.
Can you please maintain some decorum?
23.
Yes.
All are extension of.
We can't hear you when they speak. Speak loudly.
There are 3 matters, my lord. 2 are for extension of, 2 are for general parole and 1 is for emergency parole.
Fifth or fifth.
One matter pertaining to harassment by a police constable. Pending matter.
Pending matter will come in the regular course, please.
Harassment is continuing.
Come in the regular course. Yes. Sorry? Madam, please wait. Huh. Has he been served with notice? Then you have to file an appeal for regular course. Fresh matter. Day after tomorrow. Very nice, 2:30. urgency ಏನು?
The traditional, the 50 has been cancelled with the AC. Because it was gifted for our maintenance. The petitioner's father and the brother.
Senior citizen matter. Koti, Bharat.
My lord, it's a fresh matter, my lord. After subjection, everything is clear. 23/6, we have filed the.
What is the
filing.
urgency for you mentioning?
My lord, it's in trial code 2014 matter, my lord. Till the matter
Come
is
in the regular course.
kindly, my lord. I requested, my lord.
Jewels were stolen and pledged in the bank, my lord. The bank have obtained the order for releasing the police has seized that jewels, my lord. And the bank has obtained the order to take it back, my lord. Due to that order, the police are not releasing the jewels, my lord.
Criminal proceedings are pending.
The criminal proceedings are
You'll have to
pending,
file
my
an
lord.
application there, madam.
There we have filed, my lord, but
Ah.
due to this order for retaking back the jewels, my lord, they are not releasing the jewels, my lord. So part of the jewels have been released, some part which are pledged in the.
Next week avutara.
The administrator has been retired from the post. And there's an interim order in this case.
Sorry, what? Administrator?
Administrator has been retired from the post.
Pending matter.
Fresh matter. And the interim order has been granted in this case. But we have to give salary to the workers.
So it's a pending matter, it's not a fresh matter. It will come in the regular course. Yes.
Adjournments. List number 1, page number 5, serial number 39. Page number 6, serial number 40 to 45. Third.
Counsel for the petitioner seeks for a short accommodation released on 3rd September,
Your Lordship, 14th, Your Lordship.
not on your date, yes.
Your Lordship, the reason being is that the senior.
You should have filed it today, Mr. Counsel.
The changes have occurred yesterday, Your Lordship. They have filed one more writ.
10th October,
Your Lordship.
next.
Page number 7, serial number 46 to 50.
Yes. If petitioner is no more, how are you filing a memo for withdrawal, madam? Who has authorized you to file it? You'll get into trouble by filing something like that.
Because there is nobody to sign and they are not pursuing this matter.
Yes. That you can make a submission. You can't file a memo for withdrawal. 47. Learned counsel for the petitioner is before this court seeking for the following reliefs. When did he expire?
And that's 2 months of time, I'm not sure about it.
Learned counsel for the petitioner submit that the sole petitioner is expired and there is no one who has contacted the petitioner to bring them on record as a legal representative of the petitioner. In that view of the matter, petition is dismissed as abated.
Page number
My
8.
Lord, item 49.
Yes.
Lord, in this case.
My Lord, I'm in item 49.
Yes.
We want to file a rejoinder to the reply, the objection they have given, and some documents to be produced. My Lord.
Lord, in this case, DPTP Act, they are claiming the compensation of ₹3 crores and also a least fraud. This court is of the prima facie view.
You filed your objection, they want to file.
We have
their-
already filed objection.
They want to file a rejoinder.
My Lord, in this case, below.
Any interim order is there?
CJM has been made as, Chief General Manager has been made as.
Is there any interim order in this matter?
No, my
For you to get it. Why?
MD CJM has been made.
ಅದಕ್ಕೆ ಏನಪ್ಪ?
In each and every petitions, my Lord. ಅವ್ರಿಗೆ notice ಆಗುತ್ತೆ. ಅವರು
Counsel for the petition
No, they are
seeks
not
for and
an
is
SL
granted
party.
2 weeks time final to file this rejoinder. Rejoinder, if any, to be filed on or before 20th August, failing which will be taken as not filed and matter proceeded with, released on 1st September.
My Lord, before that.
Much obliged.
My Lord, it's last week of, my Lord, pressure on.
Released on 28th August.
Much, sorry.
100 mail ಇದೆ.
Page number 8, serial number 51 to 56. Page number 9, serial number 57 to 61.
Serial number 60, Lordship, a week's time may be granted.
Serial number? 60.
60. A week's time may be granted. Counsel is not keeping well.
The request of counsel for the petitioner released on 3rd September.
Much obliged.
Page number 10, serial number 62 to 64. Page number 11, serial number 65 and 66. Page number 12, serial number 67 to 69. Page number 13, serial number 70 to 76. Page number 14, serial number 77 to 80.
My lord, item 87, my lord.
Yes.
There also I would like to file a rejoinder with some documents.
We informed the other side also.
Right. You inform all the
Yes.
councils? And counsel for the petitioner seeks for and is granted 2 weeks time to file his rejoinder. Rejoinder, if any, by 20th. Failing it will be taken as not filed matter proceeded with. Relist on 3rd September.
The same, no,
Same first
the
date, my lord.
previous date, my lord.
28th August.
No, first, my
No,
lord,
September.
previous
Previous
matter
matter was 1st September.
He requested for earlier date, so we gave 28th August. So this also will have it on 28th August if you want it on the same day.
Then let it be 3rd.
3rd September.
Second, my lord.
Between instructing counsel and senior,
I'm
don't
sorry.
embrace the senior counsel.
I'm sorry, my lord.
On third.
When the senior counsel is making submission, you should hold
I'm
your
sorry,
horses.
my lord. I'm sorry.
Apology.
We won't give you both the dates. We'll give you 9 September.
Much obliged.
Yes.
Submission.
Ah.
3rd October, my lord. We have an execution. 3rd October. Request release.
97.
Yes, my lord.
97. Have you informed everybody?
I informed the advocate for ED.
97 at the request of the petitioner party in person, 3rd October.
That's my lord.
3rd
My
October.
execution is dragging on because the other side has created a fraudulent e-kata. So
Okay, 3rd
3rd October. my lord.
Yes.
Thank you.
3rd October is Saturday.
Yes, my lord. It's working.
Saturday we won't be sitting.
Any other?
5th October.
List number 1 for being spoken to, serial number 1, RB Sadashivappa.
Petitioner, there is no.
We told you yesterday not for being spoken to, you have prevailed upon.
No, this was not listed yesterday, therefore it is being listed today.
The connected matter is listed on 27/8, my lord.
We list on 27/8.
The interim order request.
Interim order.
My lord, this may be connected with WP 2200.
But yesterday it was there.
Fresh matter, serial number 2, Siddharth B. Muchandi.
Petitions.
Yes.
Seeking for my lord mandamus to consider representation. Seeking a mandamus to consider representation. My lord, the
What is your representation?
my lord, annexure H, my lord, page number 107, please. It is applicable, my lord, the
07.
representation given to the Commissioner of Police. There's a matter relating to, my lord, a temple and a trust. And they are the petitioner number 1 is a trust and the petitioner numbers 2 to 10, my lord, are the trustees. And my lord, the respondent number 5, my lord, who's my lord, interfering with
Respondent number 5.
Respondent number 5 claims to be, my lord, one of trustee. He files a suit.
And AGA accepts notice for respondent number 1 to 4. Issue notice to respondent number 5. Returnable by 9th September.
Please.
Serial number 3, Vijay Kumar.
Same matter, Lord.
Yaudu.
Page 376, my lord.
376.
This honorable court pleased to grant an interim order. Sanction of prosecution is under challenge. In respect of the committee members, my
There is
lord,
no 376.
sorry, my lord.
376 ಯಾವುದು ಇಲ್ಲ. Your wakalat ends at 374. Annexure?
Annexure N.
ಏನೆಲ್ಲ ಕೊಡುಕದು.
Sorry, 372, my lord. 372.
372. 372 is order sheet.
The interim order was granted by this honorable court, my lord. And this identical matter, my lord.
Oh, there is that series of 13.
Yes, sir.
What is your role?
Lord, I was at that point of time, I was working as assistant controller of accounts. The committee was consisting of 4 members. Lord. The first is Lord, the joint commissioner of DBMP. There is no proceedings against the joint commissioner. And in respect of the executive engineer and the chief engineer, Lord, the technical heads, the government have rejected the sanction of prosecution. And only in respect of the fourth member of the committee, my lord, assistant controller of accounts.
But you are a member of the committee.
I am a member of the committee. Only in respect of me, sanction of prosecution has been given.
The others where we have granted stay, they were not members of the committee.
They were, my lord. Kindly see annexure J, my lord, page 190.
119. There are only 4 members, Andri Vaga.
How?
One
190. Annexure J. My lord, page 204, my lord. 203 is the order. And in respect of 32, my lord, work orders, my lord, so the sanction for prosecution against the technical heads, my lord, chief engineer and the executive engineer. My lord, sanction has been rejected.
You were a member of the committee.
I am a member of the committee.
We'll serve and issue notice, let them get back. And AGA accepts notice for respond number 1 and 2. What about respond number 3, Karnataka State Accounts and Audit?
Lord, that is state government only, my lord.
State, my lord, state.
There's some confusion last time.
Yes,
Somebody
Lord.
else appearing.
Madam Swati Panduranga was director. She was, in fact, when I spoke to Madam, my lord, said appearing for the central government, not the state government.
And AGA for respond number 1 to 3. Council for the.
My lord, respond number 2 will be BBMP, my lord.
BBMP is there, my lord. For 1, 2.
1 and 3, I'll take note.
And 3 AGA. Is the BL Sanjeev who has filed wakalat before issues of notice, accepts notice for respond number 2. Relist on when is the one?
The other matters are coming up on 18th, my lord.
18th.
Interim order may kindly be, my lord, granted in this matter also.
Not as a committee member now. Connect with WP number 35778 of 2025.
Another matter is listed at serial number 59, my lord.
When it reaches, please.
Please.
Serial number 4, Gauri Shankar.
The petitioner, my lords. My lords, writ of mandamus, my lords, for consideration of annexure G, my lords, complaint. My lords, here, my lords, the petitioner is residing in Mysore, my lords, in a house where 3 persons go to the house stating that her father has sold the property to them and they're seeking to demolish the property, my lords. For that, she approached the jurisdictional police, my lords. That police did not receive the complaint, my lords. In fact, he supported the people who were demolishing the house, my lords. Your lordship may kindly see page number.
Are there photographs?
My lords, the photographs are not produced.
So how do we
My lords,
say
we
that
have
you're
filed an
demolished?
application for RTI, my lords, where the police has assaulted the petitioner, my lords, in the police station.
Madam, we find all allegations being made against the police.
My lords, in the
But
RTI application,
if there is some demolition which you claim has happened,
my lords, demolition has not happened so far, my lords. They are just threatening.
and AGA accepts notice for respond number 1 to 3, seeks fund is granted a week's time to obtain instruction and make a submission. Relist on 19th August.
Grateful.
Serial number 5,
Yes.
Lords, appearing for the petitioner, my lords. Petitioner is the father of the deceased, my lords. Petitioner is the father of the deceased, my lords. Lords, he sought for a fair and impartial investigation, my lords, in view of the fact that the local police have not taken action, even after repeated representation, repeated complaints being given, my lords.
When
It's a
did you
case of
file
suicide,
it?
my lords, on 15/5.
When was it there? When did you file
15/5/2026, my lords.
Hmm?
15/5/2026.
Yes. And the
On
complaint was
16th
filed on 16/5.
16/5. He was, the petitioner herein is a resident of Uttar Pradesh, my lords. He's a teacher over there. He has come down all the way immediately upon.
It's just been 2 months for them to
My
do
lords,
the
there is no
investigation.
action that's been taken. In fact, they go to the extent that there is a preliminary report given. It's a handwritten note, my lords. There is no investigation that's been
Case of
conducted.
suicide, my lord, my instructions are, and
But you have
investigation.
to file your final report.
Kindly see, my lord, crime number is 35/2026.
Correct.
Date of death is 2026 in the month of May, my lord. Lord, my, and it is,
15/5/26.
they have registered it under 194, my lord.
Correct. 194, you have to do the inquest.
Inquest, my lords. That
Inquest
is
has
not
to,
been.
then 196, you have to submit a report to the jurisdictional police.
Please, my lord. Now, if my lords may kindly see their prayer, they are seeking for transfer of the investigation, my lord.
Lords, that is my prayer because
The
there is no
status
fair.
of the inquest, that normally everybody is asking. Transfer.
My lords, it's a peculiar
Thankfully,
case.
is You have asked for that also.
That also,
Please,
I think.
CBI.
CBI, my lords,
Everything,
that has to be.
CBI has no work, only
Lords,
everything has to be done.
if the agency, if any other investigation,
Not that.
independent investigation agency is taking up, my lords, we have no problem, my lords. However, there is no response from the authorities, my lords. The petitioner, in fact, has visited Bangalore so many times. He's not getting any action.
It takes some time. 2 months is what has happened. They have to do the inquest.
my
The
lord.
report has to come. Postmortem report has to come. The forensic has to happen.
Lords, in fact, if I may, my lords, Annexure F, my lords, page 34, what they've given, it's a handwritten note, my lords. A parent who has lost his child, my lords, he's been given a handwritten note like this.
Yes, Mr. Shishir, let us find out what this
Okay.
one has happened.
You're sorry.
Case of suicide, my lord. He has hanged himself. It will take some time for investigation, my lord.
Yes, but how long?
Please, my lord. I have
Tell him
asked
it
the
will take some
concerned
time.
person to come along with the file, my lord. He said he will.
And AG accepts notice for respond number 1 to 5. Shri Prasanna Kumar is directed to accept notice for respond number 6. And AGS seeks for and is granted a week's time to obtain instruction and make a submission as regards the status of investigation in FIR number 35 of 2026, registered by the Marathalli police station. Released on 19th August.
Obliged, my lords.
Serial number 6, Praveen Kumar.
The account order, Annexure A, page number 10, my lord. This order passed by the Deputy Commissioner and District Magistrate, Bangalore, Urban District under Section 55 of Karnataka Police Act.
We
Order to
issued
depart
notice.
the petitioner from the territorial jurisdiction of
We issued notice. Notice was issued to you, Annexure A.
notice issued, my lord.
And you have appeared.
But is not contested.
But he remained absent.
The apprehension, my lord, in order to prevent him from.
Why did you not appear before the district magistrate? Notice where you had given the invitation, you did not attend.
But the apprehension, my lord, he will continue the offense in the locality. The
Your
only
apprehension-
criminal case is registered against this petitioner.
You should have
In
gone
the year
before him and made
2014,
your
my lord.
submissions. You can't say, I won't go before him and then come and file a writ petition. Can you do that? And you have appellate remedy. When notice has been issued, you should appear before the authority.
Yes, ma'am.
They're not going to wait for you. We'll give him one opportunity, madam. Let
Please,
him go and make a submission.
He'll grant liberty to approach the authority.
He accepts notice for respond number 1 to 4. Petitioner is before this court seeking for the following leaves. What is being challenged is the order of externment under section 55 of the Karnataka Police Act 1963. Though a notice had been issued to the petitioner chose not to be represented before the executive magistrate. The same, though not being a reason which can be accepted, considering that the order passed is one of externment. The submission made by learned counsel for the petitioner is that he has a good case on merits. This court is of the considered opinion that an opportunity could be granted to the petitioner to present his side of the story before the executive magistrate. In that view of the matter, this court passes the following order. Writ petition is allowed, certiorari is issued, Annexure A is quashed. The matter is remitted to the second respondent, executive magistrate. The petitioner shall appear before the executive magistrate without requirement of any notice at 2:30 p.m. on 20th August 2026 and file his written objection as also make his oral submission on that date. The executive magistrate is directed to consider the same and pass necessary orders within 30 days thereafter.
Much.
Serial number 7, Patil Jayam.
Lord, I am appealing for the petition.
Yes, madam.
Lord, here, my lord, the stamp duty as per the Annexure C has not been accepted by the respondent herein, my lord. Saying that the property which is mentioned in Annexure B will not fall into the jurisdiction of this. My lord, it is only a.
Where is the property located?
No, that is like it is in Andhra Pradesh,
Then how
just
can-
to carry out some mining activity. Now there is no, now the jurisdiction, I mean, the jurisdiction of the courts is mentioned at Bangalore. in Annexure B. My lord, even the parties are residing in Bangalore only, my lord.
What is the joint development for?
My
Joint
lord?
venture for?
To carry out some mining activity in the
Where?
Andhra Pradesh.
Andhra Pradesh.
In Andhra Pradesh.
Lord, it is in Madanpalli somewhere.
Hmm. He has been executed in there, not in the jurisdiction of this court, this sub-registrar.
Lord, it is just a
You can just go and
agreement. ಏನು ಇದರಲ್ಲಿ
Then why
rights
are
ಏನು
filing a writ
ಅಲ್ಲ
petition for
ಪ್ರಾಪರ್ಟಿ
this?
ರೈಟ್ಸ್ ಏನು ಕನ್ಫರ್ ಆಗಿಲ್ಲ ಇದರಲ್ಲಿ. Just to carry out the activities. Now the CMP was filed before this honorable court and the arbitration, the claim is before the arbitration tribunal.
Actually, only for payment of stamp duty, not for registration also.
It is only,
You are getting your revenue.
that was the one of
I
the
was also
objection raised.
I was also thinking of the same thing, my lord, but document is, my lord, executed in Andhra Pradesh, works are in Andhra Pradesh. That's the only reason. Otherwise, I don't think he would have rejected it.
It doesn't say it has been executed in Andhra Pradesh.
All the works, my lord, are in Andhra Pradesh.
It doesn't
And
say
now
where it has
Party
been
is from
executed.
Calcutta.
Here also they have an office, my lord, in Bangalore.
How can they determine what is the stamp duty for a proper mining activity in Andhra Pradesh?
Lord, they're also not accepting. We attempted to pay there also, my lord. They're saying since it is now no activity, my lord, this agreement is in, now there is a dispute between the parties. The arbitration proceedings are going on, my lord. In the CMP, that was one of the objection raised by the respondent. That is the reason it was called for the report by the registrar in this, by this honorable court, my lord.
We can't issue a mandamus for this particular purpose. It is only to be impounded.
Impound on,
You're-
my lord,
you're
like
trying to
it
overcome
can
the-
be paid and there is a report,
But trying
10
to-
times the penal, 10 times ಅಂತಾನೆ ಮಾಡಿದ್ದಾರೆ report ಅಲ್ಲಿ.
You are
At
trying to
Annexure
overcome
C.
the impoundment. We can't give a mandamus in that.
Lord, now the arbitrator, learned arbitrator can't impound the document.
He can impound the document. Impound and refer
We'll
it.
exercise.
So that is the process to be followed. A mandamus cannot be issued when you have defaulted earlier. And AG
But
accepts notice
thereafter
for
only it was called for the report to pay the 10 times the penalty. Annexure C, the report has been
This is a report, there is no order passed.
order ಇಲ್ಲ.
ಮತ್ತೆ order, report ಮೇಲೆ order ಆಗ್ಬೇಕು ತಾನೆ. Once there is an order passed, then they will comply with it.
Please.
The petitioner had entered into a joint venture agreement on 17 July 2018. There being certain dispute between the parties thereto. A civil miscellaneous petition number 445 of 2022 had been filed under section 11 of the Arbitration Conciliation Act 1996, wherein a report on stamp duty had been called for. When was this? 23rd. This is 23.
Please, my lord.
Now the latest Supreme Court judgment is there.
Based on that only, my lord, that this report was,
You'll have to agitate in section 11 court, not before this court. What happened to CMP?
CMP has been allowed now, the claim we have filed it.
CMP has been allowed.
It has been
Then
allowed
arbitrate.
by your lordship.
Then arbitrate. CMP 445 of 2022 had been filed, when a report on the stamp duty was submitted by the registry indicating that the stamp duty payable was 200 rupees and penalty 10 times thereof would be 2,000 rupees, totally requiring a payment of rupees 2,200. Subsequently, the said CMP 445 of 2022 came to be allowed in view of the decision of the Honorable Supreme Court in re, what is that, this one? In re stamp duty. As regard unstamped agreement, what is that citation? Citation code. We have the judgment and so on. Now the matter is pending before the arbitrator. The contention of learned counsel for the petitioner is that the document not being stamped could not be exhibited in the said proceedings. And in that background, the petitioner had approached the second respondent for the purpose of stamping of the document, which is rejected by the respondent on the ground that the document was executed in Andhra Pradesh. The joint venture pertains to mining activities in Andhra Pradesh, and as such, the respondent would not have jurisdiction to stamp the said document. It is in that background that the petitioner is before this court seeking for the opposite relief. Having perused the documents, what is seen is that the document has not been stamped at the time of execution. Is one of the parties who is now sought to unilaterally stamp the document. Earlier, a report had been submitted by the registry of this court regarding the stamp duty payable, as also the penalty payable. However, no order has been passed in relation thereto. There being a default on part of the petitioner in making payment of the stamp duty on earlier occasion, now that the petitioner seeks to exhibit the said document in the arbitral proceedings, it would be for the arbitrator to impound the said document and pass necessary orders which the authorities would be bound to comply with. A mandamus cannot be issued in the above circumstances. In that view of the matter, reserving liberty to the petitioner to approach the arbitral tribunal for purpose of impounding of the document and passing of necessary orders in relation thereto, the petition stand disposed.
I think NN Global, NN Global or
Not NN Global. INRI stamping, NN Global was the older one. The constitutional bench judgment, 7 judge benches.
Serial number 8. Suhail Ahmed.
Mr. Suhail Ahmed. Madam.
My lords, this is a matter where there's a tripartite agreement. My lords will be well aware. And we are asking for the bank from taking any courses.
Subvention scheme.
Yes, my lords.
I'll take notice for R1 and R2, but my lord may kindly see there's no relief against the Union of India. Appears, I'm just making that
You have to come up with some policy for this.
Yes, my lord. Yes, I understand. I just want to say that.
So many matters are coming up.
But if they can ask for additional relief, my lord, I will be able to help out in this matter.
In additional relief.
Our very sixth respondent pay the money asked to my lord may kindly see the prayers. The prayers is direction, nature, and mandamus, restraining sixth respondent from demanding any repayment of the IMIs.
You can take note of
send
a report to the concerned. The subvention scheme matters are coming up by dozen.
Yes, madam.
Some of the matters, two of the companies now are in CIRP. Because they are in CIRP, we are sending them there. This is a mercy petition. Nothing else.
I understand.
They can't pay. There's no
Project is not completed.
Apartment, nothing.
Yes.
But what they fail to realize, which we have been telling them, is that the clock continues to tick.
Yes.
Yes, my lords.
You only get a respite for a
Correct,
temporary period.
Even if the
But the bank is continuing to levy interest.
We understand that, my lords. My lords, in another matter, my lords have held that RERA has jurisdiction, but my only difficulty is the Supreme Court holds that when 13-4 SAFESI proceedings are initiated, only then I have jurisdiction against the banks before RERA. So that is why I've come before this court.
13-4 is a direct challenge to it, yes.
Yes,
Even
my lord.
otherwise, for the seeking of interim relief, RERA would be a possible authority.
My lord, yes, my lord. In fact, I am aware of the judgment. That is only in case where there is a mortgage, not in this case. This case, unfortunately, she has no property even.
Please allow.
So there's her, it
There
will,
is a
RERA will
tripartite
have
agreement
jurisdiction
in
here.
all these.
No, it will, RERA will have jurisdiction here.
The tripartite agreement.
The second page, fourth point, I'll give you. One minute. Fourth and fifth, my lords. RERA has jurisdiction to entertain a complaint by an aggrieved person if the bank takes recourse of any of the provisions contained in 13(4) of the SAFESI Act. And in this case, that has not happened. In most of the cases, it has not happened because for the fear of the CIBIL score getting affected, the people are continuing to pay the EMIs, my lords. It's actually a lot of public money that's getting affected, my lords. There's no relief at all, neither before RERA because we're not able to bring the banks, and there's no immediate relief before RERA. And the circulars are getting violated, and therefore Union of India, we're not able to take it up before any court.
You see para 4, it
Yes, my
only
lords.
says RERA would not apply
Yes, my lords.
if the mortgage has been created
Yes, my lords.
prior to the RERA coming into force.
Yes, my lords.
RERA came into force in 2017. When was
2017.
your?
My lords, this is in 2023. But the
It is
reason.
out of para 4.
Yes, my lords, I have read it. It says that RERA would not apply in relation to transactions between the borrower and the banks and financial institution in cases where security interest has been created by mortgaging the property prior to introduction, unless and until it is found that the creation of such mortgage or transaction is fraudulent or collusive.
Even
So if
there,
it is
that
prior
exception
to
is there.
RERA, there is a.
Even prior to RERA also, fraudulent collusive is exception is
Yes,
there.
my lords.
But post the RERA,
Post RERA, 13(4) has to be invoked.
please again read para 4. RERA would not apply in relation to the transaction between the borrower and the banks and financial institutions in cases where security interest has been created by mortgaging the property prior to the introduction of the act. If it is post the act, it would be applicable. Unless and until it is found that the creation of the mortgage or such transaction is
My
fraudulent or
lords.
collusive.
I understand, my lords.
Even that exception is available prior to the act.
Yes, my lords. But if it is post the act, then the bank has to take action under 13(4) for recovery. Only then I can get into, I can invoke 31 under RERA because bank
It is
has to.
clarified that para 36(4)
Yes.
5 reproduced and above shall be applicable in a case where proceedings
it's
before the
not
RERA
clear.
authorities are initiated by the home buyers to protect their rights. With this, the special leave petition is dismissed. So the
Yes.
clarification was also issued to
Yes,
go
my
before the RERA.
My lord,
Consider
there again,
this
my
as
lord,
the judgment.
13(4) will only come when there's a mortgage. But
Yes,
here,
my lords.
further, her it's, I'll take notice, my lord. I think she's right. I'll take notice.
You take notice, but
What help?
your clock is ticking.
My lords, we have, what is the relief that we have, my lords?
As per this judgment, you have to go before the RERA. Please look at it properly and advise your clients.
My lords,
Now, we'll issue notice. We'll stay this for 1 year. The clock doesn't stop.
we'll take necessary action, my lords. In fact, most of them are
And
also
finally,
before
what will
RERA.
happen to you is you will neither have the apartment or villa or the money.
Yes, my lords.
This
I understand, my lords. I
And
understand.
my lord, the
lords.
nature
We'll
of
take
relief is saying that restrain them from demanding this. As a contract, private contract between two parties.
Can't do. That's why we are
It
not
can't,
granting.
You modify it.
The Krishnan accepts notice for respond number 1 and 2. Pradeep Savkar for respond number 3. National Bank. Sukanya Baliga for respond number 4. Velantini Ravi for respond number 5. Tata Capital.
Yes, my lords.
Who is the
JM Patil.
JM Patil for respond number 6.
Give him
LM Infinite. Any either you GM Infinite.
JP Dashkan.
JP Darshan for respond number 7. Counsel for the petition to furnish 2 sets of the petition along with annexes on the said counsel. Shri Unnikrishnan Learned Counsel for respond number 1 and 2. He is directed to obtain instruction and make a submission as to what recourse a home buyer can have when the project has not been completed by the developer and the bank from which the home buyer has taken a loan is insisting on the payment of the regular EMIs in relation thereto under a contract between the home buyer and the bank. When will you get back?
I can get back in 2 weeks, my lord. Or date can be fixed. So
Yes, my lord.
date
Released
can be
on
fixed.
18th.
Not an
August.
adversarial litigation, my lord, I will support.
This is
my
not
lord.
adversary. You have to look at what
Yes, I
has to be done.
Yes.
Because even under CRP proceeding, now they have been given a, by way of amendment which has
Yes,
happened.
yes, yes.
They've been given that status. So in pending proceedings also, why not?
Yes.
If you
Come
can
along,
come
we'll
up
fix
with
it.
something, all these people,
Yes, my lord, yes, my lord. They all fell for that marketing wherein they said, we will pay your EMIs initially, and that's how it fell. And they were
Everybody
in the rat
loses.
race, all these institutions.
they lose because the money is there. The security is not there. The bank doesn't get the money.
Yes.
The building doesn't get done. The state government doesn't get its stamp duty. You don't get anything.
Yes.
Everybody loses.
Everybody loses.
18th August.
My lords, till the next date, the interim order may be granted, my lords.
They're not granting interim order because you approach the RERA. Liberty is also reserved to the petitioner to approach the RERA.
Please, my lords.
Serial number 9, J. Satish Kumar.
The petition.
That's for respondent. My objections are ready. I'll file it tomorrow.
Challenging this section 5(1)
They
PML
have
Act.
challenged the adjudicating authorities order.
Adjudicating
my lords.
authority. This coordinate bench of this honorable court has already taken view with similar circumstances, my lord. So the adjudicating authority, whatever order has been passed, it has been set aside and quashed, my lords. This is an offshoot of a case which has been filed against our farmer.
It's been quashed, is it already?
No, no, my lords, I'll explain. May kindly see the order, what has been
In
relied
a
upon.
different case, not in a similar circumstances.
Call for records of attachment.
My lords, may kindly come to 218.
218.
Please, my lords, is the judgment, my lords recollect, this is the same judgment which we had relied upon in another case, which is reserved. My lords, in this case, the court have held that because the khata is not made, so there is no scope of the property being alienated. May kindly come to my lords at page 252, para 62.
252.
Para 62.
Yes.
A perusal of the petition enclosed would indicate that the petitioner had sought for a direction to the MUDA for effecting transfer of khata with respect to sites transferred by sale deed dated so and so. In terms of the oral submission, the writ petition is still pending. If that is that way to show the question of transferring proceeds of crime, layering such proceeds would not arise. Any immovable property in the absence of mutation entry cannot be dealt by way of a transfer. Accordingly, the apprehension of the competent officer that if the provision attached is not resolved, there would be a likelihood of frustrating the proceeding is not based on any objective material having a nexus with the frustration of proceedings under the PMLA. Now, my lords, this order which has been challenged is adjudicatory authorities order, which is at page 24, my lords.
Yes.
This is a confirmation order of the provisional attachment order. Findings at page 54, my lords. This is an order against.
Finding at page?
Please, my lord.
Finding at page?
Page 54, my lord.
54.
4.
Yes. Yes.
Defendant number 10, 11, 12 contended that they are bona fide third-party purchaser who acquired the attached property from defendant number 4 to a registered sale deed for lawful consideration. They denied any, my lords got it?
Yes.
They denied any connection with MUDA officials or alleged illegal activity under investigation, contended the allotment in favor of defendant number 4 was
made pursuant to compromise decree and orders of the Honorable High Court of Karnataka. They further argue that no money trail connected them with any proceeds of crime, sought release of attached property. In respondent, the complainant submitted a defendant number 10 to 12 acted as a purchaser during the layering stage of laundering process by acquiring the site number so and so immediately after it is illegal allotment in favor of defendant number 4. The complainant submits that the property was purchased for 49 lakhs despite its actual stamp duty valuation of 1 crore 13 lakhs 30,000, clearly demonstrating deliberate and undervaluation intended to conceal the true origin of proceeds of crime. It is further submitted a transaction formed part of larger scheme orchestrated by real estate broker acting in collusion with Muda Commissioner to immediately convert illegally allotted site into cash and thereby layer the proceeds of crime. According to the complainant, the defendant's general line failed to explain the substantial undervaluation and unusual timing of the transaction and the surrounding circumstances establishing the laundering mechanism. It is noted that mere purchase of property through a registered instrument does not by itself establish the status of a bona fide purchaser, where the surrounding circumstance prima facie indicate that the transaction forms part of concealment, acquisition, possession, projection of proceeds of crime, as held by Honorable Supreme Court in so and so, so and so. Acquisition, possession of proceeds of crime independently attracts Section 3 of PML Act, while so and so recognizes layering and projection of proceeds of crime considered continuing act of money laundering. The substantial undervaluation, immediate transfer following allotment, and the material collected during the investigation regarding the role of intermediaries prima facie support the complainant's allegation that defendant number 1012 participated in the layering of proceeds of crime, warranting continuation of attachment proceedings. Now, my lords, they have appeared before the adjudicatory authority. My lords will get it at page 26. They are defendant number 10. Page 25, my lords. At defendant number 10, Krishna KM.
Yes.
Represented by counsels. My lords, next page are 10 to 12.
Jayamma Srinivas K.
My lords, this is that
K.
other matter, my lords.
10, 11, 12.
Yes, my lords.
Yes.
They
These are the
appeared
petitions.
before the court. They filed their objections before the court, before the adjudicatory authority. My lords, may kindly turn to page 39.
Yes.
At bottom, my lords, 10, 11, 12. This is gist of reply and rejoinder, my lords. The contention of the defendant number 10, my lords will get it at page 37. Defendant number 10, my lords. Krishna KM is one of the purchaser and present holder of site number so and so, which was originally allotted illegally as compensation under Muda scheme. The property acquired by him forms part of proceeds of crime identified during the investigation, represents a further stage in the transfer and layering of such proceeds through subsequent transaction. Then, my lord, gist of reply and rejoinder at 39, my lord's bottom. Defendant number 10 to 12 submits that they are bona fide third-party purchaser who acquired the attached site from defendant number 4 through a registered seal deed dated 27/7/2023 for lawful consideration. They deny any connection independently applied for compensation. Orchestrated by brokers. The entire allotment was orchestrated by real estate
Deny any
broker.
connection. So it goes to.
My lords, that 2 pages there, my lords, here, like this.
The left side is a column where their contention is there.
Yes, ma'am.
Rebuttal is on the right side. So
My
you
lord,
can't read the right side after they deny any
Yes, my lords,
connection with
Muda
Muda
officials.
officials on
Yes,
the
yes, yes.
next
I
page. you
stand corrected, ma'am. With the Muda officials or the least illegal activity under investigation, contented that the allotment of Srimati Ningama was pursuant to a compromise decree, Honorable High Court, they argue that no money trail has been established linking them to proceeds of crime and seek a
Where is this
release of.
compromise petition?
Is a
Compromise
page-
degree? Page number?
Page number, annexure L, my lords, sir.
Page?
Page 123, 133. my lords. That is the compromise petition, 133.
133.
Please. The plaintiff and defendant submit as follows.
Not the High Court, this is.
This compromise took place before the senior civil judge at CMM at Mysore, my lords.
Pursuant to the compromise decree and direction of the Honorable High Court of Karnataka is what you said. Where the direction of the Honorable High Court of Karnataka?
That's page number 133, Annexure L, which I am reading. Annexure L.
What is the direction of the High Court of Karnataka that you are referring
My
to?
lords, I will come to that page. That is at page number 126, my lords, Annexure J.
126.
Please, my lords. My lord, may I just brief facts of the case, my lords. Ningamma was the original owner of the property measuring 2 acre 14 guntas, my lords. The land was acquired without being notified, my lords. That has been challenged and compromise has arrived, my lords. In the meantime, the government of Karnataka passed an order with regard to the granting of monetary compensation, my lords. That has been decided where it came to be affected because of the notification, my lords. This honorable court intervened and it said you have to honor the commitment of whatever compromise that has taken place, my lords. That is at relevant page is at 131, my lords. Paragraph 5 is the from the beginning right under the nose of this honorable court, orders have been passed, my lords. There is no crime or the proceeds.
Order passed by this court, madam, approving the compromise.
My lords, may I kindly say,
Approve the
for-
compromise.
so far as Ningamma also, there is a role that she has played. That, my lords, so far as this property
Your
is
only
concerned.
contention is the valuation difference
My
between
lords.
49 lakhs and 1 crore 13 lakhs.
Yes, my lords.
49 lakhs is what they had paid.
Yes, my lord.
1 crore 13 lakh was the stamp duty as on the date on which the registration took place.
Paid.
So that is why it has to be paid.
My lords.
Even if there's an earlier agreement,
Yes, my lord.
it's the date on which the registration happens, that is the valuation. Which is,
My
that
lords-
cannot be on the ground that you can, when there are two judgments of the trial court in 2020 and this court in 23.
Yes,
Can
I
you still
probably have
override
to-
the orders of this court?
Because in that even I have to probably seek instruction because today I wanted to take time. They
We'll-
have it day after.
We'll
my
stay
lords.
it in light of
My
these
lords, may
judgments.
don't stay.
You
my
file
lords.
your objection, don't take any action.
My lords,
Take coercive action.
no, my lords, now this adjudicating authority's order has come. They have to challenge it before the appellate authority.
Madam,
I
if
will
the
not-
adjudicatory authority is acted contrary to the orders of this court,
My
it
lord,
doesn't
that has
matter.
not been placed before the adjudicatory authorities, before the
It has
adjudicatory.
been placed, that is what you read, that's why we asked you this. What is the decree and direction of the High Court of Karnataka? That's why we asked you that.
My
clear
lords,
direction
no,
of
no,
the High Court of Karnataka.
the Ningamma's judgment, which has been confirmed by this honorable court, is not placed before the honorable adjudicating authority, my lords.
Page 40, what you read,
Please, my lords.
that is what it is.
My lords,
Left side of page.
Has been
4.
submitted, copy has been furnished, my lords.
Pursuant to
That's
compromise
We have
decree
in
and
narration
directions
also,
of-
we have submitted in our reply.
lords, in that case,
Can't be acting contrary to the orders passed by this court.
please, my lord, I'll probably have to.
Learned Ms. Annapurna Bardole accepts notice for respond number 1 and 2.
Please.
Muda TP Vivekananda for respond number 3. Considering that the allotment of the sites was made in favor of Ningamma in pursuit of a compromise decree in OS number 348 of 2020, which has been approved by this court. on 13 June 23 in WP number 7102 of 2023, the subsequent sale by Ningamma to the petitioners cannot at this stage be considered to be a layered transaction. Hence, the operation of the order dated 29/6/26 at Annexure A is stayed till the next date of hearing. When will you file your objections,
My
madam?
lords, I'll file it in 2 days, a short day.
Learned counsel for respondent number 1 and 2. Submit that objections would be filed in 2 days' time.
Yes, sir.
Grateful. On 18th August.
Grateful.
Examine the
I
order.
will.
Can't be contrary to the orders
Yes,
passed by.
yes, of course.
Obliged.
Serial number 10, Sridhar K.
I appear for the
Yes, Mr.
petitioner,
Sridhar.
my lord. There was a civil dispute between petitioners and respondents 3 and 4. Injunction is granted in my favor. In spite of what, my lord, I am the owner of site number 7 and 13. The respondent 3 and 4 made a claim that 7A, 7B, 13A, 13B after lapse of 10 years and made a claim and filed a suit for injunction. That injunction was refused. Injunction is granted in my favor. There is a civil dispute pending before the matter civil court, my lord. Now the first respondent initiated proceedings under section 130 of BNS Act saying that you have to execute bond and surety. Police officer cannot interfere in the civil matter, my lord.
Yes, but if you are going to indulge yourself in law and order issues.
No, my lord, no, my lord, I'm a retired central government officer, first petitioner.
Where is
And
Annexure K page number?
Annexure K nalli. ಓದ್ಬಿಡ್ಲಾ 50ರಲ್ಲಿ
52.
ಎಸ್ ಮೇಡಮ್ ಕುರುಬರ ಕರಿಯಜ್ಜ ಪೊಲೀಸ್ ಸಮೀಪ ರಾಮಮೂರ್ತಿ ನಗರ ಪೊಲೀಸ್ ಠಾಣೆ ಬೆಂಗಳೂರು ಪ್ರಕರಣದಲ್ಲಿ ಪ್ರತಿವಾಳ 1ನೇ ಮಮತಾ ಕೋಮ್ ವೆಂಕಟಪ್ಪ 58 ವರ್ಷ ಮತ್ತು ವೆಂಕಟಪ್ಪ ಬಿನ್ ರಾಮ 72 ವರ್ಷ. ಇವರು ವೆಂಕಟಪ್ಪ ಈಸ್ ಎ ಸಫರಿಂಗ್ ಫ್ರಮ್ ಪಾರ್ಕಿಂಗ್ಟನ್ ಡಿಸೀಸ್. He is always confined to the house and a central government employee. ಎರಡನೇ ಪ್ರತಿವಾದ ಚೇತನ್ and ಶ್ರೀಮತಿ ಶೋಭಾ. ಶೋಭಾ ಅಂದ್ರೆ ಅವ್ರ ಮದರ್ ಅಂಡ್ ಸನ್.
This is a show cause notice, Mr.
My lord?
Sridhar.
Sure, no, my lord, I've appeared. No, I've appeared. He asked me to appear. Then he said that, no, my lord, no, you first you execute, otherwise I'll issue warrant. He threatened us. That statement I've made.
Have you filed your objections to this notice?
No, my lord, what he said, you first to furnish.
He says 100 things. What you are the counsel advising your client.
Correct.
What have you advised your client?
ಅಲ್ಲ ಇದರಲ್ಲಿ ಏನಕ್ಕೆ ಶೋಕ ನೋಟಿಸ್ ಅಂದ್ರೆ ಫಾರ್
Have you filed your objections to the show cause notice?
I appeared. Petitioner appeared. Then he said that you first furnish.
Alakne sati question kedada Sridhar.
No, in writing I have not submitted.
When will you file?
ಒಂದು ವಾರದಲ್ಲೇ ಕೊಡ್ತೀನಿ. Yes.
Law and order, that is the reason.
Law and order, central government employee.
Pass your orders. You can't be orally directing. And AG accepts notice for respond number 1 and 2. Notice to respond number 3 to 5 is dispensed with in view of the proposed order to be passed. What has been petitioner is before this court seeking for the following leaves. What has been essentially challenged is a show cause notice which had been issued under section 130 of the BNSS Act. Full format. A challenge.
My lord,
show cause notice.
if I may say respect, this is Adesha. It is an order, not notice.
ಸಲ್ಲಿಸಲು ಸೂಚಿಸಿ
ಭಾರತೀಯ ನಾಗರಿಕ ಸಂಘ 132 ಆದೇಶ. He has already.
Last line ಓದಿ.
ತಮ್ಮ ಸಮಜಾಯಿಷಿ ಸಲ್ಲಿಸಲು ಸೂಚನೆ ನೀಡಿ.
ಅಷ್ಟೇ. Show cause notice under section 130 of the BNSS Act. On inquiry with the learned counsel for the petitioner as to whether any written objections has been filed, learned counsel fairly submits that no written objection had been filed, but the petitioner had appeared before the first respondent. When a show cause notice is issued, it is required of the petitioner to have replied to the said show cause notice, and for the first respondent to have considered the reply and passed necessary orders. In that view of the matter, there is no interference required to required at the hands of this court, reserving liberty to the petitioner to reply to the show cause notice dated 12/6/26 at Annexure K, which reply shall be furnished by end of day 11th August 2026, and directing the first respondent to consider the said objection and pass necessary orders within 15 days thereafter. The petition stands disposed. Needless to say, until the orders are passed by the first respondent, no coercive steps can be taken against the petitioner.
Serial number 11.
Mr. Saad. Enable. Defreezing. None appears for the petitioner. Axis Bank.
Francis Xavier.
If Francis Xavier is directed to accept notice for the respondent, counsel for the petition furnish two sets of the petition along with annexures on Mr. Xavier, relist on 1st September.
Serial number 12. VR Sarathi.
Wait for the petition.
Okay, wait.
The issue is this. A tender notification is floated on 30/12/2025 as per Annexure B.
30/12?
30/12/2025.
5 years.
Lordship get it in Annexure B, page 22.
Yes.
The last date prescribed for filing in floating an application in pursuant to that is 7/1/2026. And the technical bid is opened on 9/1/2026. The financial is on 12/1/2026.
Yes.
The limited period which is prescribed under the rules 2022 in pursuant to that is 90 days. No action has been taken. On 30/3/2025, we have given representation stating that our bid is rejected on the ground that technical bid rejected on the ground that solvency certificate is not placed. But in fact, we have placed that. And in that regard, we submitted our objections, page 44, your lordship get it.
Who is the contesting respondent?
Contesting now after 6 months. Quite interesting is, your lordship, they approached the dishonorable court. After the period of lapse of the tender, they say that we have made a representation to the authorities with regard to the price in which they quoted. The honorable court records their statement. Your lordship get it in page 49.
49. Yes.
49. It's a small order, your lordship get it. I will read from the beginning itself. Learned counsel appearing for the petitioner and the learned additional government advocate on instruction fairly submit the present writ petition can be disposed with a direction to the tender authorities to examine the quotation furnished by both the L1 bidders. It is jointly requested that the authorities are directed to advert to the price quoted by the respective L1 bidders and undertake comparative assessment to ascertain as to whose quoted rates are in closer proximity to the prevailing market price. Recording the aforesaid submission and consensus between the learned counsel on either side, the writ petition stands disposed of. The respondent authorities are directed to consider the quotations submitted by both L1 bidders and to advert to the observation made by this honorable court while evaluating their respective claims strictly in accordance with law. So by the time they approach this honorable court, the period itself has been lapsed. This is they have approached this honorable court in the
But now there is an order passed by the coordinate bench. If you are aggrieved by this,
no, your lordship, I am not agreed by this.
Action has been taken in pursuance of this.
No. What the honorable court has only said, they record the submission and pass an order appropriated in accordance with law. So neither of the parties have placed it before this honorable court. The scheme is already lapsed.
So you can't place it in a separate petition before another bench. You'll have to go before the same bench. That's proprietary.
Because the court has never said.
That is for that court to say. That court has directed that everything should be completed within 4 weeks' time, and that they have acted upon and they have released the work order. Now you are challenging the work order.
But by the time they have.
Can we get into an order passed by a coordinate bench?
Lordship, the honorable court only said in accordance with law. The rules still has to be mandated. That is what my submission is. Because this was as on the date in which I understood, Lordship, but the fact remains is only in accordance
advise
with
you
law.
what to do. We are not out, we are out of the advisory
Fairly, I am conceding that the court has never said that so.
In adjudicatory jurisdiction, we can only dismiss your writ petition. because this is a pursuant to the order of the coordinate bench.
I do concede that, but the order is only to consider in accordance with law. The Lordship can dispose of with
AG
the.
accepts notice for respond number 1 to 4. The Prithvish MK accepts notice for respond number 5. Petitioner is before this court seeking for the following reliefs. The work order which has been challenged.
Lords, may I make one submission if your lordships permit me? My lords?
Yes.
In a recent decision, your lordships have held, my lords, once the petitioner became unsuccessful as on the date of work order, he has no locus, my lords. Now, admittedly, as on the date of work order, for whatever reason, my lords, for non-submission of solvency certificates, para 16, my lords. Para 16, internal page 10. Having been rendered ineligible to participate in the tender process on account of his own non-compliance with the tender conditions, the petitioner cannot now claim to be an aggrieved person in relation to the
Get into
subsidy.
that in this. It's not because it's in person or direction by a
Yes.
coordinate bench.
So therefore, he cannot even say Rule 22 violation, and your lordships have held that.
The work order which has been challenged by the petitioner, was issued in person, the order dated 23rd April 26, passed by a coordinate bench of this court in WP number 10813 of 2026. That being so, an action taken in pursuance of a direction issued by a coordinate bench cannot be challenged by way of the present writ petition. No grounds being made out, the petition stands dismissed, reserving liberty to the petitioner to avail such remedies as may be available under law.
13, Rudrabhushan.
Yes.
Petitioner. My lords, this is a writ of mandamus. My lord, I am not sought for interim prayer in this. A notice may be issued.
Asking for mandamus against the insurance company.
Yes, my lord.
How is a mandamus maintainable against the insurance
To
company?
consider the representations I have given, my lords.
They are not state. Bajaj Alliance is not a state.
Yes, my lord.
Matte mandamus enkodadu.
My lords, I clarify, a notice may be issued in this matter.
We can't issue notice just like that. What is your representation for?
The representation is with respect to acceptance of the claim, my lords. The insurance. They have rejected my claim in this aspect, my lords.
Mandamus cannot be issued for that, Mr. Counsel.
Well,
My lords, there was
Try
a
to file
fact.
appropriate proceedings. Notice to respond number 1 and 2 is dispensed with in view of the proposed order to be passed. Petitioner is before this court seeking for the following reliefs. The petitioner had availed of a fire insurance policy from respond number 1 and 2, in persons of which the petitioner had submitted a claim to the respondents. The said claim not being considered and payments being made, the petitioner is before this court seeking for a mandamus to be issued. The reliefs as sought for by the petitioner cannot be granted for reasons more than one. Firstly, that respondent number 1 and 2 are insurance companies which do not answer the test of state under Article 12 of the Constitution. Secondly, the respondents have not involved in any public function requiring this court to exercise its extraordinary jurisdiction under Article 226 of the Constitution. Thirdly, the dispute which has arisen between the parties is out of a private contract of insurance, the claim of the petitioner not having been paid by the respondents. Fourthly, the petitioner has an alternative efficacious remedy in terms of filing appropriate proceedings, such a claim before the appropriate authorities. For all the aforesaid reasons, no grounds being made out, petition stands dismissed.
serial number 14.
Again,
Yes,
with respect to the subvention scheme, my lords. the
Subvention scheme again.
Please.
Same.
Same.
Ghulam Mustafa.
Ghulam Mustafa.
Go to RERA, how many times we have to
We
tell
have,
you?
my lords, there are a batch of petitions which are pending, and the Supreme Court also has taken cognizance of the matter.
And now this company is in CIRP also.
That has been stayed, my lords.
Has been
That
stayed?
has been stayed.
Sorry.
You're unnecessarily, your clock is continuing to tick.
But my lords, at least the temporary relief, because from past 6 years I've been paying the EMI, my lords, past 6
Shri M.
years.
Unnikrishnan is directed to accept notice for respond number 1. Shri Pradeep Savka for respond number 2. Sukanya Baliga for respond number 3. Velankini Ravi for respond number 4. State Bank of India, Vignesh Shetty for Vignesh Shetty.
That's I've served
Where
it
are
on
Vignesh?
Nandish Patil. Nandish Patil.
Nandish Patil for respond number 5. Gulam Mustafa,
The JP Darshan,
JP Darshan for respond number 6. Piramal Capital,
JM Patil,
JM Patil. Darshan for 6 and 8. Sri Unnikrishnan, then there is yet another case of a subvention scheme where the purchaser, the probable homeowner is before this court, contending that the project not being complete, the bank from which the petitioner has availed of a loan, namely respond number 5, is continuing to demand the payment of the monies due on the loan account. Shri Krishna is directed to secure instruction, make a submission as to what recourse a homeowner would have in such circumstances. Released counsel for the petitioner furnished 2 sets of the petition along with annexures on the aforesaid counsel. Released on then 18th allow put it. 18th
The interim orders have been passed at Annexure Y, my lords, page 373.
170
373, my lords.
373. The benefit of the interim order granted in WP 18286 of 2025 is extended to the petitioner also. Connect with WP number 18286 of 2025.
Great.
serial number 15, Sachin DS.
So earlier, my lords, a mandamus was issued, my lords, to consider my representation seeking, my lords, refund of, my lords, bill, my lords, the auction amount which was done. Lords, that is rejected now, my lords, by virtue of annexure A2, page 41.
Rejected.
Lords, it's been rejected. Lords, the reason that is, my lords, saying that the trees that are cut and that is now sold is prior to the date of alienation and hence you are not eligible. That was the
AGA accepts notice for respond number 1 and 2. He seeks for and is granted 2 weeks time to obtain instruction, make his submission. Released on 1st September.
16, Sampath F.
Yes.
The petitioners, my lords, I'm seeking a mandamus, my lords, based on my representation in annexure A, B, C, and D, my lords.
What is your representation?
Before the DC, JDLR, DDLR, and ADLR, my lord, respondent 2, 3, 4, 5. Because there was a civil dispute, my lords, in OS which was filed by the petitioner, which came to be dismissed for partition separate position, against which RA is preferred, my lords, which is pending. Meanwhile, my lords, I get to know that another branch of my grandfather has filed a suit and obtained a collusive decree against amongst themselves, my lords, and the same also have challenged in an OS. That is also pending, my lords. Being such a case, my lords,
What is your representation for? You're saying is an illegal adverse. It's already been conducted. If you have to challenge the adverse, you have to challenge it under KLR, not how can your representation to set aside? Because
I've submitted representation to take appropriate action against the surveyor, my lords.
Ali Akrama Khatedar, Aditam Kanun. You are asking for the cancellation of the Kata, everything. The adverse has happened.
It's happened, my lords. Annexure E and F is there.
You agreed by the adverse, you have to challenge the adverse. Mandamus cannot be issued.
Lords may pass.
And AG accepts notice for respond number 1 to 5. Petitioner is before this court seeking for the following reliefs. By way of the representation dated 11/2/26 and 10/2/26, the petitioner has sought for cancellation of the adverse conducted on application by one Sri Krishna Gowda and others, and all subsequent actions taken in pursuant thereto. A representation for cancellation of adbust, even if it is alleged to be illegal, cannot be considered, cannot be directed to be considered by issues of mandamus. If the petitioner is aggrieved by the adverse conducted, the petitioner would have to challenge the said adverse, reserving liberty to the petitioner to challenge the same petition before the appropriate forum. Petition stands disposed.
17, Gaurav Subramaniam.
External proceedings, Millards. Petition has been extended from Mysore to Dharwad.
Where you issued notice?
Not even Millards. Initially, the notice was issued and order has been passed. And after that, the same was challenged before the district court, Millards, in criminal RP. And after the dismissal of criminal RP, the without issuing any notice or something, they have passed the another order stating to. And his presence has not been so noted, Millards, in the order. Page number 19, Millards. Since
when was notice issued to him?
Notice was issued in 2025, my lord, once, then it is quashed, I think.
Yes.
As per this
After that,
order, the notice.
After that notice was issued.
I'll just verify, my lord, kindly.
And AGA accepts notice for respond number 1 and 2. He seeks for and is granted a week's time to obtain instruction, make his submission as to whether before passing the impugned order date 17/7/26, a notice had been issued to the petitioner. If so, to place a copy of the said notice and the acknowledgement of service thereof before this court, released on 12th August.
Let's think. Let's 63 years old, my lords, he has been externed. Kindly, he stayed, my lords.
The operation of the impugned order dated so and so at Annexure A is stayed till the next date of hearing.
Much.
We'll come back in 5 minutes.
ಹೆಸರೆಲ್ಲಾದ್ರೂ ಡೌಟ್ ಬಂದ್ರೆ ಇವ್ರನ್ನೇ ಕೇಳಿ ಹೇಳ್ತಾರೆ. ಅಲ್ವಾ ಇವ್ರಿಗೆ ಚೆನ್ನಾಗಿ ರೂಢಿ ಆಗೋಗಿದೆ ಈಗ. List number 1, serial number 18, Pratap SS.
My lord, this is for extension of parole, my lord. At page number 9, this endorsement is ending tomorrow, my lord. My extension, my lord, this is.
First surrender ಮಾಡಿ.
Last date to surrender.
Let's get the report from them, how your behavior was, then we'll extend it.
Because on education purpose, there's some work.
No problem. And AGF for respond, relist on 5th.
19,
It's a premature matter, my lord.
And approval ಆಗಿದೆಯಾ?
No, my lord. Let it come
AGF
tomorrow.
for respond, relist tomorrow.
20, Pradeep Patil.
Similar.
And AGF for respond, relist tomorrow.
Tomorrow.
Obliged.
21, Arun Kumar.
Lords, this counsel on behalf of the petitioner, my lords, is before this honorable court seeking to quash the rowdy sheet opened against the petitioner by respondent number 4 dated 24/6/2026, my lords.
How many criminal proceedings are
My
pending?
lords, only one criminal proceeding, my lords, in annexure G1, my lords. 303 crime number was registered against me, which was a counter blast of.
Make sure you have marked it. We don't have the page number. You'll have to give us the page number.
Annexure G1 61 to 62, my lords, page 61. 61 to 62, which was a counter blast of crime number 302, which I had registered against the accused person, annexure G, my lords.
Annexure G1 is criminal petition 7680.
My lords, that has been stayed by the Honorable High Court of Karnataka.
Which is the criminal proceeding pending against you?
My lords, 57 to 60, my lords. Page number 57 to 60, annexure G, my lords.
74, 79, 1.
That has been stayed by the Honorable High Court of Karnataka, my lords. In page 61 to 62.
It's only been stayed, so the pendency is there.
Pendency is there, my lords. My lords, my one humble submission is that, my lords, these disputes have arisen due to the ancestral property case which were pending against the complainant and the accused, which I was being registered in crime number 303, which was a counterblast of 302. 6 cases has been registered against the accused in crime not through, my lords. Kindly refer page number 57 to 60. The respondent number 5 has issued a notice to me on 8/5, my lords. I have replied on 19/5 in annexure K, my lords. They have failed to consider my
If we keep on mentioning annexures, we can't look at it. We told you once already. Give
Yes,
us
my
the
lords.
page numbers.
My lords, kindly refer page number.
CD andre, we'll only know that you know ABC.
Sorry, my lords. My lords, page number 68 to 72, my lords.
68.
Yes, my lords. Annexure K, my lords, 68. My lords, this notice was issued by respondent number 5 against the petitioner on 8/5/2026, calling upon why the petitioner's name should not be registered in the rowdy list.
Yes.
My lords, subsequently I have replied to the same letter on 19/5/2026 within a period of 15 days. Annexure L 73 page, my lords. I have replied and also to respondent number 3, 4 and 5 through registered post, my lords. Annexure L1 is the acknowledgement. Whereas, my lords, in annexure M page 82, they have opened a rowdy sheet. They have willfully ignored my representation, stating that ನೀವು ಯಾವುದೇ ಸಮಜಾಯಿಷಿಯನ್ನು ನೀಡಿಲ್ಲ ಎಂದು ತಿಳಿಸಿ ನಿಮ್ಮ ವಿರುದ್ಧ ರೌಡಿ ಆಳೆಯನ್ನು ತೆರೆಯಲು ವರದಿಯನ್ನು ಸಲ್ಲಿಸಿರುತ್ತಾರೆ.
You not consider his reply.
Kindly pass over, Lord, I've sought.
Pass over, learn AG, pass over.
Serial number 22.
Post before a bench of which SGRJ is not a part.
3, Ashoka T.
My lords, in this case, I'm from petitioner, my lords. A tender notification is challenged, my lords. It's annexure A, my lords, in page 19, my lords. My lords, in page number 24, my lords, class 6, my lords. ಆರ್ಥಿಕ ಬಿಡ್ನಲ್ಲಿ ಸಲ್ಲಿಸಬೇಕಾದ ವಿವರಗಳು. ಬಿಡ್ಡುದಾರರು ಟೆಂಡರ್ 24, my lords. Class 6, my lords. First class.
Clause 6, yes.
ಬಿಡ್ಡುದಾರರು ಟೆಂಡರ್ ಸಲ್ಲಿಸುವ ಕಾಲಮಿತಿಯಲ್ಲಿ ಮಾರುಕಟ್ಟೆ ಸಮೀಪದ ದರಗಳಿಗೆ. Please, ma'am. 6.
Clause 6.
In 24, my lords, para 6. ಆರ್ಥಿಕ ಬಿಡ್ನಲ್ಲಿ ಸಲ್ಲಿಸಬೇಕಾದ ವಿವರಗಳು, my lords.
And item number 1.
My lords, ಅದು ಪೇಜ್ ಹೆಚ್ಚು ಕಡಿಮೆ ಆಗಿದೆ, my lords. Next page ಅಲ್ಲಿ, my lords.
25.
25.
ಆರ್ಥಿಕ, yes.
ಬಿಡ್ಡುದಾರರು ಟೆಂಡರ್ ಸಲ್ಲಿಸುವ ಕಾಲಮಿತಿಯಲ್ಲಿ ಮಾರುಕಟ್ಟೆ ಸಮೀಪದ ದರಗಳಿಗೆ ಅನುಗುಣವಾಗಿ ಮೊತ್ತವನ್ನು ನಮೂದಿಸಬೇಕು. ಟೆಂಡರ್ ದರಗಳು ಮಾರುಕಟ್ಟೆ ದರಗಳಿಗಿಂತ ಶೇಕಡ 5% ಹೆಚ್ಚು ಅಥವಾ ಕಡಿಮೆ ಇರಬಾರದು. ಸದರಿ ಟೆಂಡರ್ ದಾರರು ಯಶಸ್ವಿ ಟೆಂಡರ್ ದಾರರಾಗುತ್ತಾರೆ. ಮೈಲಾಟ್ಸ್ ಮಾರ್ಕೆಟ್ ರೇಟ್ ಏನಂತಾನೆ ಇದ್ರಲ್ಲಿ ತೋರಿಸಿಲ್ಲ ಮೈಲಾಟ್ಸ್. ವಿತೌಟ್ ಶೋಯಿಂಗ್ ದಿ ರೇಟ್ ಆಫ್ ಮಾರ್ಕೆಟ್ ಮೈಲಾಟ್ಸ್, ದಿಸ್ ಕಂಡೀಷನ್ is prescribed ಮೈಲಾಟ್ಸ್.
Market rate is not shown?
Not shown mylords. In the bottom, in the same page mylords, items are given but market rates are not given mylords.
Kindly pass over, my lord. All tender matters they are
Pass over.
obtaining in.
Pass over.
Please.
Please.
24, Shri Ashwini.
My lords, petitioner is a student in the respondent number 1 institution. And the respondent number 2 is the ICC committee, also called as ICASH in the respondent number 1 institution, Your Honor. Petitioner is a student and she's challenging annexure A at page 37, which is an order passed by the registrar of the college, suspending her from the college, Your Honor. And annexure B is the findings report against her. My lords, if I may just explain the facts in nutshell. Petitioner is a BTech student, 4th year, final year student, Your Honor, and she's a very meritorious student. In fact, she secured an all India rank of 327 through JEE Advanced, and that's how she got admission in R1 institution.
Everybody would be same in whoever has gone into respondent.
Please, agreed, Your Honor. Your Honor, what has also happened is that in the year 2024, she has been sexually molested in the college. She's filed an ICASH proceedings, which is the ICC
He
proceedings.
filed the ICASH.
Please, Your Honor, please. And the student was then rusticated from the college. Subsequently, another ICASH proceedings she had filed against another student who was asked to tender an apology. Now, Your Honor, why am I mentioning these earlier ICASH proceedings? It's because of these two incidents, she has been considered as a problematic student in the college. Now, when a subsequent ICASH, now what has happened, Your Honor, in the month of January, one student has unofficially created an Instagram account called as the UG confessions page. Now, Your Honor must be aware, for confessions to be posted on an Instagram account, first, anonymously students through a Google form will upload their confession. Admin reviews it, and admin of the account, only if approves it, will it get published on the Instagram account. Now, my lord, several posts have been posted against the petitioner and a few other girls of the college students, which were very derogatory and had some sexual undertone, Your Honor. Now, petitioner goes ahead, files a complaint with the ICASH. They don't take any action. Several students also file it, Your Honor. Now, since ICASH has not taken any action, they all approach the police. Subsequently, a cyber cell they approach. Cyber cell has traced this account to one of the first year students of the college. Now, my lords, the ICASH then proceeds against this student. Now, subsequently, Your Honor, in the first meeting with the committee, he admits to having created this account and being the admin. He has admitted everything. Now, my lord, subsequently, he has altered his entire version and he's blamed the petitioner for all the posts. He is saying that petitioner is the one who has posted everything. Now, just based on his averment, Your Honor, at page number 69, annexure C, Your Honor, an email is sent by the ICASH committees. I may just read it, Your Honor, saying that, dear so-and-so, we are writing to you regarding the ongoing proceedings before the ICASH. Based on the material present on record and the evolving nature of the inquiry, the ICASH considers it appropriate to inform you that your role in the proceeding now requires to be examined more closely. Accordingly, you're being treated as a co-respondent for the limited purpose of enabling a fair and comprehensive inquiry. My lords, this in fact violates even the POSH Act. As per POSH Act, there has to be a written complaint by the complainant before initiating any inquiry against any student or anybody. Here, there is nothing on record, only based on one respondent who wants to blame the other student for whatever reason. He is the one who has complained against the respondent. Now, my lords, I'll just come to the findings report. Now, the findings report conclusively state that the student who created the account is the admin. Now, the finding reports is at page number, apologies, Your Honor, at page number 38. Now, my lords may see at page number 50 of this report, at the last, just above respondent number 1, version 2, just above that, confirm that both Instagram accounts were linked to the email IDs of so-and-so and so-and-so, the mobile number ending 5347, and that he used IASC LAN and mobile data without employing a VPN. This is connected to the student who created it. It's completely admitted. Now, my lords, They have arrayed petitioner as respondent number 2. No conclusive evidence against her. They have just said that there is a likelihood that she has in fact.
Finding against you by the inquiry committee, there's an appeal that you have filed against.
Please,
before
Your
the
Honor,
director, that is also, we can't grant you interim order right now.
No, my lords, I have filed it. There is no, they have not even come replied. In fact, the college has begun from yesterday, Your Honor.
Let us get them.
My lords, if I'm.
Pradeep Saukar. If Pradeep Saukar is directed to accept notice for respond number 1 and 2. Counsel for the petitioner served 2 sets of the petition along with annexures on the said counsel. Relist on 7th August.
No, my lords, if I may just make one more mention, Your Honor. In fact, they are continuing to target her. I'm producing this memo where they have even cancelled her student registration, Your Honor, recently.
Let us hear them, because there are quite serious allegations which have been made against you also in this.
My lords, the allegations are not based there are no conclusive proof, Your Honor. In fact, Your Honor, to suspend her.
The preliminary finding, madam.
My lords,
So
it's
the
an
entire proceedings will have to happen. If the preliminary findings are pretty much against you.
Please, Your Honor, but this is the final report. If I may just make one more submission, Your Honor, the right to even suspend a student from the college is not a power granted to them. As per the ICASH policies, if I may just refer to the policy, Your Honor, at page number
87.
101, Your Honor. At page 101, lays down the penalties that can be imposed on a student.
Yes.
There, Your Honor, it says written apology, warning, reprimand or censure, withholding results, debarring from exams, debarring from entering the
Expulsion
campus.
is also there, madam.
Expulsion is there, but she has been suspended for 1 year from the college. Your Honor, when she's not even the admin, she's not doctored any post, then this is not just excessive jurisdiction, Your Honor, but they've also imposed a very high
Allegations
penalty.
are very serious. Let us hear them. Serve a copy. Relist on 7th.
25.
I-1 of 26 is allowed. Yes, Anand?
Yeah, for the petitioners in this matter. So the matter pertains to section 10, note 2A, banking regulation.
ಯಾರಾದ್ರೂ ಫೈಲ್ ಮಾಡಿದ್ರೆ ಯಾರು ಇಲ್ಲ. Ms. Nayantara BG is directed to accept notice for respond number.
Take notice for respond number 1 to 2.
You take note.
Yes.
So and so. There are so many counsels in this matter.
The matters are allotted to different people, my lords.
For the same issue, now you are the 5th counsel coming. So who will be filing objection? Who will address argument? We won't allow all 5 of you to address arguments. So and so accepts notice for respond number 1 to 3. Reserve Bank of India.
Swati L. Patil.
Swati so and so.
Swati L. Patil.
Learned AGA for respond number 5 and 6.
7, my lord, Shailesh SK is a standing counsel. Shailesh SK.
Shailesh SK for respond number 7. Adu put your order. Same order, connect with so and so. Relist on
25-8.
25-8.
Please.
Issue notice to Attorney General, same order.
26. B. Pradeep. Name.
Limitation. Limitation disposed.
27.
This matter, the petitioner, Lord, is a managing director of one company called Aradha Steel, my lord. They availed certain credits facility from the Indian bank, my lord. After credits facility availing, my lord, that loan became a turn into NPA. And after NPA, my lord, due to the business loss, my lord, and consequently, without unilaterally, without following the due process or inquiry and all, my lord, they unilaterally declared the loan account of the borrower company is being fraud. Subsequently, my lord, after declaring a fraud, my lord, they filed a complaint to the CBI saying that there is a cheating. Based on that, my lord, the CBI initiated FIR, my lord, and filed a final report, which had cause for the enforcement directorate to register the ECIR, my lord. Subsequently, my lord, subsequently, my lord, that the entire bank and all the records of the bank itself is indicated there was no element of fraud, my lord. And thereafter, where I went to the High Court of Karnataka, my lord, coordinate bench, my lord, page number 212, my lord. were questioning the very fraud itself, the initiation of the proceedings and declaration of fraud itself, that because I have not element of fraud in any manner of the records of the bank itself. Where lordship has kindly go to the page number 213, my lord, operative portion of the order. The both the side having argued the matter very easily, sometime the court suggested the fairly agreed that the respondent bank should retrace the steps concerning the subject loan account being branded as fraudulent as much as a deeper inquiry so accomplished. There is no blameworth conduct attributable to the petitioner. The respondent bank should tell the RBI allegation of fraud after inquiry is been found not to be. Therefore, it earlier communication made by the RBI wrong assumption of a fraud should be accordingly recalled. Thereafter, my lord, the pursuant to this, my lord, that a bank has withdrawn the reporting of a fraud.
They withdrawn.
Withdrawn, my lord.
Where is the
Page
withdrawal?
number 215, my lord. They withdraw the reporting of a fraud. And subsequently, my lord, I have cleared the entire liability, my lord. It's only a civil nature, my lord. I did not fraud do any, and they withdraw the. Subsequently, my lord, our entire liability has been cleared, and they have sold my company also, my lord, to the some other Bansal Aradhya, my lord, and in NCLT. And subsequently, my lord, the criminal proceedings have been ended in quashing of the proceedings, my lord. Only on a technicality, they went to the Supreme Court saying that the High Court should not exercise the 482 by considering all other records. And thereafter, it has been remanded for predicate offense is pending consideration, my lord. And thereafter. And subsequent to that, my lord, in view of the quashing of the proceedings, page number 23, my lord, the ECR is been stand quashed by this honorable court, my lord. Page number 23, my lord. The very basis for initiation of ED proceeding is based on the predicate offense, my lord. Since the predicate offense has been stand quashed by the honorable High Court, my lord, and consequently, the page number 23, this honorable court.
Page Supreme Court order is 239.
Page number 239, my lord.
This is filed by the CBI.
CBI, my lord. Against order, again, sorry, my lord. Page number 212, my lord. 212 is a High Court order, my lord, with regarding recording a fault.
That
And
is
subsequently, I have
35.
yes, my lord.
Yes.
And page number 218, my lord, kindly peruse 218, where I have questioned the correctness of legality of the proceedings initiated by the CBI itself, my lord.
Yes, that was allowed.
That was allowed.
Then that was taken on appeal in.
Yes, my lord, SLP. SLP, where the technicality has been raised at the Supreme Court, my lord, because myself has made a submission that we will go for the discharge.
64896 was set aside.
Set aside. Only on the reason.
Restored with the quashing.
No, that is the reason, Mullah. That is the only observation. What is done? They are not touched the merits of the matter, Mullah. Only that myself.
Counsel, it has been set aside.
Please,
the matter is remanded.
Please,
the CC is restored.
Please,
you are allowed to file a discharge application.
Yes,
correct, Mullah.
On contention that it's been quashed is wrong.
No. On my submission, Lordship, my submission,
Predicate
the
offense survives,
Supreme Court has said that we will file a discharge application, and after hearing the matter, my lord, the Supreme Court has set aside the order of the High Court of criminal proceedings. Subsequently, I filed a discharge application before the trial court, which is a pending consideration. Meantime, the company has come to Honorable High Court saying that defer the proceedings because the very proceeding itself should not be maintainable for the reason that the entire liability has been clear. There was no element of fraud and all. This is the proceedings have been deferred, Mela. This is the order copy. Please. Subsequently, my lord, this in view of that, my lord, page number 23, that ED proceedings have been stand quashed earlier. In view of that, the liberty which they have
been quashed, show us the quashing order. You told us that, but what you have shown us is not quashed.
No, it's not quashed. No, my submission, my lord, that the discharge application is pending consideration of mine, which is still pending consideration. It is on my side, the argument is over, my lord, completed. CBI took a date for argument, my lord. Meantime, my lord, this ED proceeding which has been stand quashed by this honorable court. In view of
that, has been set aside by the Supreme Court.
No, it has not been set aside. That is the reason, my lord. Page number 23, my lord.
Page 23.
Page number 23. This order has not been questioned. This order has not been questioned. This order has been quashed. This has not been appealed.
So which is the order?
Page number 23. Okay. 211187. This has been stand quash. However, the courts have given
There's a liberty given at the end of
liberty
the
has been
The
given.
council,
that it will revive on the revival of the predicate offense. The predicate
Ah,
offense
that is
today
only.
stands. The ED proceedings will also
Now
survive.
they wanted to revive this the ED proceedings, my lord, because of the reason, my lord. Throughout the records of the CBI itself is saying that they themselves are saying that there is no element of fraud. There is entire liability has been clear, and there was no even crime at all. That consequent to the crime
all
generated.
your arguments are in the teeth of the order of the Supreme Court. And you are trying to mislead this court.
No.
Please,
I'm
This is the only conclusion that we can draw.
no. Fairly, I'm sorry, my
You are
lord.
referring to orders which have been set aside by the Supreme Court.
Please, man.
You cannot be referring to the orders which have been set aside by the Supreme Court.
No, I am not coming in any way, my lord. My submission means that the CBI proceedings which have been initiated by the CBI court, CBI department in the court, my lord, that the records itself has indicated, because I have extracted all the records, my lord.
That is in your discharge
The
application.
discharge application.
You
That
succeed
no,
there,
no,
then
no.
you come back.
No, my submission, my lord. It's the only my simple submission.
You
Those
want us to pass an order
no.
adverting to your submissions, we'll
No,
pass the
I'm
order.
not saying. My lord, this honorable court has passed an order earlier, my lord. During the pendency, this order was not in the merits, my lord. This order was not meritly decided. During the pendency of the proceedings, my lord, the interim order was there, my revival. In case, my lord, if they wanted to revive these proceedings of ED, I'm only seeking interim protection that they should not revive these proceedings till conclusion of the predicate offense. That's what I'm asking.
21187, where the interim order was passed, was disposed of on 14th March 2024.
Please. Ma'am.
Supreme Court judgment was in 2025.
Please,
April 20.
please.
And you want us to revive an order of the High Court after the Supreme Court has set it aside?
No.
Please,
No. Sorry, I must have been correctly
trying asking
No.
us to do.
Sorry, Mala. I'm correctly. I'm making submission, Mala. ED proceedings are entirely different, and the CBI proceedings are entirely different. As far as the CBI case, which is a predicate offense, my lord, is concerned, which has been quashed by this honorable court. Subsequent to that, they went to the Supreme Court. The Supreme Court has set aside that order, go and file a discharge application. That is a one matter. Based on the CBI case,
Predicate offense continues.
Correct.
Predicate offense continue. My
Annapurna Bhattala accepts
Please,
notice
my
to
lord.
respond.
my
You want us to pass an order?
No. My humble submission, my lord. One interim protection might be.
That's why you want us to pass an order, we'll pass an order.
My humble submission, because
Petitioner is seeking for ad interim protection, directing the respondent ED not to take any coercive action as against the petitioner pertaining to the investigation in ECR so and so. The petitioner had earlier approached this court challenging the predicate offense by filing a proceedings in criminal petition number 6496 of 23, which came to be allowed by a coordinate bench of this court on 19 February 24. Subsequently, on the basis of the said order, the petitioner had challenged the ECIR by filing WP number 21187 of 2023, which came to be allowed by this court on 14th March 2024, on the ground that the predicate offense has already been quashed in criminal petition number 6496 of 23. Liberty was however reserved to the respondent as prayed for. The CBI challenged the quashing, the challenge order passed in criminal petition number 6496 of 2023 by filing SLP criminal number 10316 of 2024, and the Honorable Supreme Court, while its order dated 22nd April 2025, set aside the order dated 19/2/24 passed in criminal petition number 6496 of 23 and restored restored the predicate offense in CC number 6082 of 2023, reserving liberty to petitioner to file a discharge application. The said discharge application has been filed by the petitioner, which is pending consideration in CC number 6082 of 23. In that view, in view of the order dated 22nd April 2025 of the Honorable Supreme Court in SLP criminal number 10316 of 2024, the predicate offense has been restored in view of the, in furtherance thereof, in view of the liberty which has been restored, the liberty which had been granted by the order dated 14th March 24 in WP number 21187 of 2023, the ECIR also stands restored. Hence, the contention of the learned counsel for the petitioner that the predicate offense has been quashed, disentitling the ED to take any coercive steps is not borne out by the records. We are using a very simple word. The interim order, therefore, sought for cannot be granted and is rejected.
I'm pleased.
3 weeks' time is granted to the respondent to file a statement of objection. Objection
Copy may be served, my lord.
by counsel for the petitioner furnished 2 sets of the petition along with annexures on the counsel for respondent by end of day 11th August. 3 weeks' time is granted to the respondent to file a statement of objection, which shall be filed on or before 8th September, relist on 17th September.
My lord, only interim protection because earlier.
You have rejected it by a reasoned order, Mr. Counsel.
My humble submission, my lord. Initially, during because it is not on the merits of the matter, during it is not been revived, my lord. Now we are in the apprehension that they are going to revive this proceedings, my lord.
It stands automatically revived after the Supreme Court order.
No, that is the reason.
Please don't make these kind of submission against the Supreme Court order.
No, I am not.
It may be contemptuous.
Absolutely, my lord.
Serial number 28.
Parole and AGA for respondent relist on 5th.
For the petitioner.
Parole.
Yes,
Tomorrow.
Pokso, my lord.
ನಾಳೆ ಎಲ್ಲ
For children education. Notice.
29. Parole.
My lordship, this is extension of parole, my lordship. He has already served a
Surrender.
sentence of 14 years.
You
No, my
surrendered.
lordship, today he will surrender, my lordship.
Surrender. Surrender ಅಂದ್ರೆ ನಾಳೆ ತಗೊಳಕ್ಕಾಗಲ್ಲ.
If he surrendered,
And AGA for respondent relist on 12th August.
30.
Much obliged, my lordship.
Kiran SS.
Appear for the petitioner, my lord. Same matter. Parole.
Parole respondent relist on 5th.
31. Tuyo Gerade.
Yes.
Order under 6A2, my lords, of Essential Commodities Act. Interim order passed by the Deputy Commissioner, my lords. Under 6A clause 2, my lords, of Essential Commodities Act, my lords, page number 16. Directing, my lords, for disposal of the seized goods, my lords. The seized articles are, my lords, the organic manure. Yes, sir, directed, my lords, to page 17.
Yes.
Lords, he has directed to, my lords, to distribute it in, my lords, Sarkar the Krishi
Under what
Ilake.
provision was it seized?
Lords, they conduct a mazar. They write, my lords.
Under what provision was the seizure done? Mazar is a administrative act.
Lords, under the 1985 control order, my lords, they seize it. Thereafter, my lords,
85
to,
Control order.
please, lords,
Clause 28(3).
please, lords, they seize it.
28(3).
Where any fertilizer seized by an inspector under this clause, he shall forthwith report the fact of such seizure to the collector, whereupon the provision of section 6A, 6B, 6C, 6D, and 6E of the Act shall apply to the
What is
custody.
the
disposal.
violation committed?
Lords, the allegation is that, my lords, one, my lords, they say there is no, my lords, license to the petitioner, my lords, to manufacture organic manure as per control 19, my lords, of the control order 1985. And, my lords, the seized manure, my lords, are substandard is the allegation. No proceedings under 6A, my lords, has been initiated as on.
Where is your license to manufacture
My
fertilizer?
lords, what happens is, kindly see, my lords, annexure E, page 22.
Where is your license?
My lords, in 2007, my lords, they give an endorsement saying, my lords, they cannot give license. There is no question of granting license for the manufacturing of organic manure. Kindly see page 22, my lords, annexure E.
Hmm. Sasya Yes.
Thereafter, my lords, Panchayat grants me license.
Hmm?
Annexure F, my lords, Panchayat grants me license. And my lords, at annexure F1, my lords, it is
Trade
renewed.
license.
Please, my lords.
Yes.
This being the case, my lords, now they, my lords, conduct a raid and they seize, my lords, certain organic manure from my shop. Now, my lords, no confiscation, my lords, proceedings has been initiated under 6A. No show cause notice issued, my lords, no proceedings has been initiated. In the meantime, my lords, under 6A clause 2 of the Essential Commodities Act, he has directed, my lords, for disposal of the goods.
Yes, when you say that you can't issue a license, can you say it has been manufactured without a license?
Yes.
And AGA accepts notice for respond number 1 and 2. The petitioner had earlier approached the respond number 1 for grant of a license to manufacture organic manure, as regards which an endorsement had been issued on 23/7/2007 at Annexure E, that for manufacture of organic manure, there is no license which can be granted. And in furtherance thereof, that the petitioner continued to manufacture organic manure, which has now been seized. Considering that it has been seized on the ground that there is no license which the petitioner has obtained for purpose of manufacture of such organic manure. Considering that the respondent themselves had indicated that no license can be issued for manufacture of organic manure, there cannot be a subsequent allegation of violation of manufacture of organic manure on the ground that license has not been obtained. Hence, the operation of order dated 2/7/26, pairing number so and so issued by respondent number 2, as also the further direction to respondent number 1 are at annexure B are stayed till the next date of hearing.
Great.
Now, what will you do with this 10.6 tons?
I'll have to get instructions and make my submissions.
When?
Couple of days, my lord.
Learned AGA seeks for and is granted 3 days time to secure instruction and make a submission as to whether the organic manure seized could be returned to the petitioner. If so, by when and under what conditions? Relist on 7th.
Great.
I1 of 26 is allowed.
32, Latif B.
Yes.
An order of externment has been passed under section 55 and 55A and B of
Notice was
Police
issued
Act,
to you?
Please, my lord.
Notice was issued?
No, my lord. This is the first time, my lord. Notice was issued, my lords, as per annexure B, my lords. It is a vague notice which was issued under section 58, my lords. There are no details about the crimes which has been registered against the petitioner. Page number 25, my lords. If your lordship peruse the annexure A, my lords, one case is pending at page number 18, my lords. That is the theft case, my lords. 309
You
clause
submit
6.
any written reply?
Please, my lords.
Annexure C you have submitted.
Annexure C is the objection, my lords, which
You
was
submitted the
detailedly filed before the magistrate, my lords, in which it has been clearly stated that, my lords, one cases that has been acquittal.
Now you have to file an appeal. You can't come before this court under 558.
My lords,
59 appeal is there.
My lords, as per the judgment, my lords, the 58 notice which was issued, there are no details.
You have not taken up any of those
Lords,
contentions in your reply. Now you are taking up that contention. We cannot accept that contention here. Only on the merits of the matter which you have replied, you can go on appeal. And AGA for respondent number 1 to 4, petitioner is before this court seeking for the following reliefs. What has been challenged is the extendment order under section 55 of the Karnataka Police Act 1963. Before passing of the said order, notice had been issued to the petitioner. The petitioner had supplied its reply on 29/5/26, which has been considered in the impugned order. Though the contention of the learned counsel for the petitioner is that the details had not been furnished along with the notice, no such contention has been taken in the objections which have been submitted as regard non-furnishing of any particular document. The petitioner, as a statutory remedy under section 59 of the Karnataka Police Act, reserving liberty to the petitioner to avail such statutory remedy, statutory appellate remedy, petition stands disposed.
33, Shivarudra.
Shivrudra.
Petition is agreed by annexure B.
Annexure?
Petitioner is the owner, annexure P, my lord.
Page?
That's it, page 47. Being challenged before him, lords. The petitioner is owner of a site, my lord, in SVS layout in Yalanka. The right side of the highway, my lord, towards, he is constructing a house. Not in 2025 also and 2023 also, the site was utilized by the defense forces for exit. There was, your lordship kindly recollect, my lord, once there was a fire hazard in Yalanka Air Base where
on the right side.
On the right side.
Yes.
Then when this compound wall of the petitioner was demolished and they paved a way towards the other side of the road for the vehicles to move. But at that time they didn't construct the wall. After with the great efforts the petitioner put in calling all the authorities, they issued annexure K, my lord. If your lordship kindly have a glance at annexure K, my lord.
Yes.
Last paragraph. ಆದ್ದರಿಂದ ಸದರಿ ಏರ್ ಫೋರ್ಸ್ ಸ್ಟೇಷನ್ ಗೇಟ್ 5ರ ವಾಹನಗಳನ್ನು ಹೊರಗೆ ಹೋಗಲು ಕಾಂಪೌಂಡ್ ಹಾಗೂ ಶೆಡ್ ಅನ್ನು ದಿನಾಂಕ 10/2/25 ಒಳಗೆ ತೆರವುಗೊಳಿಸಿ ಏರೋ ಇಂಡಿಯಾ 25ರ ಪ್ರದರ್ಶನ ದಿನಾಂಕ 14/2/25ರಂದು ಮುಕ್ತಾಯಗೊಳ್ಳುತ್ತದೆ. ದಿನಾಂಕ 17/2/25ರ ನಂತರ ಸದರಿ ವಿನಿವೇಶದಲ್ಲಿ ಕಾಂಪೌಂಡ್ ನಿರ್ಮಿಸಿಕೊಳ್ಳಲು ಮತ್ತು ಮಾನ್ಯ ಜಿಲ್ಲಾಧಿಕಾರಿಗಳು ಬೆಂಗಳೂರು ನಗರ ಜಿಲ್ಲೆ ಇವರ ಮೌಖಿಕ ಆದೇಶದಂತೆ ಈ ಕಚೇರಿಯಿಂದ ಯಥಾಸ್ಥಿತಿ ಕಾಂಪೌಂಡ್ ಹಾಗೂ ಶೆಡ್ ನಿರ್ಮಿಸಿಕೊಳ್ಳಲಾಗುವುದು ಎಂಬುದಾಗಿ ಈ ಮೂಲಕ ನಿಮಗೆ ತಿಳಿಸಿಕೊಳ್ಳ. So it was constructed by them again and it was handed over to me. Now, my lord, the petitioner has obtained a sanction plan from the authorities and started construction because he doesn't have a house. Now they are coming and telling you don't construct, you should not construct. But there is a lane which goes behind the Air Force compound to the other side. There they don't want to get out, but they wanted to come out from the site of mine. And they issued annexure P, pressurizing the local authorities to ensure that I stop my construction. If your lordship kindly have a glance at annexure P, my lord, at page 49, my lord, the ಒಂದು ಇದನ್ನು ಬರೆದಿದ್ದಾರೆ ಶರಾತರ 1990ರಲ್ಲಿ to immediate cease with further construction of the work at your site for violations of provisions of ODA Act.
Central government. So also is direct to accept notice for respondent. You'll also accept for the Air Force Station. The Air Force Station is also central government.
They'll have to take notice.
Separate.
Center.
You will have to take notice. So initially, the director accept notice for respondent number 1 and 2. 1, 2, 3. And AGA for 4, 5, 6. TMC Unsmanali.
Govind Rajti.
Shri Govind Rajti is directed to accept notice for respondent number 6. The impugned notice bearing number so and so dated 8/7/26 at annexure P is stayed till the next date of hearing, considering that the land of the petitioner had been made use of by the respondents for emergency use during a fire accident during Aero India. And now the recognizing that the petitioner was the owner of the land, and now the respondents are seeking to come in the way of the petitioner using the said land. Shri Nischal Dev and Council for respondent number 1 to 3 is direct to secure instruction and make a submission as to on what basis respondent number 1 to 3 are seeking to restrain the petitioner from usage of his own land. Released on 19th August.
Published.
34, Nischal Dev.
Prayer is for mandamus, my lord, to consider my online complaint and publish the SIR electoral roll pertaining to Dodbam Sandra part. The facts, my lord, is petitioner is a permanent resident of Dodbam Sandra locality, which was earlier under the Yelahanka constituency.
You can direct them to consider your complaint, not direct them to publish this.
No, my lord, otherwise, my lord, I will be left out, my lord. My name would not be included.
Your complaint can be directed to be considered. We can't direct them to publish it, your name to be included.
No, can it be done before 8th of, otherwise, my lord, post 8th, my lord, then I would not have any, I will be left remediless, my lord. Then it would be classified as absentees
Yeah,
shifted or?
Dodwad. Shri Dodwad is directed to accept notice for respond number 1, Vaishali Agde for respond number 2, GBA. Manne yaru? Pavan Kumar for respond number 3 and 4. His name is not included. He's given you a complaint. We'll direct you to consider and pass orders by
Lord,
8.
even his apprehension is not correct. Even after 8, my lord, we will publish the draft roll. He has opportunity to file his claim till 1 month is time. After 8, my lord, there will be 1 month time.
8th is only last date for submission.
No, correct. Adadmele they will issue the draft roll. If it is not,
No, well, it is not.
It is the last day for submission. Next
Please, my lord.
September is when they will publish the
September
draft roll.
9. September is the last date, my lord.
And it will
October
go
we
on
will
till
publish.
December.
correct. There are certain defects and material irregularities in that list.
Petitioner is before this court contending that the online complaint submitted by the petitioner on 19/7/26 has not been considered by the respondents. Whenever any complaint is submitted, it is required for the concerned authority to consider the said complaint and pass necessary order, either accepting or rejecting the complaint, in either case accompanied by reasons. The complaint have been recently submitted on 19/7/26, but however, taking into consideration that the SIR process is ongoing, it would be required for the respondent to pass necessary orders before finalizing of the electoral roll. In that view of the matter, this court passes the following order. Writ petition is partly allowed. A mandamus is issued directing the respond number 1 to consider the online complaint of the petitioner dated 19/7/26 and pass necessary orders before the draft list of voters is published.
Before draft is probably difficult, my lord, because what happens, election commission will not be directly involved in publication of the draft. Lord, it is the electoral registration officer of the constant assembly constituency is the competent authority whether to include or exclude from the electoral roll. Lord, if the petitioner has made the complaint in the electoral roll, electoral registration officer,
who have you made the complaint to?
It's an online complaint, my lord.
To whom?
ECI.
ECI net.
Yes.
So this will go to, you will have to direct it to the concerned authority.
My lord, not before the draft roll.
In the 30 days is there. We should pass orders before that day.
So
Lord,
what has
17th
happened?
we will publish the draft roll.
They are published defective.
My lord, even otherwise his apprehension is not correct unless he files enumeration form, my lord.
Shall we make your, shall we note your undertaking, record your undertaking that his name will be in the final list?
No, my lord, that can't be, my lord.
The apprehension is not correct, is not
But in the sense, my lord, if he has filed enumeration form, my lord, he will be published in draft roll.
Pass orders before you publish your preliminary.
Before that, kindly see Annexure D, my lord. The BLO had given the part details. If I punch in the part details, it is completely mismatching to the previous entry. One lady named Ratnama is being shown.
My lord, that's not correct, my lord. If he has filed the enumeration form, my lord, his name will be in the draft roll.
It will be deleted because if I don't enter 2002,
Where is it showing Ratnama's name?
Page 25, my lord.
this matter tomorrow. Okay. Take instruction.
This one is different. You are correct, selected something different.
Illa, this is
Your
the
serial
present.
number is 155-302 St. Philomena English School, 152 Batranpura. You selected 161 Government Higher Primary School.
This
And
is the
part number
detail.
841.
The information furnished by
Information furnished by the BLO. The present, earlier it was under the Yelahanka
They are
constituency.
defective.
Later it became the Batranpura post 2009.
It has been Batranpura for a long time.
Yes.
I am also
19
part of the same ward. You are selecting
that
a
is the
wrong
information
details.
provided by the BLO.
Let him take instruction.
Mail a pre-filled information ಏನಿದೆ ಅದನ್ನ ಇಲ್ಲಿ select ಮಾಡಬೇಕು. If you select that, it will be proper. You selected
That is
some other
defective. That
information.
is my respectful submission. That is defective.
Whatever they have uploaded is that.
My lord, even otherwise, if he has filed the non-enumeration form, my lord, his name will be in the draft roll.
See, your part number, serial number is 155. And part number is 302 St. Philomena's English School.
No, that is the present one.
152 Batranpura.
Correct. That is the present one.
You have selected Yelahanka. It was never part of Yelahanka. Batranpura was never part of Yelahanka.
No, prior to 2002. After delimitation, my lord, it came under the.
Batranpura is different. Yelahanka is different. CMC Batranpura. ಆಮೇಲೆ ಇದು ಬಂದಿದ್ದು.
My lord, if
Then
my
it was
lord
rural.
Dodbamsandra was in.
Then it was Bangalore rural.
No.
If my lord see the page number 21, my lord.
Staying in Yelahanka, I voted for rural at that time.
Dodbamsandra was within
Not part of urban.
Lord, if my lord see the kindly see the
Pass
page.
orders by 70.
Please, we will pass. Only thing,
For
my
the
lord,
preliminary,
is as per
before the preliminary draft, before the draft list. Yes, Yes. Before the draft list is published, they will pass orders on your complaint.
35, Vishwanath HM.
Yes, Mr. Kanor.
Senior citizen. Lord, I'm aware of your lordship's orders and in one of the matters your lordships have given certain directions, my lord, to the, and, but here, my lord, it will be slightly different, my lord, because what has happened is, my lord, the mother, my lord, the petitioner, there's one more son. In fact, she still has another 9 properties she still has. She's an income tax assessee as well.
That doesn't mean that she has to give it to you.
No, not that. And now what has also happened is the other brother, my lord, he has filed a now suit for partition. What the mother says in the petition that the petitioner said that this property, if it's gifted to him, he would, my lord, ensure that it gets partitioned amongst them. Now she's staying in the same property, the residential Sampangiram Nagar.
How much are you willing to pay?
My lord, the rent what, my lord, we are taking for the 1,600 square feet below which is being rented out, that is about 42,000, my lord, which we are getting, we'll pay that to her.
How much are you willing to pay out of your pocket? Apart from that. That is hers anyway.
Lord, another.
You'll be doing no favor by giving her what.
I understand. Another 20,000 we'll pay.
75,000 you continue paying her.
Please.
And AGA accepts notice for respond number 1 and 2. Issue emergent notice to respond number 3. Returnable by 3rd September. In view of the submission made by Shri Gurudas Kannur, Learned Senior Counsel on instruction of Shri Vishwanath HM, is instructing counsel that an amount of rupees 75,000 would be paid by the petitioner to respond number 3 month on month, every month until the disposal of the above petition by the 10th of every month to the bank account of respond number 3. The respond number 3 is restrained from in any manner alienating, dealing with, changing the character of the subject property till the next date of hearing. Respondent number 2 is also restrained from implementing the order in MSC 46 of 26 dated 10/7/26 at Annexure 8 till the next date of hearing. Process fee and copies to be furnished by end of day 5th August, failing which interim order will stand automatically vacated. The acknowledgement of deposit for the month of August on 10th August to be filed with the registry by the 12th of August 2026, and such acknowledgement to be filed month on month every month by the 12th of August.
We'll do that. Oblige.
1 of 26 is allowed.
36.
My lord, connected writ petition already stayed by this honorable court. Kindly connected this along with 21-272 of 20. And kindly ordered for notice in the present case.
Notice yaar respondent
The same respondents, my lord.
They have not appeared in that matter.
No.
issue notice to the respondents returnable by
17/8 ಅಂತ ಡೇಟ್ ಇದೆ.
17/8 ಅಂತಿದೆ.
ನಾನು
By 17/8,
Yes.
connect with WP number 21272 of 2026.
37, Rishikesh M.
For the respondent number 4.
Respond number?
4. Last time we made a submission that we are issuing a retirement letter. But the client has contacted me to.
Shri R.S. Umesh has entered appearance for respond number 4, delete name of Shri Rajesh B.R.,
As a K-waiter.
whose name had been shown as K-waiter for respond number 4. Yes?
So there's no file.
Counsel for the petitioner is not well.
Still for the petitioner is not well. What about GA served? Now AGA accepts notice for respond number 1 and 2. Counsel for the petitioner seeks for understand 2 weeks time, relist on 1st August, 1st September.
38, MS Nagaraja.
For R6, my lord, the
Up
matter
here for
pertains
R5,
to-
my lords. This is the bar association matter, my lord.
Matter pertains to, my lord, the appointment of administrator to the advocate association by superseding the, my lord, existing the body. Solely on the ground, my lord, the election is conducted on 21/4/2026, my lord, is improper. And annual returns which are not being submitted. On 2 grounds, my lord, the first respondent, state government has appointed the administration, my lord, administrator. Wide and actual judge, my lord, which is under challenge, my lord.
Yes.
Election has been conducted, my lord, on 21/4.
Which is the annexure?
My lord, annexed judge is the order passed by
Page number?
page number 67, my lord.
Yes.
Annexure or 2, annexed judge, my lord, this is only the ground, my lord, at in page number 69.
Yes.
What's the Advocates Association Nagmangla? Was the term of the office was getting over. What's the model bylaws?
What are the term?
What's the term was for a period of 1 year, which would be expiring in September 2025.
September 25.
Yes.
When was the last election?
No, its last election was again in the year September 2024.
It was held in September.
Yes. Lords, we have adopted the model bylaws of the Bar Council of Karnataka, which provides the term is actually 2 years. So what we did, we had passed a resolution in the association saying that since we have adopted the model bylaws, we will conduct the election after 1 year. That is from September 25 to September 26. We had written a letter to the Bar Council because
Option was by the general body or by the
Lords, it was by the general body.
Where is the
Now
resolution?
page 37, your Lords may kindly have a look at.
Yes.
Notice the Bar Council said that you conduct the elections on or before 31st March 2026, the last paragraph.
President has undertaken that elections will be held on or before 31st
Yes.
March. Yes.
So that the last paragraph, notes it says that we are permitted to hold the elections on or before that.
On your
date.
undertaking.
Yes. Then what happened? Page number 46. 25/3/26.
Yes.
Permission to conduct elections of the bar associations which are due. The Karnataka State Bar Council is receiving requests from various bar associations to permit to conduct elections. Previously, the State Bar Council has requested all the bar associations throughout the state to postpone the elections of the bar associations. Now, on the directions of so and so, the bar associations are permitted to conduct the elections which are due. So and so returning officer is also permitted the bar associations to conduct any functions which are pending due to the general so and so. This was the communication which was done on 25th of March 2026. Then we started the process.
Lords, one more letter was issued, my lords, again by the Bar Council.
This is a general correspondence that.
My lords, after that, if your lords were to see after
There is
that,
specific direction.
no,
The general
page number.
correspondence will not override the specific direction.
No, not at all. Then there is a general, there is a specific direction, my lords, to all the bar associations. Despite this, at page 39.
Yes. Where is it specifically for you?
No, specifically it is not extracted. It said that you maintain status quo. Last paragraph, page number 40.
Your order is specific to your association.
No difficulty, my lords. We held the elections in the month of April 2026.
31st March 26 did you hold?
31st of March 26 was the time. There was an order of status quo. Then the direction was given, which I now read to your lordships, saying that you can hold the elections.
You, Mr. Ravi Shankar. That is a general thing. When there is a
Now-
specific order
now the
for
question
you,
is this,
you have to
Lords.
comply with the specific order.
Lords, now we issued the calendar of events. Calendar of events was not challenged. All the advocates participate in the election process. Election is held. Elections, after holding the elections, results are declared. Office bearers have taken charge in the month of March 2026. So this is a process which the advocates in the general body have accepted. Now what happens? A block president of that constituency who is not an advocate, he gives a complaint to the registrar.
Who is not an advocate.
Who is not an advocate. Lords, may kindly have a look at that complaint.
Page.
Annexure. Annexure C, my lords, page 23.
23.
Allah, sure, page, annexure C, page 24.
24. Yes.
Lords will see in the letterhead, he gives a complaint. ಮೇಲ್ಕಂಡ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ಮನವಿ ಮಾಡಿಕೊಳ್ಳುವುದೇನೆಂದರೆ ನಾನು ನಾಗಮಂಗಲ ವಕೀಲರ ಸಂಘದ ಅಸ್ತಿತ್ವದ ಬಗ್ಗೆ ಅರ್ಜಿ ನೀಡಿದಾಗ ತಮ್ಮ ಕಚೇರಿಯಿಂದ ಸೋನ್ಸೋನ್ ಹಿಂಬರಹ ನೀಡಿ ಯಾವುದೇ ಲೆಕ್ಕಪತ್ರ ಸಲ್ಲಿಸಿರುವುದನ್ನು ತಿಳಿಸಿರುತ್ತೀರಿ. ಈ ಬಗ್ಗೆ ನಾಗಮಂಗಲ ಅಡ್ವೊಕೇಟ್ ಅಸೋಸಿಯೇಷನ್ ಹೆಸರಿನಲ್ಲಿರುವ ಸಂಘದ ಯಾವುದೇ ಲೆಕ್ಕಪತ್ರಗಳನ್ನು ಹಾಜರುಪಡಿಸಿಲ್ಲವೆಂದು ಹಾಗೂ ರಿನಿವಲ್ ಆಗಿಲ್ಲವೆಂದು ತಿಳಿಸಿದ್ದರಿಂದ ನಾನು ಸಂಘವನ್ನು ರದ್ದುಗೊಳಿಸಬೇಕೆಂದು 23/4/25 ಅರ್ಜಿ ಸಲ್ಲಿಸಿರುತ್ತೇನೆ. ಆಗ ತಮ್ಮ ಕಚೇರಿಯಿಂದ 23/6/25 ಅಡ್ವೊಕೇಟ್ ಅಸೋಸಿಯೇಷನ್ ಸಂಘಕ್ಕೆ ನೋಟಿಸ್ ನೀಡಿ ಅದರ ಕಾಪಿಯನ್ನು ನನಗೆ ಕಳಿಸಿಕೊಟ್ಟಿರುತ್ತೀರಿ. ಆದರೆ ಸಂಘಕ್ಕೆ ನೋಟಿಸ್ ನೀಡಿ 3 ತಿಂಗಳಾದರೂ ನಿಮ್ಮ ಕಚೇರಿಯಿಂದ ಯಾವುದೇ ಕ್ರಮ ಕೈಗೊಂಡಿರುವುದಿಲ್ಲ. ಆದ ಕಾರಣ ತಕ್ಷಣ ಮುಂದಿನ ಕ್ರಮ ಸೋನ್ಸೋ. Now on the basis of this,
the previous page expressed it that. Previous page expressed it.
Our mostly ಆಮೇಲೆ ನೀವು ಬನ್ನಿ.
But now no inquiry is conducted. But what the registrar does is,
yes,
he sends a report.
Page.
Notice the report is at annexure M.
Page.
Notice ಇದೆ ಅಲ್ವಾ report? ಅಲ್ಲ. I just point out. Page number annexure N, page 44. Correct.
44.
Yes.
Yes.
This is only a report. ಅಡ್ವೊಕೇಟ್ಸ್ ಅಸೋಸಿಯೇಷನ್ ನಾಗಮಂಗಲ ಮಂಡ್ಯ ಜಿಲ್ಲೆ ಸಂಘಕ್ಕೆ ಸಂಘಗಳ ನೋಂದಣಿ ಕಾಯ್ದೆ 27 ಹಿರಿಯ ಆಡಳಿತಾಧಿಕಾರಿಯನ್ನು ನೇಮಿಸುವ ಕುರಿತು ಸಹಕಾರ ಸಂಘಗಳ ಸೋನ್ಸೋ ಮೇಲ್ಕಂಡ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ಅಡ್ವೊಕೇಟ್ ಅಸೋಸಿಯೇಷನ್ ರಿಜಿಸ್ಟರ್ಡ್ ನಾಗಮಂಗಲ ಮಂಡ್ಯ ಜಿಲ್ಲೆ ಈ ಸಂಘಕ್ಕೆ ಆಡಳಿತಾಧಿಕಾರಿ ನೇಮಕ ಮಾಡಲು ಸಂಘದ ಜಿಲ್ಲಾ ನೋಂದಣಾಧಿಕಾರಿಗಳು ಹಾಗೂ ಸಹಕಾರ ಸಂಘಗಳ ನಿಬಂಧಕರು ಮಂಡ್ಯ ಜಿಲ್ಲೆ ಮಂಡ್ಯರವರು ಉಲ್ಲೇಖಿತ ಪತ್ರದಲ್ಲಿ ಈ ಮೂಲಕ ಕಚೇರಿಗೆ ಪ್ರಸ್ತಾವನೆಯನ್ನು ಸಲ್ಲಿಸಿರುತ್ತಾರೆ. ನೋಟ್ಸ್ ದಿ 4 ಐಟಮ್ಸ್ ಆರ್ ಸಂಘವು ಸೋನ್ಸೋರಂದು ಆಗಿರುತ್ತದೆ, ನೋಂದಣಿ ಆಗಿರುತ್ತದೆ. ಸದರಿ ಸಂಘವು ಸಂಘದ ಲೆಕ್ಕಪತ್ರಗಳನ್ನು ತಹಲ್ವೆರಿವಿಗೂ ಫೈಲಿಂಗ್ ಮಾಡದೆ ಸಂಘದ ಹೆಸರಿನಲ್ಲಿ ಹಲವಾರು ಆರ್ಥಿಕ ವ್ಯವಹಾರಗಳನ್ನು ಮಾಡಿರುತ್ತದೆ. ಅಸ್ತಿತ್ವವಿಲ್ಲದ ಸಂಘದ ಹೆಸರಿನಲ್ಲಿ ಪತ್ರಿಕಾ ಹೇಳಿಕೆಗಳನ್ನು ನೀಡುತ್ತಿರುವುದು ಕಂಡು ಬರುತ್ತದೆ. ನಿಯಮದ ವಿರುದ್ಧವಾಗಿ ಸಂಘವು ಕೆಲಸ ನಿರ್ವಹಿಸುತ್ತಿರುವುದರಿಂದ ಸಂಘವನ್ನು ರದ್ದುಪಡಿಸುವಂತೆ ಶ್ರೀ ರಾಜೇಶ್ ರವರು ದೂರು ನೀಡುವುದಾಗಿ ಸಹಕಾರ ಸಂಘದ ನಿಬಂಧಕರು ಮಂಡ್ಯರವರು ತಿಳಿಸಿರುತ್ತಾರೆ. Not the entire instigation is at the instance of a non-advocate. I'll go to the other allegation also. After he gives, and then the process is started, an advocate who had defaulted in payment of his arrears of subscription of the membership, he gives one more statement. Next, ಶ್ರೀ DR ಮಂಜುನಾಥ್ ವಕೀಲರು ಹಾಗೂ ಇತರರು ಸಂಘದ ಸದಸ್ಯರು ಸಂಘದ ಬೈಲಾ ಪ್ರಕಾರ 17/7/24 1 ವರ್ಷದ ಅವಧಿಗೆ ಚುನಾವಣೆ 15/7/25 ಆಡಳಿತ ಮಂಡಳಿ ಅವಧಿ ಮುಗಿದಿರುವುದಾಗಿ ಬೈಲಾ ಪ್ರಕಾರ ಹಿರಿಯ ವಕೀಲರ ವತಿಯಿಂದ 2 ತಿಂಗಳ ಅವಧಿಯನ್ನು ಮುಂದುವರಿಸಲು ಅವಕಾಶ ಪಡೆದು 15/9/25 ಮುಗಿದಿದ್ದು ಇಲ್ಲಿಯವರೆಗೂ ಯಾವುದೇ ಚುನಾವಣೆ ಘೋಷಣೆ ಮಾಡಿದೆ ಆಡಳಿತ ಮಂಡಳಿ ಇರುವುದಿಲ್ಲ. ಆದ್ದರಿಂದ ಸಂಘದ ಕಾರ್ಯಚಟುವಟಿಕೆಗಳಿಗೆ ತೊಂದರೆ ಆಗಿದ್ದು ತುರ್ತಾಗಿ ಚುನಾವಣೆ ಅಧಿಕಾರಿಯನ್ನು ನೇಮಕ ಮಾಡಿ ಆಡಳಿತ ಮಂಡಳಿ ರಚನೆ ಆಗುವಂತೆ ಮುಂದಿನ ಕ್ರಮ ಜರುಗಿಸಬೇಕೆಂದು ಕೋರಿರುವುದಾಗಿ ಸಹಕಾರ ಸಂಘಗಳ ಉಪನಿಬಂಧಕರು ಮಂಡ್ಯ ಜಿಲ್ಲೆಯವರು ತಿಳಿಸಿರುತ್ತಾರೆ. ಮಾನ್ಯ ಕರ್ನಾಟಕ ರಾಜ್ಯ ವಕೀಲರ ಪರಿಷತ್ನಲ್ಲಿ ಸಂಘದ ಅಧ್ಯಕ್ಷರು ದೂರುದಾರರಾದ ಮಂಜುನಾಥ್ ರವರ ಸಮಕ್ಷಮ ವಿಚಾರಣೆ ಹಾಜರಿದ್ದು, ಸಂಘದ ಚುನಾವಣೆಯನ್ನು 31/3 ಅಥವಾ ಸದರಿ ದಿನಾಂಕದೊಳಗೆ ನಡೆದ ಬಗ್ಗೆ ದಿನಾಂಕ 21/11/25 ಆದೇಶ ಹೊರಡಿಸಿರುವುದು ತಿಳಿಸಿರುತ್ತಾರೆ. ಸಂಘವು 2021ನೇ ಸಾಲಿನವರೆಗೆ ಲೆಕ್ಕಪತ್ರಗಳನ್ನು ಫೈಲಿಂಗ್ ಮಾಡಿದ್ದು, 21-22ರಿಂದ ತಹಲ್ಬರಿವಿಗೂ ಫೈಲಿಂಗ್ ಮಾಡಿರುವುದಿಲ್ಲ. 1 ತಿಂಗಳು ಕಾಲಾವಕಾಶ ನೀಡಿದ್ದು, 2 ತಿಂಗಳು ಗಳಿಸಿದರೂ ಸಹ ಸಂಘವು 21-22ನೇ ಸಾಲಿನಿಂದ ತಹಲ್ಬರಿವಿಗೂ ಸಂಘದ ಲೆಕ್ಕಪತ್ರ ವಾರ್ಷಿಕ ಮಹಾಸಭೆ ನಡವಳಿಕೆ ಹಾಗೂ ಕಾರ್ಯಕಾರಿ ಮಂಡಳಿ ಪಟ್ಟಿಯನ್ನು ಸಲ್ಲಿಸಿ ಸಂಘದ ನೋಂದಣಿ ಅಧಿನಿಯಮ ಕಲಂ 13 ರಲ್ಲಿ ಸಲ್ಲಿಸುವ ಸ್ವೀಕೃತಿ ಪಡೆಯುವುದಿಲ್ಲ. ಸದರಿ ಅಂಶಗಳ ಹಿನ್ನೆಲೆಯಲ್ಲಿ ಸಂಘದ ಕಾರ್ಯಕಾರಿ ಮಂಡಳಿ ಸ್ಥಾನದಲ್ಲಿ ಕರ್ನಾಟಕ ಸಂಘಗಳ ನೋಂದಣಿ ಅಧಿನಿಯಮ 27ರಲ್ಲಿ ಆಡಳಿತಾಧಿಕಾರಿಯನ್ನು ನೇಮಕಗೊಳಿಸಲು ಸರ್ಕಾರಕ್ಕೆ ಶಿಫಾರಸು ಮಾಡಬೇಕಾಗಿ ಸಹಕಾರವು ಉಪನಿಬಂಧಕರು ಮಂಡ್ಯ ಜಿಲ್ಲೆಯವರು ಕೋರಿರುತ್ತಾರೆ. ಮೇಲ್ಕಂಡ ಹಿನ್ನೆಲೆಯಲ್ಲಿ ಆಡಳಿತ ಅಧಿಕಾರಿಗಳನ್ನು ನೇಮಿಸುವ ಅಧಿಕಾರಕ್ಕೆ ಸರ್ಕಾರ ದತ್ತವಾಗಿರುತ್ತದೆ. ಜಿಲ್ಲಾ ನೋಂದಣಾಧಿಕಾರಿ so on and so forth. Notes what is not referred to in this is the fact that the elections by this on 3/2/2026 was not conducted. It was extended up to 31/3/2026. Now there is a reference to that 31/3/2026 also. Lords, this date I am not certain, Lords, because they make a reference, but anyway, there is 31/3/2026 is also referred to. Without waiting for 31/3/2026, a report is sent saying that you will have to appoint the administrator. Now, after this, if your lords were to see,
when was the last election held?
Lords, 21/7/2024.
21/7/2024.
I'm sorry, 15/7/2024.
15/7/2024. And when was the last filing of the annual returns made?
Lords, the filing of the annual returns has already been done. Lords, may kindly have a look at page 34.
Yes.
Lords, so far as this extent is concerned, my lords, there is a report which is called for from the cooperative development officer at page number 34, annexure H. 11/11/25.
Yes.
Lords, straight away, can I take your lords, the last paragraph commencing from page number 35.
Yes.
ಮೇಲೆ ವಿವರಿಸಿರುವಂತೆ 2017-18ನೇ ಸಾಲಿನ ಪ್ರಸ್ತಾವನೆಯನ್ನು ಹೊರತುಪಡಿಸಿ 18-19ನೇ ಸಾಲಿನಿಂದ 20-21ನೇ ಸಾಲಿನವರೆಗೆ ನವೀಕರಣಕ್ಕೆ ಸಂಘದಿಂದ ತಮ್ಮ ಕಚೇರಿಗೆ ಪ್ರಸ್ತಾವನೆ ಸಲ್ಲಿಕೆ ಆಗಿರುತ್ತದೆ. ಮುಂದುವರೆದು 21-22ನೇ ಸಾಲಿನಿಂದ ತಹಲ್ವರಿವಿಗೂ ಅಂದರೆ 24-25ನೇ ಸಾಲಿನವರೆಗೂ ಪ್ರಸ್ತಾವನೆ ಸಲ್ಲಿಕೆ ಆಗಿರುವುದಿಲ್ಲ. ಕರ್ನಾಟಕ ಸಂಘಗಳ ನೋಂದಣಿ ಅಧಿನಿಯಮ 1960 ಪ್ರಕರಣ 13 ಪ್ರಕಾರ ಯಾವುದೇ ಸಂಘವು ನೋಂದಣಿಗೊಂಡು 5 ವರ್ಷಗಳವರೆಗೆ ನವೀಕರಣಕ್ಕೆ ಸಂಘದ ಲೆಕ್ಕಪತ್ರ ಫೈಲಿಂಗ್ ಮಾಡದೇ ಇದ್ದ ಪಕ್ಷದಲ್ಲಿ ನೋಂದಣಿಯನ್ನು ರದ್ದು ಮಾಡಲು ಅವಕಾಶ ಕಲ್ಪಿಸಲಾಗಿದೆ. ಅಲ್ಲದೆ ಮಾನ್ಯ ಸಹಕಾರ ಸಂಘಗಳ ನಿಬಂಧಕರು ಕರ್ನಾಟಕ ರಾಜ್ಯ ಬೆಂಗಳೂರು ರವರ ಸುತ್ತೋಲೆ ಸಂಖ್ಯೆ ಸೋನ್ಸೋ ರೀತ್ಯ 5 ವರ್ಷ ಮೀರಿ ಲೆಕ್ಕಪತ್ರಗಳನ್ನು ಸಲ್ಲಿಸಿದ ಸಂಘಕ್ಕೆ ಪ್ರತಿ ವರ್ಷಕ್ಕೆ 30,000 ರೂಗಳನ್ನು ದಂಡವಾಗಿ ಪಾವತಿಸಿ 31/12/25 ನವೀಕರಣ ಸ್ವೀಕೃತಿ ಪಡೆಯಲು ವಿನಾಯಿತಿಯನ್ನು ನೀಡಿರುತ್ತಾರೆ. ಈ ಹಿನ್ನೆಲೆಯಲ್ಲಿ ಸಂಘದವರಿಗೆ ನವೀಕರಣಕ್ಕೆ ಲೆಕ್ಕಪತ್ರಗಳನ್ನು ಸಲ್ಲಿಸಲು ಸೂಚನೆ ನೀಡಬಹುದಾಗಿರುತ್ತದೆ ಎಂಬ ಅಂಶವನ್ನು ತಮ್ಮ ಅವಗಾಹನೆಗೆ ಪೂರಕ ದಾಖಲಾತಿಗಳಿಂದ ಸಲ್ಲಿಸಲಾಗಿರುತ್ತದೆ. After this, now your lords may kindly see file matrದಲ್ಲಿ page number 66.
Yes, sir. 66.
Yes. 24/4/2026 it is submitted. On 23/4/26 letter, bottom is the acknowledgement. ಈ ಮೇಲ್ಕಂಡ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ಈ ಮೂಲಕ ತಮ್ಮಲ್ಲಿ ಮನವಿ ಮಾಡಿಕೊಳ್ಳುವುದೇನೆಂದರೆ ಸಂಘವನ್ನು 21, 22, 22, 23, 23, 24, 24, 25, 25, 26 ವರೆಗೆ ನವೀಕರಣಕ್ಕೆ ಬೇಕಾದ ಎಲ್ಲಾ ದಾಖಲಾತಿಗಳನ್ನು ಲಗತ್ತಿಸಿರುತ್ತೇವೆ. 1/4/21 31/3/24 ಅಧಿಕಾರದಲ್ಲಿದ್ದು ಕಾರ್ಯಕಾರಿ ಮಂಡಳಿಯವರು ನವೀಕರಣಕ್ಕೆ ಅರ್ಜಿ ಸಲ್ಲಿಸಿರುವುದಿಲ್ಲ. ತಮ್ಮ ಕಾರ್ಯಕಾರಿ ಮಂಡಳಿ ದಿನಾಂಕ ಸೋನ್ಸೋ ಅಧಿಕಾರದಲ್ಲಿದ್ದು ನಾವು ಅಧಿಕಾರಕ್ಕೆ ಬಂದಾಗಿಂದ ಹಿಂದಿನ 3 ವರ್ಷದ ಆಡಳಿತ ಮಂಡಳಿಯವರಿಗೆ ಮೌಖಿಕವಾಗಿ ಹಲವಾರು ಬಾರಿ ಸಾಕಾಗಿ ಕೊನೆಗೆ ದಿನಾಂಕ 31/10/25 ಮೇಲ್ಕಂಡ 3 ವರ್ಷದ ಪದಾಧಿಕಾರಿಗಳಿಗೆ ಲಿಖಿತ ನೋಟಿಸ್ ನೀಡಿ ಇದುವರೆಗೂ ಕಾಯ್ದಿರಿಸಿದ ಸಹಕಾರದ ಕಾರಣ ಫೈಲಿಂಗ್ ಅನ್ನು ಸಲ್ಲಿಸಲು ತಡವಾಗಿರುತ್ತದೆ. ನಮ್ಮ ಕಾರ್ಯಕಾರಿ ಮಂಡಳಿ ಹೊಸದಾಗಿ 21/4/26 ಅಸ್ತಿತ್ವಕ್ಕೆ ಬಂದಿರುತ್ತದೆ. ಆದಾಗ್ಯೂ ತಕ್ಷಣ ಕ್ರಮ ವಹಿಸಿ ಫೈಲಿಂಗ್ ಸಲ್ಲಿಸಿರುತ್ತೇವೆ. ಆದ್ದರಿಂದ ಸೋನ್ಸು 23/4/2026 minutes the filing is already done.
So you are a new committee.
We are a new committee.
None of them were part of the earlier committee.
No.
Yes.
Now this is already submitted. No, the reason why I am submitting this is that one of the reasons which was subject matter of the earlier report, which was dated 3/2/2026, did not remain. The PDO also said that this is the provision. This benefit could be extended and we have availed the benefit and we have filed it. The returns have already been filed now. The only other question, my lords, now is elections is already conducted. Now, the registrar does not send a report after the election.
Sends it on February.
And February.
Hmm.
Now the order impugned, my lords, if your lords were to kindly have a look at the order impugned at Annexure Z, which is, my lords, at page number 67.
Yes.
ಇದರಲ್ಲಿ ಸಹಕಾರ ಸಂಘಗಳ ನಿಬಂಧಕರು 3/2/26 ಉಲ್ಲೇಖ. ಸರ್ಕಾರದ ನೋಟಿಸ್ ದಿನಾಂಕ 13/4/26, ಕಾರ್ಯದರ್ಶಿ ಅಡ್ವೊಕೇಟ್ ಅಸೋಸಿಯೇಷನ್ 23/4/26, ಸಹಕಾರ ಸಂಘಗಳ ಉಪನಿಬಂಧಕರು ಹಾಗೂ ಜಿಲ್ಲಾ ನೋಂದಣಾಧಿಕಾರಿ ಮಂಡ್ಯ ಇವರ ಪತ್ರ ಸಂಖ್ಯೆ 25/5/26.
(23/4) is when you submitted all the.
Yes.
Yes. (13/4/26) ಯಾವುದು?
Notes 13/4/26 is the notice issued by the government on the basis of this 3/2 report.
Page number?
Not that notice is at page number page 57. Notes it reiterates the contents of the 3/2/2026 notice.
So this is also not replied to.
Because this is replied to, page number 59. Page 61, my lords, is the acknowledgement also. They have referred to, my lords, that we have given the reply at.
This is after the new committee came in.
After the new committee comes into existence on 23/4/2026, this is given. 13/4 is the date of notice, and this.
Yes.
Now, lords, so far as holding of the elections is concerned, my lords, all the advocates have participated. The polling has taken place. Declaration of results has already happened.
What is the strength of the association?
Association. Lords, 82 are the total members, my lords.
How many voted?
Lords, out of 82, 57 have voting power.
How many voted?
Vote ಮಾಡಿದ್ದಾರೆ.
Come to you.
Lords, unanimously they were elected. Nobody filed the nominations other than the requisite number of posts.
So there is no voting.
No, voting, the situation did not arise because after the.
Yes
of course,
or
your
no,
lordship's right.
To find out how many have participated, you've been saying that everybody participated.
Lords, now the moment election was notified.
The difference could be participated or boycotted when nobody voted.
Lords, that's if I were to read annexure, page 67, annexure Z, that is not the allegation against us because.
Anyway, there was no election.
Because the number of nominations filed was equal to the number of posts which was put for polling.
Yes. Did you also follow the Supreme Court directions on the reservation?
Page 55, if your lordships were to take.
Supreme Court direction on reservation has also been followed?
All these things are page 55, my lords. ಇದೆ ಟ್ರೆಷರ್ ಪೋಸ್ಟ್ ರಿಸರ್ವ್ ಮಾಡಬೇಕು ಅಂತ ಹೇಳಿದ್ದಾರೆ, ರಾಜಮ್ಮ ಅಂತ ಹೇಳಿ ಮಾಡಿದ್ರು, ಅವ್ರಿಗಾಗಿದೆ. ಪೇಜ್ 56 ಮಿನಿಟ್ಸ್.
56.
Page 56.
And what 1/3 for women in the committee? What about the committee?
Page 56.
Committee illa. Only the posts.
Serial number 4.
That is only for the treasurer. 1/3 in the committee. Women.
There are 5 members in the committee, my lords. Our election declaration of results ಅಂದ್ರೆ 5 ಜನ committee members ಅಂತ ಏನಿಲ್ಲ. My lords, according to the bylaws of Nagmangla, committee members will be co-opted, my lords. They will be, that's how their bylaws are designed.
Supreme Court.
The 5 office bearers, the election is only for 5 office bearers.
Yes.
Only 5 nominations were filed. Now, Lords, may kindly have a look at page 57, 67, annexure Z.
Yes.
Page 69, my lords.
Yes.
ಅದರಲ್ಲಿ ಪೇಜ್ 67 ಅಲ್ಲಿ ಹಿಂದ್ಗಡೆ ಪೇಜ್ ಅಲ್ಲಿ ಆ ಪ್ರಕಾರ ಅಂತ ಶುರುವಾಗುತ್ತೆ ಲಾಸ್ಟ್ ಲೈನ್ ಅಲ್ಲಿ. ಆ ಪ್ರಕಾರ ದಿನಾಂಕ 11/3/26ರಂದು ಪರಿಷತ್ಗೆ ಚುನಾವಣೆ ನಡೆದಿದ್ದ ಮಾನ್ಯ ಪರಿಷತ್.
Where are you reading?
Sorry, just read from page 68 minutes.
68.
Yes. ಮೇಲೆ ಓದಲಾದ ಕ್ರಮಾಂಕ 3ರ ಪತ್ರದಲ್ಲಿ ಸಂಘದ ಕಾರ್ಯದರ್ಶಿ ಲಿಖಿತ ಸಮಜಾಯಿಷಿಯನ್ನು ಸಲ್ಲಿಸಿ ದಿನಾಂಕ 1/4/21ರಿಂದ 31/3/24ರವರೆಗೆ ಅಧಿಕಾರದಲ್ಲಿದ್ದು ಕಾರ್ಯಕಾರಿ ಮಂಡಳಿಯವರು ನವೀಕರಣಕ್ಕೆ ಅರ್ಜಿ ಸಲ್ಲಿಸಿರುವುದಿಲ್ಲ. 15/7/24ರಂದು ಅಧಿಕಾರದಲ್ಲಿ ಕಾರ್ಯಕಾರಿ ಮಂಡಳಿ ಅಧಿಕಾರಕ್ಕೆ ಬಂದಾಗಿನಿಂದ ಹಿಂದಿನ 3 ವರ್ಷದ ಆಡಳಿತ ಮಂಡಳಿಯವರಿಗೆ ಮೌಖಿಕವಾಗಿ ಹಲವಾರು ಬಾರಿ ಕೇಳಿ ಸಾಕಾಗಿ ಕೊನೆಗೆ ದಿನಾಂಕ 31/10/25ರಂದು ಮೇಲ್ಕಂಡ 3 ವರ್ಷದ ಅವಧಿಗಳಿಗೆ ಲಿಖಿತ ನೋಟಿಸ್ ನೀಡಿದ್ದು ಸಹಕರಿಸದ ಕಾರಣ ಬಾಕಿ ಇದ್ದ 5 ವರ್ಷಗಳ ಫೈಲಿಂಗ್ ಹೊಸದಾಗಿ ಅಸ್ತಿತ್ವಕ್ಕೆ ಬಂದ ನಮ್ಮಗಳ ಕಾರ್ಯಕಾರಿ ಮಂಡಳಿಯವರು ದಿನಾಂಕ 24/4/26ರಂದು ಸಂಘದ ಸಂಸ್ಥೆಗಳಿಗೆ ನೋಂದಣಾಧಿಕಾರಿಗಳಲ್ಲಿ ಎಲ್ಲಾ 5 ವರ್ಷಗಳ ಫೈಲಿಂಗ್ ಅನ್ನು ಮಾಡಿರುತ್ತೇವೆ. ದಿನಾಂಕ 16/7/24ರಂದು ಕಾರ್ಯನಿರ್ವಹಿಸುತ್ತಿದ್ದು ಕಾರ್ಯಕಾರಿ ಮಂಡಳಿ 1 ವರ್ಷಕ್ಕೊಮ್ಮೆ ಚುನಾವಣೆ ನಡೆದರೆ ಚುನಾವಣಾ ವೆಚ್ಚ ಮತ್ತು ದೀರ್ಘಕಾಲೀನ ಅಭಿವೃದ್ಧಿಗಳಿಗೆ ತೊಂದರೆಯಾಗುತ್ತಿದ್ದರಿಂದ ಬೈಲಾ ಆರ್ಟಿಕಲ್ ಸೋನ್ಸೋರಂತೆ 1 ವರ್ಷದ ಬದಲಾಗಿ 2 ವರ್ಷಕ್ಕೊಮ್ಮೆ ಚುನಾವಣೆ ನಡೆಸಲು ದಿನಾಂಕ 16/7/25ರಂದು ನಡೆದ ಸಂಘದ ಸಾಮಾನ್ಯ ಸಭೆಯಲ್ಲಿ ಸಂಘದ ಬೈಲಾವನ್ನು ತಿದ್ದುಪಡಿ ಮಾಡಿ ಸದರಿ ತಿದ್ದುಪಡಿ 24/25ರ ಕಾರ್ಯಕಾರಿ ಸಮಿತಿಗೆ ಪುನರ್ ಅನ್ವಯವಾಗುವಂತೆ ಸರ್ವಾನುಮತದಿಂದ ಅಂಗೀಕರಿಸಿದ ಸಾಮಾನ್ಯ ಸಭೆಯಲ್ಲಿ ಅನುಮೋದನೆಗೆ ಪಡೆಯಲಾಗಿರುತ್ತದೆ. ಸದರಿ ಸಾಮಾನ್ಯ ಸಭೆ ತೀರ್ಮಾನಕ್ಕೆ ಬೈಲಾದ ಆರ್ಟಿಕಲ್ 45ರಂತೆ ಮಾನ್ಯ ಕರ್ನಾಟಕ ರಾಜ್ಯ ವಕೀಲ ಪರಿಷತ್ನಿಂದ ಅನುಮತಿ ಪಡೆಯುವುದು, ನಂತರ ಮಾನ್ಯರವರಲ್ಲಿ ನೋಂದಣಿ ಮಾಡುವುದು ಅವಕಾಶವಿರುವುದರಿಂದ ದಿನಾಂಕ 3/9/25ರಂದು ಪತ್ರವನ್ನು ಪರಿಷತ್ಗೆ ಬರೆಯಲಾಗಿರುತ್ತದೆ. ಸದರಿ ಪತ್ರದ ಮೇಲೆ 22/11/25ರಂದು ಸದರಿ ಪರಿಷತ್ನಿಂದ ಆದೇಶ ಮಾಡಿ 31/3ರೊಳಗೆ ಚುನಾವಣೆ ಪ್ರಕ್ರಿಯೆ ಮುಗಿಸಲು ನಿರ್ದೇಶನ ನೀಡಲಾಗಿರುತ್ತದೆ. ಆದರೆ ಅದರ ಬದಲಾಗಿ ಸಂದರ್ಭದಲ್ಲಿ ಪುನಃ ಮಾನ್ಯ ಕರ್ನಾಟಕ ರಾಜ್ಯ ವಕೀಲರ ಪರಿಷತ್ತಿನಿಂದ 6/12/25ರಂದು ಆದೇಶ ಮಾಡಿ ಪರಿಷತ್ಗೆ ಚುನಾವಣೆ ಇರುವುದರಿಂದ ಕರ್ನಾಟಕದ ಎಲ್ಲಾ ವಕೀಲರ ಸಂಘಗಳ ಪರಿಷತ್ ಚುನಾವಣೆ ಪ್ರಕ್ರಿಯೆ ಮುಗಿಯುವವರೆಗೆ ಪರಿಷತ್ತಿನಿಂದ ಮುಂದುವರೆದು ನಿರ್ದೇಶನ ಬರುವವರೆಗೆ ಚುನಾವಣೆ ನಡೆಸಬಾರದೆಂದು ನಿರ್ದೇಶನ ನೀಡಿರುತ್ತದೆ. ಆ ಪ್ರಕಾರ ದಿನಾಂಕ 11/3/26ರಂದು ಪರಿಷತ್ಗೆ ಚುನಾವಣೆ ನಡೆದಿದ್ದು ಮಾನ್ಯ ಪರಿಷತ್ನಿಂದ 25/3/26ರಂದು ತಮ್ಮ ಸಂಘಕ್ಕೆ ಚುನಾವಣೆ ನಡೆಸಲು ನಿರ್ಣಯಿಸಿದ ಪತ್ರದ ಸಂಖ್ಯೆ ದಿನಾಂಕ 6/4/26ರಂದು ತಲುಪಿದ್ದು 7/4/26ರಂದು ನಮ್ಮ ಸಂಘದಿಂದ ತುರ್ತು ಸಭೆ ಕರೆದು ಚುನಾವಣೆ ನಡೆಸಲು ತೀರ್ಮಾನ ತೆಗೆದುಕೊಂಡು ಅದರಂತೆ ನಮ್ಮ ಸಂಘದ ಹಿರಿಯ ಸದಸ್ಯರಾದ ಶ್ರೀ ಸೋನ್ಸೋರ್ ಅವರನ್ನು ಚುನಾವಣಾಧಿಕಾರಿಯನ್ನಾಗಿ ನೇಮಕ ಮಾಡಿ ಬೈಲಾ ಪ್ರಕಾರ 15 ದಿನದೊಳಗಾಗಿ ಚುನಾವಣಾ ಪ್ರಕ್ರಿಯೆ ಮುಗಿಸಲು ತೀರ್ಮಾನ ತೆಗೆದುಕೊಳ್ಳಲಾಯಿತು. ಅದರಂತೆ ನಮ್ಮ ಸಂಘಕ್ಕೆ ಚುನಾವಣೆ ನಡೆದು 21/4/26ರಂದು ನಮ್ಮ ಕಾರ್ಯಕಾರಿ ಸಮಿತಿ ಅಸ್ತಿತ್ವಕ್ಕೆ ಬಂದಿದ್ದು ಎಂದು ತಿಳಿಸಿ ಆಡಳಿತಾಧಿಕಾರಿ ನೇಮಕ ಕೈಬಿಡುವಂತೆ ಕೋರುತ್ತಾರೆ. ಮೇಲೆ ಓದಲಾದ ಕ್ರಮಾಂಕ 4ರ ಅನ್ವಯ ಉಪನಿಬಂಧಕರು ವರದಿ ಸಲ್ಲಿಸಿದ್ದು ಚುನಾವಣಾ ವೇಳಾಪಟ್ಟಿಯನ್ನು ಸಂಘದ ಸದಸ್ಯರಿಗೆ ಜಾರಿ ಮಾಡಿರುವ ದಾಖಲಾತಿಗಳನ್ನು ಸಲ್ಲಿಸಿರುವುದಿಲ್ಲ ಮತ್ತು ನಿಯಮಾನುಸಾರ ಚುನಾವಣಾ ವೇಳಾಪಟ್ಟಿಯನ್ನು ಪ್ರಕಟಿಸಿರುವುದಿಲ್ಲ ಹಾಗೂ ಸಂಘಕ್ಕೆ ದಿನಾಂಕ 21/4/26ರಂದು ಚುನಾವಣೆ ನಡೆದಿರುವ ಬಗ್ಗೆ ಸುಳ್ಳು ದಾಖಲಾತಿಗಳನ್ನು ಸೃಷ್ಟಿಸಿರುವುದಾಗಿ ಆಕ್ಷೇಪಣೆಗಳನ್ನು ಸ್ವೀಕೃತವಾಗಿರುವುದರಿಂದ ಸದರಿ ಅಡ್ವೊಕೇಟ್ ಅಸೋಸಿಯೇಷನ್ ಕೋರ್ಟ್ ಆವರಣ ನಾಗಮಂಗಲ ಮಂಡ್ಯ ಈ ಸಂಘಕ್ಕೆ ಆಡಳಿತಾಧಿಕಾರಿಯನ್ನು ಉಪವಿಭಾಗಾಧಿಕಾರಿಗಳು ಪಾಂಡವಪುರ ಉಪವಿಭಾಗ ಮಂಡ್ಯ ಜಿಲ್ಲೆ ಇವರನ್ನು ಆಡಳಿತಾಧಿಕಾರಿಯನ್ನಾಗಿ ನೇಮಿಸಲು ವರದಿ ಸಲ್ಲಿಸಿರುತ್ತಾರೆ. ಸಹಕಾರ ಸಂಘಗಳ ನಿಬಂಧಕರು ರಾಜ್ಯ ಬೆಂಗಳೂರು ಮತ್ತು ಸೋನ್ಸೋ ಕೂಲಂಕುಷವಾಗಿ ಪರಿಶೀಲಿಸಿ ಸಂಘದ ಚುನಾವಣೆ ನಡೆದಿದೆ ಎಂದು ಸಲ್ಲಿಸಿರುವ ನಡವಳಿಕೆ ಸಂಘದ ಬೈಲಾದ ನಿಯಮಗಳ ಬಾಹಿರವಾಗಿರುವುದರಿಂದ ಹಾಗೂ ಚುನಾವಣೆ ನಡೆದಿರುವ ಬಗ್ಗೆ ಸುಳ್ಳು ದಾಖಲಾತಿಗಳು ಸೃಷ್ಟಿಸುವಾಗಿರುವುದರಿಂದ ಆಕ್ಷೇಪಣೆಗಳು ಸಲ್ಲಿಸಿರುವುದರಿಂದ ಸಮಜಾಯಿಷಿಯನ್ನು ಒಪ್ಪದೇ ಅಡ್ವೊಕೇಟ್ ಅಸೋಸಿಯೇಷನ್ ಕೋರ್ಟ್ ಆವರಣ ಮಂಡ್ಯ ಜಿಲ್ಲೆ ಸಂಘಕ್ಕೆ ನೋಂದಣಿ ಅಧಿನಿಯಮ ಸೋನ್ಸೋ ಆಡಳಿತಾಧಿಕಾರಿಯನ್ನು ಉಪವಿಭಾಗಾಧಿಕಾರಿ ಪಾಂಡವಪುರ ವಿಭಾಗ ಇವರನ್ನು ನೇಮಿಸಲು ತೀರ್ಮಾನಿಸಲು ಈ ಕೆಳಗೆ. Now there are only 2 contentions. If there is an allegation which is made that elections is not conducted properly, inquiry is necessary because somebody has to give a finding. It cannot be based on a report. Somebody cannot give an ex parte report behind my back and say that this is the Dakeshwari Cotton Mills case very specifically said you can't secure something behind my back and do this. This appears to be page 67, reference number 4. There is some reference to 25/5/2026. We are definitely not aware of what this is. Notice the proceedings before the government is based on the 3/2/2026 report only. After we submitted the report on submitted our reply on 23/4/2026, we have not received any further notice. No oral hearing. There appears to be a report which is referred to at page number 4. That's reference number 4, which says that these are the documents. We are not notified about anything. Straight away they say that because of this we are appointing an administrator. There is a necessity, minimum necessity, my lords, is that they will have to
Administrators appointed, my lord, and taken charge on Saturday.
Just taken charge.
Taken charge.
Lords, ಗೆಜೆಟ್ ಆಗಿಲ್ಲ ಇನ್ನ.
ಆಯ್ತು ನೀವು ಮುಗಿಸಿ ಆಮೇಲೆ
ಅವ್ರು ಹೇಳಿ, ಅವ್ರು ಹೇಳಿದ್ರಲ್ಲ ಟೇಕನ್ ಚಾರ್ಜ್ ಅಂತ.
ಇನ್ನ ರಿಪ್ಲೈನೂ ಇದೆ ನಿಮ್ಗೆ.
Lords, the reason why I said this is, before an order comes into existence, this is what is happening wherever the political motivations is writ large, at least in this matter. Because entire thing starts instigated at the instance of a block congress president who has nothing to do with the association. And he takes cognizance. He doesn't even say. He sends a report. Notes now that report forms the basis of the notice which is issued to me. I have replied to the notice by which time the elections are said to have been conducted. One more letter is generated through one more person saying that no, elections is not conducted. Notes, where is any question of saying that because of this reason I am going to appoint an administrator? Because the reason which is now assigned is page 69, that second paragraph. All the other allegations have gone. Now they say the elections which are said to have been conducted is not properly conducted. They have manipulated the document, so on and so forth. Minimum required is to conduct an inquiry, my lords. Yes. Now, the one principle which evolved, my lords, during the course of this section 25 and inquiry proceedings, etc., is it came before a coordinate bench as to whether
whatever judgment you want to rely on.
Relying upon this. Lords, the coordinate bench was called upon to decide whether any dispute in relation to the election could be decided under section 25. Coordinate bench said it cannot be. Election disputes is only within the domain of the civil code because it requires an assessment of the facts, yes, which domain is not there with the Lords, now two grounds which I am urging, my lords. One, it is not preceded with any inquiry, nor the government holds an inquiry. Lords, may I kindly have a look at section 27 capital A.
Which para do you want to refer to in this?
Pardon, my lords. It is the jurisdiction of the registrar, my lords, which was considered. Sorry, my lords, I did.
Which para?
I'm sorry. Paragraph number. It commences from paragraph number 12, my lords. It commences from paragraph number 12.
Page?
Page number 18. Internal page, print page 18.
18.
Following a 3 judges bench judgment of the Chennai High Court, my lords.
Full bench of the Madras
Yes.
High Court approved by the Supreme Court.
Yes. Now that is at page 24, my lords.
So para 12 is the full bench.
It's full bench.
Approved by the
Supreme Court.
is at.
Lord, then the apex court in a judgment that is at page number 24. Apex court in a judgment rendered later notices the full bench judgment with the approval in the case of so and so. That is again highlighted, my lords, in para 3 at page 25. And then at page 27, my lords.
Is Narayana.
Yes. There are 2 judgments, my lords. One is Narayana's case, Ami Vilas case, 2 judgments. Para 13, my lords, is essentially where the court comes to the conclusion.
Para 13.
Para 13, sorry, para 13, it commences.
Page 28.
Yes, my lords. Page number 28. And para 14. Para 13 and para 14. And a positive direction is issued, my lords, that this is an issue which has to be resolved only by the competent civil court at para 14.
Yes.
Can I just pursue your lords? May I kindly see 27 capital A, my lords. Assuming they wanted to do this. Lords, 27 capital A 1C, where on a report made by the registrar or otherwise on inquiry, the state government considers it necessary in public interest to do so. The state government may, by an order published in the official gazette, appoint an administrator. So, three requirements, Lords. One, there should be a report of the registrar or otherwise.
That you have argued
To
extensively in
inquiry.
the other matter where we'll be dealing with that.
No, the reason why I am referring to in this is,
On
Lords,
inquiry is by the registrar or by the state government.
Lords, inquiry should be, Lords, the requirement is, even if the registrar conducts an inquiry, the inquiry contemplated in terms of section 27A 1C by the state is a distinct inquiry. That's a view taken by. I'll give that judgment, Lords. It says that inquiry by the registrar has nothing to do with the inquiry contemplated under 28 1C, which is by the state. So that has nothing to do with. So state is required to conduct an inquiry.
Give us the judgment.
That judgment I'll pass it on, Lords. Of course,
In the other matter also, you did not give that judgment.
I will pass it on, Lords. That's the view taken, Lords, by His Lordship Justice
We are
Bopana.
considering that also, we had started dictating, we are
My
considering that
apologies,
also
Lords.
without that judgment.
He had already prepared the written submissions. Yesterday I could not because I had not come to the courts on account of my ill health. So, but today itself, by the end of the day, I'll ensure it is. Now, where on a report made by the registrar or otherwise, on an inquiry, state government considers in public interest. Number 4 is gazetting.
Gazette, yes.
So now, unless all these 4 ingredients takes place, there is no question of appointment of administrator. Now, what happens next is this, Lords. The assistant commissioner does not wait for the gazetting.
Yeah, the crucial gazette, of course, the crucial thing would be Justice Bopana's judgment, what
Yes,
you
Lords.
mentioned.
Inquiry is a must, Lords. Those,
Inquiry
there
is
are
a
at least
must.
2 judgments, Lords. I have the judgments. I'll immediately,
Yes.
I'll
In
hand it
another
over,
Nimsha
Lords.
is it?
Yes.
You can come back and give it to us in the
Yes,
afternoon.
Lords, I shall
You
do
can
that.
finish your other arguments.
Now, and of course, one more judgment of the coordinate bench, Lords. Para 7 of this judgment.
Yes.
Here also the same issue came about, Lords. Of course, Para 7. In the facts and circumstances, it is required for the first respondent to satisfy himself as to the illegality committed in the election of the petitioner society, and only thereafter he can supersede the elected body and appoint an administrator. Contentions of respondent 3 to 7 is that the election to the petitioner society is not conducted in a manner known to law, and that the office bearers have been elected in contravention of the bylaws and the law of the land. To come to such conclusion, first respondent in his order has to state whether what is the bylaw or the law of the land which has been violated by the petitioner society, and what is the illegality in constitution or election of the present office bearers. Reason given by the first respondent, the impugned order is that the term of the governing body of the petitioner came to an end on 21/3/20, and after that the office bearers will only take carers. They are not entitled to take any major decisions. However, their said observation is in contravention of bylaw 27, which permits the previous office bearers to function till new body is constituted. Based on erroneous conclusion, they cannot take a major decision. He found fault with the manner in which elections has been conducted and enrollment of new members. Though he has come to conclusion that enrollment of members has taken place keeping in view the election, it is not mentioned which provision of the law is contravened. Further, the advocate appearing for response 1 and 2, response 3 to 7 in the course of arguments are not able to point out what is erroneous in enrollment of the said new members. No other ground has been assigned in the impugned order for appointment of the administrator. However, the counsel for so and so during the course of argument submit that election as per the bylaws of petition society has to be conducted in annual general meeting. The same has not been done in the instant case, and if opportunity is given, they would establish the same before the authorities. However, the same is disputed by the petitioner, contending that election has been conducted in a manner known to law. Whether election is conducted in the general body or not is contemplated in the bylaws of society is a question of fact which cannot be gone into by this court while exercising its powers on 226. Both petitioner and respondent 2 to 7 submits that if given an opportunity before the first respondent, they would be able to establish the respective cases. This aspect has not been examined. Milords, in the next last line, Milords, liberty has to be reserved to the parties to approach the first respondent in this regard. That's because if this is an issue which you have to consider, that has to be looked into.
First respondent is the Secretary, Department of Cooperation.
Milords, yes, he is the state within the meaning of 27 capital A, Milords. Milords, one fact which I wanted to say, Milords, I think it's not that an administrator has to come to the association. Milords. They are kept. We understand that there were We have explained whatever has happened.
That would have been the first thing that.
Milords,
we
I-
said.
Milords, I can
Except
understand,
the
Milords, if-
Our council itself has said we tried to mediate and did not mediate. That's why we did not say anything. And the bar council had tried to mediate between both of you, have not mediated, then what can we say?
No, Milords, now can I just say this, Milords? What? One ನಿಮಿಷ ಇದು ಹೇಳ್ಬಿಡ್ತೀನಿ, ತೋರಿಸ್ಬಿಡ್ತೀನಿ.
Both factions were in touch.
Can I just, before that, Milords, I want to say this. ಏನಂದ್ರೆ association ಗೆ ಬೀಗ ಹಾಕದ. The assistant commissioner puts a lock to the association complex.
ಈಗ ಹಾಕೊಂಡಿರೋ association ಗೆ he has gone there.
Milords, any person can be appointed. Milords.
See, it is very clear, Mr. Ravi Shankar, that there are two factions. Both of you, iradi 87 jana. That's why we.
57 eligible voters.
Adralli, whatever 87 total members, we'll take it. 87 members only if you fight, what is this?
Milords, that's the reason why I said, Milords.
Can I make a
Milords, there is no question. Let this be decided. I will just make the submission, Milords. Milords, if the proceedings were initiated at the instance of any person who was related to the association, the requisite numbers in terms of section 25, probably it would have been a dispute. Milords, here is a case where a person unconcerned with the association, a block president of the Congress, which is the present ruling party, he initiates the proceedings. It is at his instance everything.
But Mr. Reddy is appearing.
Milords, no, that is, Milords, now that is apathy. Milords, now, can I just?
The more you say Mr. Reddy
No,
is.
Milords, can I just?
Cringing on that.
No, can I just? ಅವ್ರು ನೋಡ್ಲಿ ಒಂದ್ಸಲಿ ಅದನ್ನ. Can I just? Milords, he gives a press briefing.
We can bring solution.
Whatever it may be.
In the evening, I have initiated the discussion between both factions.
ಅಲ್ಲ ಹಂಗಾದ್ರೆ then of course.
ಇವತ್ತೇ.
But
We will come with solution.
one cold drink proceed.
ಅವ್ರು cold drink ಕಟ್ಸ್ಕೊಂಡು ಅವ್ರನ್ನ
Coffee ಕೊಡ್ಸ್ಬೇಡಿ.
ಅವ್ರನ್ನು ಸೇರಿಸ್ಕೊಂತೀನಿ ಡಿಸ್ಕಷನ್ಗೆ.
ನನ್ಗೆ Milords, something like this, Milords, about other associations, it is not a matter. But when it comes to advocates associations, I am emotionally involved. This is not the way advocates association should be treated.
Mentioned also, we told you we're instructing council.
No.
Try and
How
resolve
can the
it
state
and-
treat an advocates association like this?
21st, when the alleged election was held that day, I don't want to pain any faction. Buddha Jayanti, Shankaracharya Jayanti, B.R. Ambedkar Jayanti, I was told matter. No semblance of any election was done that day. In May, one caveat ಕೊಡುತ್ತೆ. Election has been held ಅಂತ ಇರ್ಲಿ, ಇದೆಲ್ಲ ಬೇಡ, ಇದು ಯಾವುದು ಬೇಡ. ನಾನು ಇಬ್ಬರನ್ನು ಕೂಡಿಸ್ಕೊಂಡು.
We are here to only decide ಅಷ್ಟೇ ನಮ್ ಕೆಲಸ.
ಇಬ್ಬರನ್ನು
But
ಕೂಡಿಸ್ಕೊಂಡು ನಾನು 4.
Milords, where is any question of?
all of you
It is,
know.
no, do they want to support?
ಒಂದ್ ನಿಮಿಷ Mr. Ravi Shankar.
Solution
ಅಲ್ಲ ಈಗ ನಾನು ಹೇಳ್ದಲ್ಲ ಈಗ ನಾವು ಅಡ್ವೊಕೇಟ್ಸ್ ಅಸೋಸಿಯೇಷನ್ ಗೆ ಅಡ್ಮಿನಿಸ್ಟ್ರೇಟರ್ ಅಪಾಯಿಂಟ್ಮೆಂಟ್ ಮಾಡಿದ್ರು. I was the one who represented. I said that there is no way that an administrator will be appointed to an advocates association.
Very good that noble thoughts are there. Now both of you sit and talk.
ಅದನ್ನು ಮಾತಾಡಿಸಿ will ensure that there is a solution by evening.
Only 87 people. It's
I
not
understand.
like
Milords,
you
it
have
is-
to get
Milords,
500 people
Can
together.
I, Milords, it is not like that. Milords, it is not like that. Now your lordships is finding that there are two factions, Milords. To start with, there were no two factions. There was one letter of this block Congress president and the proactive government who wanted the appointment of an administrator. No, we should not know about it. We are concerned about what the record says.
That's human society.
Present
Otherwise,
president is willing to conduct the election on his behalf also, I am claiming, whom Ravi Shankar represents.
both of you,
To conduct the
all
election.
of you,
He has also said, Papa.
the fact that so many of you are standing, past, present, future, everybody is here.
We have to bar, we have to.
You can look at it and
Milords,
sort it out.
Milords, I'm not coming in the way of what the Mr. Vivek Subbareddy is saying. I'm not speaking about that. No, Milords, I'm not on that point at all. Milords, what is paining me is that an administrator is coming to the advocates association. That is what is paining me. Not what he, Milords, I'm always open. I'm the one who takes the initiative to ensure that if there are such disputes, I go and take the forefront. But not, Milords, that an administrator is hanging on our heads.
Involved more than the president.
I should be. I will be.
Sarmarna.
I will be. No, I'm telling him. He also knows I get involved more than the president at times, even in relation
Right
to
now,
Advocates Association Bangalore.
we can only speak through our orders. That is what.
Very well, Milords. I'll just
Right
leave it
now,
at that.
all of you try and
We'll sit
see if
down
we
and
can
sort
sort
it
it out. If we sort it out, well and good. If there is any small niggly things in between, we can try and use
No,
our
of
good
course,
officers.
I have full faith in the president, my lords, when.
Keep Ravi and
If you are there,
ಮಾಡಿದ್ರೆ
if it doesn't sort out, then we have to pass orders, but avoid that.
very well, my lords. No, not.
For all litigants also, we say that if it is settlement, please do the settlement, because then you know what you are getting. It has to be one way or the other.
True, my lords.
And ultimately, Lord, it would be some ego there. We have to mollify and sure.
Always.
ಅಲ್ಲ ಈಗ ಅವ್ರಿಗೆ ಫಸ್ಟ್ ಗವರ್ಮೆಂಟ್ ಅಡ್ವೊಕೇಟ್ ಅವರು ಫಸ್ಟ್ ಲಾಕ್ ಓಪನ್ ಮಾಡ್ಬಿಡ್ಲಿ ಅಡ್ವೊಕೇಟ್ಸ್ ಅಸೋಸಿಯೇಷನ್. ಅಲ್ಲಿ ರೆಸ್ಟ್ ರೂಮ್ ಕೂಡ ಯೂಸ್ ಮಾಡೋ ಪರಿಸ್ಥಿತಿ ಇಲ್ಲ ಅಲ್ಲಿ. ಮಾಡ್ಲಿ.
ಅಸೋಸಿಯೇಷನ್ ಒಳಗೆ ಇದೆಯಾ?
ಅಸೋಸಿಯೇಷನ್ ಒಳಗಡೆ ರೆಸ್ಟ್ ರೂಮ್ ಇದೆ, ಲಾಕ್ ಮಾಡಿದ್ದಾರೆ, ದಯವಿಟ್ಟು ಲಾಕ್ ಓಪನ್ ಮಾಡ್ಬಿಡ್ಲಿ. ಅಡ್ಮಿನಿಸ್ಟ್ರೇಟರ್ ಆಮೇಲೆ ತೀರ್ಮಾನ ಮಾಡ್ಕೊಳ್ಳಿ.
Nobody will sit there. Mr. Ravishankar. No faction, nobody will
Nobody,
sit in.
Lords, as long as your lordship is handling this matter, nobody will claim that they are the president and secretary. But association will function.
Facilities will be used by all the lawyers.
All the lawyers.
Facilities. You want it in as an order?
No, my lord, 2:30 I'll get it.
We'll make it let us see by 4:30 what.
Now 5 o'clock.
ಬೇಗ ಮಾಡಿ.
ಇಲ್ಲ, ನಾವು sitting ನಲ್ಲಿ ಇದ್ದಾಗ ಬಂದ್
We don't want to sit, it's a little difficult to sit for too long. So 4:30 and nodi.
Lordship. Great.
Lordship, on submission, my lord.
Yes.
Serial number 86. It is a time bound matter, my lord, the division bench matter. There is a time bound matter, my lord. The division bench has directed to the honorable court dispose the writ petition within 4 months.
There is a direction by the division.
How,
file tegiri.
Taken up 2:30, my lord.
If there is a direction, we'll take it up.
Please, my lord. 86, my lord.
86, yes.
Now serial number 54. I informed the other side.
54. 54.
54. I informed the other side.
List ಕೊಡಿ, list ಎಲ್ಲ
ಮುಗಿಸ್ಕೊಂಡು ಮತ್ತೆ ಕರೀತಾರೆ. ನಿಮ್ದು ಯಾವ್ದಿದೆ? 74 ಇದೆ. ಈಗ ಮೆನ್ಷನ್ ಮಾಡಕ್ಕಾಗಲ್ಲ.
54.
Please.
You inform the
Other side, I informed.
50. ಏನಕ್ಕೆ?
Because some health issue there, senior counsel.
At the request of counsel for the petition released on 1st September.
Oblige.
Disposed of andre?
Please, my lords, the partial amount is received and they undertake to.
We can't pass orders now.
Sorry.
Only three matters. First, Dharwad, second list to passed over, so continue. Sir? 94, 92 ಇದೆ sir. Serial wise. ಇನ್ನೂ ಬಂದಿಲ್ಲ, ಬರಬೇಕು. 2:30 ಬರಲ್ಲ, 4 ಗಂಟೆ ಆಗುತ್ತೆ ಬರಕ್ಕೆ. ಅದೇ ಬೆಳಗ್ಗೆ ಮೂವ್ ಮಾಡಿ ಮಧ್ಯಾಹ್ನಕ್ಕೆ ಬರ್ಸ್ಕೊಡೋಣ.
ನಾಳೆಗೆ
ಮಾಡಿದ್ರೆ ಆಗ್ತಿತ್ತಲ್ಲ. 86 2:30ಗೆ ಅಂದ್ರೆ ಧಾರವಾಡದ ಆದ್ಮೇಲೆ. ಧಾರವಾಡ
ಟ್ರೈ ಮಾಡೋಣ.
ಟೂ ಮ್ಯಾಟರ್ಸ್.
ಅದು ನೆಕ್ಸ್ಟ್
ಕೊಟ್ಟಿದ್ದೀನಿ ನಾನು.
39 ಇಂದ 42 ಮಧ್ಯ ಯಾವುದು ಇಲ್ಲ. ಹೌದು ಇಲ್ಲ ಸರ್, ಫಸ್ಟ್ ಧಾರವಾಡ, ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್, ಫಾಸ್ಟ್ ಅವರ್ಸ್, ಆಮೇಲೆ ಕಂಟಿನ್ಯೂ ಮಾಡಿ. ಅರ್ಜೆನ್ಸಿ ಇದ್ರೆ ಮಾಡಿ. 69 ಇದೆ. ಅದೇ ಸಬ್ಮಿಷನ್ ಮಾಡಿ ಇದೆ ಸರ್. ಮಂಜುನಾಥ್ ಇಲ್ವಂತೆ ಈಗ, ಚಂದ್ರಮೋಹನ್ ಕೆ ಅಂತೆ. ಹೌದಾ ಸರ್, ಹೆಂಗಿದ್ರು ರೀಚ್ ಆಗಲ್ಲ ಸರ್, ನೆಕ್ಸ್ಟ್ ಟೈಮ್ ಬರೋ. ಹಾ ಸರ್, ನೆಕ್ಸ್ಟ್ ಟೈಮ್ ಬರೋ ಅಷ್ಟರಲ್ಲಿ ಡೇಟ್ ಆಮೇಲೆ ಅಪ್ಡೇಟ್ ಮಾಡ್ತಾರೆ. ಹೋಗ್ಬೋದು. 28. ಚಂದ್ರಮೋಹನ್ ಕೆ ಅಂತ. ಅಲ್ಲ, ಫಸ್ಟ್ ಧಾರವಾಡ, ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್, ಫಾಸ್ಟ್ ಅವರ್ಸ್, ಕಂಟಿನ್ಯೂ. 2:30 ಗಂಟೆಗೆ ಬರುತ್ತೆ ಸರ್. ಅಲ್ಲಿ ಮೆಮೊ ಬುಕ್ ಇದೆ, ಒಂದು ನಿಮಿಷ ಅವ್ರು ಬರ್ತಾರೆ, ಕೊಡ್ತಾರೆ ನಿಮ್ಗೆ. ನಾವು ಮೆಮೊ ಕಳ್ಸಿದೀವಿ. ಇಲ್ವಾ? ನೋಡಿದ್ರ ನೀವು ಇವತ್ತಿಂದ್ರಲ್ಲಿ ನೋಡಿದ್ರ ಗೊತ್ತಿಲ್ವೇ ನೀವು ಕೊಟ್ಟಿದ್ದಲ್ಲ ಅಂತೂ ಕಳ್ಸಿರ್ತೀವಿ ಯಾವ ನಂಬರಿಗೆ ಕೊಟ್ರಿ ನೋಡಿ ಯಾವ ಕೋರ್ಟಲ್ ಕೊಟ್ರಿ ನೋಡಿ
ಇಲ್ಲೇ ಕೊಟ್ಟಿದ್ದು ಮೇಡಮ್ ಬೆಳಗ್ಗೆಯಿಂದ ಇಲ್ಲೇ ಇದೀನಿ.
ಇದೆ ಎಲ್ಲ ಇದೆ ಇದೆ ಧಾರವಾಡ ಫಸ್ಟ್ ಧಾರವಾಡ ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್ ಪಾಸ್ ಕಂಟಿನ್ಯೂ ಕಾಯ್ಬೇಕು ಲಿಸ್ಟು ಎಷ್ಟೊತ್ತು ನಡೆಯುತ್ತೆ ಗೊತ್ತಿಲ್ಲ ಇದೆ ಒಂದು 2 ದಿನದ ಅಂದ್ರೆ ನೀವು FR ನಂಬರ್ ಅಲ್ಲಿ ಕೊಟ್ರ ರೆಗ್ಯುಲರ್ ನಂಬರ್ ಆಗಿತ್ತಾ ಇನ್ ಕೇಸು 2 ನಂಬರು ಇಲ್ವಾ ಇಲ್ಲಿ ಏನ್ ನಾವು ಈಗ ತಗೊಂಡ್ರೆ ಇಲ್ಲಿ ಕೊಡ್ತೀವಿ ಸರ್ ಸಬ್ಮಿಷನ್ ಮಾಡಿ ಕೊಟ್ಟಿದ್ದೆ ಈ ಕಡೆ ಕೊಟ್ರೆ ಈ ಕಡೆನಾ ಆ ಕಡೆ ಕೊಡ್ಬೇಕಲ್ಲ ಅವರು ಯಾವ್ದು ನಾವಂತೂ ಇಟ್ಕೊಳಲ್ಲ ಹಿಂಗ್ ಬಂದ್ ಕೇಳ್ಬಾರ್ದು ಯಾರು ಅಂತಾನೆ ಎಂಟ್ರಿ ಕೂಡ ಮಾಡ್ಕೊಂಡು ಸೈನ್ ತಗೊಂತೀವಿ ನೋಡ್ಪ ಯಾವ್ದಾದ್ರು ಮೆಮೊ ಆ ಕಡೆ ಇಟ್ಕೊಂಡಿದಾರ ಅಂತ ಅಷ್ಟೇ ಹೌದು ಆಗ್ತಾ ಇರ್ಲಿಲ್ಲ 62 ಇದೆ ಅಲ್ಲ ನೀವು ಸಬ್ಮಿಷನ್ ಮಾಡಿ ಡೇಟ್ಸ್ ತಗೊಳ್ಳಿ ನಾನ್ ಕೊಟ್ಟೆ 28/8 ಆಫೀಸ್ ಇದೆಯಾ ಇದೆ 28/8 ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್ ಇದೆ ಮಧ್ಯಾಹ್ನ ಇಲ್ಲ ಸರ್ ಲಿಸ್ಟ್ ಯಾವ್ದು ಅಡ್ಜರ್ನೇ ಆಗಿದೆ ತಗೊಳ್ಳೋದೇ 2:30 ಅಲ್ವಾ ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್ ಅಷ್ಟು ಎಷ್ಟಾಗುತ್ತೆ ಜಾಗ ಬಂಡ್ಲು ಹೆಂಗ್ ಕೊಡ್ತೀರಾ ಇರ್ತೀರಾ ನೀವು
ನಮ್ಗೆ ಇರ್ತೀನಿ ಒಂದೊಂದ್ಸಲ
ಅದೇ ಅದಕ್ಕೆ ಇಲ್ಲಂದ್ರೆ ಇದೆಲ್ಲ ಇಲ್ಲಿ ಜೋಡಿಸ್ಬೇಕು ಇದನ್ನ ತೆಗ್ದು ಆ ಕಡೆ ಜೋಡಿಸ್ಬೇಕು ಹಂಗ್ ಮಾಡ್ಬೇಕು ಇದನ್ನ ತೆಗ್ದು ಕೆಳಗೆ ಹಾಕಬೇಕು ಹೆಂಗಿದ್ರು ರೀಚ್ ಆಗ್ತದೆ ಅಷ್ಟೇ ಎಂಟ್ರಿ ಮಾಡಿ ಹೋಗ್ತಿರ್ತೀವಿ ಆ ಕಡೆಗೆ ಆ ಕಡೆ ಇಟ್ಬಿಟ್ರೆ ಒಳ್ಳೇದು ಹೌದು ಹಾ ಹೇಳಿ ಸರ್. ಆಮೇಲೆ ಅದೆಲ್ಲ ಇವಾಗಿಲ್ಲ. ಧಾರವಾಡ 2 ಮ್ಯಾಟರ್ಸ್. ಅದಾದ್ಮೇಲೆ ಲಿಸ್ಟ್ ನಂಬರ್ 2 ಪಾಸ್ಟ್ ಓವರ್ಸ್ ಆಮೇಲೆ ಕಂಟಿನ್ಯೂ. ಗೊತ್ತಿಲ್ಲ. ಹಾ 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 ಅಲ್ಲ ಅಲ್ಲ ಯಾವತ್ ಹಾಕಿದ್ದು ಅಂತ ಡೇಟ್ ಏನಾದ್ರು ಗೊತ್ತಿದ್ಯಾ? ಹೇಳಿ. ಫಸ್ಟ್ ಧಾರವಾಡ ಆಮೇಲೆ ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್. ಹಾ ಓಕೆ. ಇಲ್ಲಿ ಇಟ್ಕೊಂಡೆ. ಇಲ್ಲ ಸರ್, ಫಸ್ಟ್ ಧಾರವಾಡ ಆಮೇಲೆ ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್.
Ma'am, the court will take the first list or the second list?
First Dharwad bench matters, then second list.
Okay, thank you.
ಲಿಸ್ಟ್ ನಾನು ಕೊಡ್ತೀನಿ, ಅವ್ರ ಹತ್ರ ಇದೆ, ನನ್ನ ಹತ್ರ ಆ ಲಿಸ್ಟ್ ನೋಡಿನ ತಾನೇ ಅವತ್ತೇನೋ ಹೇಳಿದ್ದು. ಒಂದ್ಸತಿ ಅವ್ರಿಗೆ ಹೇಳಿ, ನನಗೆ ಹೇಳಿದ್ನ ಅವ್ರಿಗೆ ಹೇಳಿ, ಡೇಟ್ ಇದೆ ಏನ್ ಮಾಡ್ಲಿ, ನಾನೇನ್ ಮಾಡ್ಲಿ, ಎಲ್ಲದಕ್ಕೂ ನಾನೇ ಅಂದ್ರೆ ನಾನು ಎಲ್ಲಿಂದ ನನಗೆ ಗೊತ್ತಿದ್ಯಾ ಉತ್ತರ? ಎಲ್ಲದಕ್ಕೂ ನಾನು ಅದನ್ನೇ ಮಾಡ್ಬೇಕಷ್ಟೇ.
Lordship.
62. If I pass an order, you can't mention it for an order to be passed. At the request of counsel for the petitioner, relist on respondent relist on 1st September.
My lord,
Filing an
You don't want to wait. You want the order to be mentioning stage. Yes.
filing memo where the petitioner is not able to file the
Yenappa?
petitioner is not able to file the application under rural category because it's not having caste and income certificates. I filed an IA for the interim order, filing the memo for the same.
Without your caste certificate, you can't file an application.
No, Lord, because we have to enter the RD number, then only application will be for listing.
my lord, serial number, list number to serial number 11, my lord.
ಅವ್ರಿಗೆ ಕೊಟ್ಬಿಡಿ.
I'm appearing for the petitioner, my lord.
Yes.
Kindly 2 weeks time may be granted, my lord. I informed the other side also.
You informed everybody?
Yes, my lord.
11 at the request of counsel for the petitioner, relist on 2nd September. Yes.
Achha.
Serial number 62, my lord.
Huh?
Cost title is mistaken, my lords. Cost title, there is a typographical error in the cost title. It has to be Deccan Charters Private Limited.
Can we do anything at the mentioning stage, Mr. Counsel?
Dharwad bench matter. Serial number 1, Dayanand M. Bandi.
Please, Lords, I appear.
Yes, Mr. Upar.
Yes, Lords, in this revenue department, Lords, has taken steps, Lords, but with regard to Lords, UD and RDPR and Lords, Inspector General of Registration, Lords, the information is not yet received, Lords. So I request, Lords, next week, so that Lords, the process which has taken, Lords, the developments, I put forth before your Lordships.
So you need the instructions from whom? UD?
RDPR and Inspector General of Registration.
And IGR. Your AGA submit that the revenue department has already taken steps. However, action from the urban development department, rural development and Panchayati Raj department and the Inspector General of Registration and Stamps is awaited, directing them to provide the necessary information to the learned AG at the earliest. Relist on 19th August.
Please.
Serial number 2,
Lords, my learned friend would hand over Lords, a memo with regard to Lords, progress in the matter.
Mugita ilva?
Still, Lords, last time only, Lords, the notice was issued to the law secretary, Lords.
When will it be completed, madam? You have to follow this. This is, others will follow. This you will have to follow. And AG has filed a memo enclosing the letter dated 31/7/2026 from the ಯಾವ department ಇದು? From the law secretary. She submits that the draft workflow has been prepared and given 4 weeks time, the software would be implemented. Relist on 7th September.
Please.
list number 2, pronouncement of order, serial number 1, S.Y. Shivalli.
For the aforementioned reasons, most of them having been considered in judgment dated 15/7/24, even after considering the additional arguments and the additional citation which have been placed on record by the petitioner, this court does not come to a different conclusion than that arrived at on 15/7/24. No ground being made out for review of the aforesaid order, having come to a conclusion the claim can be rejected in part against defendant or against a particular property or against defendant with respect to a particular property, the above review petition stands dismissed.
Serial number 2, Vijeta Nayak.
It is, the writ petition is allowed in part. It is declared that the issuance of the lookout circular against petition number 2, his arrest and detention on 16/8/2014 and seizure of his passport were illegal and in violation of section 41, 41A and 438(3) of the Code of Criminal Procedure and Passports Act 1967 and the fundamental right of the petition number 2 to personal liberty under Article 21 of the Constitution. Respondent number 5 shall pay compensation of rupees 5 lakhs to petition number 2 and rupees 4 lakhs to petition number 1 within 12 weeks from the date of receipt of a copy of this order. The state through respondent number 5 shall be at liberty to recover the said amounts from respondent number 3 after giving respondent number 3 a reasonable opportunity of being heard in accordance with law. Respondent number 4 and 5 shall consider afresh in light of the findings in this judgment in paragraph 11 of Arnesh Kumar whether any further action against respondent number 3 is warranted in accordance with law and shall take an informed decision within 12 weeks. The quantum of any department penalty is left to the disciplinary discretion of the competent authority. Respondent number 3, 4 and 5 and the police authority shall scrupulously observe the safeguards in section 41 and 41A of the Code of Criminal Procedure, section 35 of the BNS 2023 and the direction in Arnesh Kumar while dealing with complaints arising out of matrimonial disputes. The prayer to direct a specific quantum of department punishment against respondent number 3 is declined. The allegation of custodial assault on petition number 1 is left open to be pursued if so advised before the appropriate forum. The Registrar General shall communicate a copy of this judgment to the Chief Secretary of the Government, the Principal Secretary of Home Department, Director General of so-and-so for compliance and for circulation of the above general direction to all the police units in the state. Though the matter is disposed, released on 14/9/26 to report compliance with general directions.
Serial number 3, Rupesha B.
ನೀವು ಸರಿಯಾಗಿ ನೋಡಿ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿ ಇನ್ನ ನೋಡು everything is in your favor. Writ petition is allowed. The impugned order dated 17/4/25 passed by respondent number 1 in case number so and so directing the petitioner to quit, vacate and hand over vacant possession of scheduled property is hereby quashed. It is made clear that the observation and finding in this order on the rights of the parties in scheduled property, including on the effect of the register gift deed dated 3/5/2018 and the deed of cancellation dated 16/2/21 are prima facie in nature and are confined to the disposal of this writ petition. OS 189 of 22 and OS number 1831 of 22 and any other proceeding between the parties shall be decided by the concerned court on their own merits uninfluenced by the observation in this order. Subject to result of these suit, the petitioner are permitted to reside in the ground and first floor of the building without causing any interference or obstruction to respond making use of the second and third floor of the building. Respondent number 3 shall have full access to the second and third floor and all common amenities which shall not be disturbed by the petitioners. Liberty is reserved to respondent number 3 to seek maintenance and such protective orders as are available to her under the Maintenance and Welfare of the Parents and Senior Citizen Act 2007 against the persons liable thereunder and to pursue such other remedies as are available to her in law if she is so advised. In the circumstance of the case, there shall be no order as to cause pending interlocutory application if any stand disposed.
Serial number 4.
Four.
5.
Wrong briefing. The writ petition is allowed. We have taken the view. Let us see. The order dated 8/1/25 passed in IA number 1 in COMAP number 112 of 24 is set aside. Consequently, IA number 1 is allowed and the application filed by HPCL under section 34 of the Arbitration Conciliation Act 1996 in COMAP 112 of 24 is held to be barred by limitation and stands dismissed. There shall be no order as to pass. Please. ಯಾವುದು ಏನದು 86 ಏನು ಅದೇ ಕೊಟ್ಟು ಹೋಗಿ ಅದು 86
List number 1, serial number 86, Parshuram Hattarkihar.
What is the directions by division bench?
For the writ petition. 29th July 2025, my lord. As expressly as possible, preferably within a period of 4 months from this order.
Earlier date as convenient. ಅಷ್ಟೇ. As convenient, it will be taken up in sequence.
Consequence
won't
is this,
get
my lord,
any-
already IA number 2 has been disposed by the Honorable
You won't
Court.
get any priority. There are a lot of people waiting before you.
That is correct, my lord. All the IAs are kept open, my lord. Matter taken a B group, my
At
lord.
1:30, you mentioned that the time-bound disposal. There's no
Within
time-bound
a-
disposal. Please don't make this kind of
My
submission.
lord, within 4 months from the date of order.
Ellide.
Your lordships kindly see. 7, page number 7. As accessible, preferably within a period of 4 months from this order.
Petitioner at earlier date as convenient request the court to dispose of the petition as expeditious as possible. Preferably within a 4
Please, my
months.
lord. Already 1 year lapse.
Then why did you not bring it to notice till now?
So many times I make a notice, my lord. For the bench. I filed a memo in this regard also.
Now 4 months have expired.
That is correct, my lord. If it is convenience, my lord, next week any date may fix at 2:30, my lord, lordships is heard and dispose of that. 2:30, my specifically.
Take
Senior
your
counsel is
chance.
engaged in this matter, my lord.
Take your chance. The request of counsel for the petitioner released on 19th at 2:30 PM.
Please, my lord. In preliminary.
List number 2, serial number 5, Bhargav Deepak.
This is my lord. We applied for building sanction. They want us to relinquish free of cost land towards a road. Page 16, lord, that condition is imposed.
Ayappa.
Bayappa.
Where is Mr. Yogesh Naik? How many times to tell them when they keep on doing this?
Paso, my lord, will call him.
Tell him we need to probably initiate contempt against them. How many judgments have been passed? Paso.
Admission, serial number 6, Bhargav Deepak.
Lords, I appear, my lords, for the petitioner. In this matter, my lords, lords had directed for me to take out hand summons.
Summons, what has happened?
My lords, hand summons were not able to be served. On the last occasion, my lords, I was not aware. There is a COMAP which is filed against my Section 9 order. I'll serve that counsel, my lords, who's appearing for them.
The counsel for the petitioner submit that
COMAP 258 of 2026.
appeal in COMAC
COMAP 258
uh,
of 2026.
has been filed challenging the order dated 22nd September 25 in commercial AA number 208 of 25. The counsel for the petitioner is permitted to serve the counsel for the respondent.
Counsel for the applicant.
respondent who has appeared in the said matter. Released on 19th August.
I'm obliged, my lords.
Serial number 7, Ravindranath K.
Lord. Today ready?
Here for the respondent number 2.
Lord, Lord, the petitioners all, my lord, the assistant, my lord, lineman, Lord, joined the service of the, my lord, the BESCOM.
State of Karnataka. Where is the additional SPP? Who is appearing for the state? Ready, madam?
Please.
Yes, Kelly. Let's go ahead, Ravindra.
5586, my lord.
Which file do you want us to take?
No, any, man. Look, your lordship holding which, my lord, I want to
You
take.
tell us which file will take that file.
First, my lord, the
11284? Yes, 11284 we have here.
It is the state master. Yeah. State master issue.
Lord, the petitioners are all, my lord, BESCOM employees. Lord, they joined the services, my lord, after the notification issued by the BESCOM. Lord, they all, my lord, the completed their ITI course in the year 2000, my lord, 12 to 13. Lord, the notification was for appointment was, my lord, invited in 2015. Lord, all they was, my lord, applied under the, my lord, said ITI courses, my lord, they joined. Lord, in the till by Lord 2022, there is no issue. Lord, in the only, my lord, in the 2019, Lord, when the communication has been sent by the, my lord, the employer, that have come to the, my lord, government, ITI board, Lord, there, my Lord, he said that the marks card which has been produced by the my Lord petitioners are not correct. Lord, some of the Lord, there is a mismatch of the names or the my Lord, the marks variations. And my Lord, some of the my Lord, the approval is not taken. These are the my Lord, three.
Approval by?
Approval means, my Lord, instead of, my Lord, when the admission which has been taken in the Hubballi, my Lord, the admission, my Lord, approval, for approval, they have taken the permission from the head office, Bangalore.
For the appointment.
Appointments. No, no, not for the appointments, my Lord, for writing the examinations.
Writing the exam, which exam?
ITA course, my Lord, ITA course.
Okay.
ITA course. Lord, that is done in the Lord 2013. Approval was allocated. Approval has been done to the Lord, all the employees. Lord, initially, Lord, because the inquiry was also been conducted, Lord, as per the order of the division bench of the Honorable Court, saying that, Lord, initially all the employees were terminated by the Lord issuing the notices that after receiving the notices from the ITA board, Lord, communication, they would dismiss the services of these Lord petitioners. Not only these petitioners, Lord, many Lord, almost 700 people, 700 Lord, employees were terminated. Everybody, Lord, they challenged him, Lord, individually writ petitions before this court. Lord, without holding any inquiry, Lord, the order of dismissal came to be passed. So, Lord, that order has been challenged before the Lord, the single judge, Lord, coordinate bench of this court. Lord, all the petitions filed by the Lord employees across the Lord, the state was allowed. Lord, holding that, the inquiry was not conducted. The proper inquiry was
found that inquiry was not conducted.
Not conducted.
In terms of division bench order.
Yes, my Lord.
Yes.
That order, my Lord, assailed by the my Lord, the BESCOM before the division bench, saying that, my Lord, whatever the order passed by the London single judge is not correct. But what, my Lord, the division bench says, my Lord, in the year 2020, instead of, my Lord, conducting an individual inquiry, Lord, this court, my Lord, in the division bench was appointed one, my Lord, retired district judge, who then, my Lord, arbitrator, the director of the arbitrator, one Mr. retired district judge, Nanjan Swami. Lord, he has conducted the inquiry. After holding the inquiry, my Lord, even in the inquiry, because the person who has to say regarding the marks card, my Lord, was the director of the ITA board. He himself only, my Lord, appeared before the inquiry officer. My Lord, he has certified cross-examination, he produced several documents. In the, my Lord, document, in the courses of cross-examination, he has admitted many things, my Lord, yes, because it is not the fault of the, my Lord, any students or the colleges. My Lord, because the initially, my Lord, for approval, Lord, what are the criteria is required? Lord, they have received the payment of the, my Lord, examination fees. Then, my Lord, they have given the all tickets. They have allotted the centers. Allotted the centers, they permitted to write exams wherever they allocated. Then, my Lord, marks card was issued by the ITA board. Lord, subsequently in the year, my Lord, 2019, they come up with that the earlier director was not, my Lord, mingled with these people, and he has created all this mess. Lord, that is not correct, because the ITA, my Lord, marks card were printed. Even C form is also been issued. Lord, C form means before getting the marks card, my Lord, they'll print the, my Lord, C form, all the marks card which has been obtained and after valuations. That is also, my Lord, based on this, my Lord, the inquiry officer come to the conclusion that the charges against the petitioners are not made out by the BESCOM. So, my Lord, they are all acquitted, my Lord, the
disciplinary proceeding.
Disciplinary proceeding, my Lord, concluded, and it has been come to the favor of the petitioners, all employees.
You've been reinstated.
Yes, I am reinstated. Now, what happened? Similarly placed charges, my Lord, the BESCOM, Lord, some of the Lord, executive engineer of the employees, Lord, BESCOM, they filed a complaint before jurisdiction police station before the, my Lord, inquiry. Charges in the, my Lord, the inquiry proceedings and the charges in the, my Lord, the complaint are one and the same.
Petitioners here are the second category.
Yes, my Lord.
Yes.
Oh, this is the, my Lord, where on the basis of that, my Lord, after the my Lord, holding inquiry and fair, my Lord, because the earlier only, my Lord, charges has been filed by, my Lord, the concerned police station, and also in some of the, my Lord, petitioner, some of the employees, where the, my Lord, the similar charges was placed, was, my Lord, all this matter was, my Lord, referred to the CID. My Lord, CID, my Lord, in almost all, my Lord, in one respect of 120 employees, they filed a, my Lord, A report, my Lord, B report, in respect of 90 employees, that after holding the inquiry, they have found that they have not committed any, my Lord, mistakes. My Lord, similar issue, my Lord, where this petition also before this court. My Lord, in the respect of this, my Lord, the Supreme Court also held, my Lord, when charges of the, my Lord, in the D as well as in the Lord, the criminal
was D initiated against the petitioners?
Everything is
even against these petitioners, D was
acquitted. Yes, my Lord. They're all, my Lord, it's in their favor. Lord, I've produced many, my Lord, in that way. One of that I can read out to you. Lord, your lordship will find it on volume 4, my lord, some of the.
Volume
4, my lord. Inquiry reports. Starts from, my lord, 940 page. Volume 4, page number 940.
Volume 4, page 940.
940.
Yes.
Lord, before that, my lord, page number 894, that is a division bench order. Para number 19, my lord, in that. Lord, 18 and 19 are very important. Lord, 19, my lord, where it is, my lord, that is page number 936, my lord, internal page 45.
Internal page 45.
45, para 19, 936.
These are all different people.
No, same people, my lord.
Who are the petitioners here?
They are also petitioner in that writ appeal, my lord. Some of the, there are.
Any of those petitioners, the appellants.
Some of them, not everybody. Some
Respondents are not here.
No.
Yes.
Lord, your lordship got 936, Lord, internal page 45, para 19. Lord. It is needless to observe that all the respondent employee who have not yet been reinstated shall be reinstated into service within a period of 2 weeks from the date of receipt of the certificate copy of the judgment. If not already reinstated, this directions is being issued since the appellants have already reinstated 12 employees and therefore having regard to the principle of parity, all the respondent employees shall reinstate it if already not reinstated. It is further directed that the said reinstatement is subject to the result of the inquiry. Any benefits that they have received consequential, the reinstatement shall also be subject to the result of the inquiry except salary that they would receive from the. This is a lord where the direction is given. Lord, here, para 18, my lord. Lord, in the middle, we think it and appropriate, my lord. In the para 18, lord, in the middle.
Yes.
We think that it is just and proper to direct Mr. H.M. Ranjan Swami, retired district judge, and presently the director of the Bengaluru Arbitration Center, to be appointed as an inquiry officer to conduct the inquiry and submit the report to the appellant in the place of Sri Shivanagowda, who has been appointed by the appellant's learner inquiry officer shall decide the venue of the inquiry and so on. So this, on the basis of this, my lord, the inquiry has been initiated by the, my lord, one of that, my lord, the inquiry is at page number 940. It is respect of the first petitioner, my lord.
Yes.
Lord, is conducted the thorough inquiry, my lord. Even in the, my lord, report, Lord, points 944, my lord, the finding of the inquiry. Before that, my lord, para 11, my lord, in 944, the points of the, my lord, reference, point number 1, which has been considered. I have heard the arguments both the sides and pursued the records. Now the points of emerged by me consideration that whether the state through BESCOM has established that the marks are produced by the DBE to secure the job of assistant lineman, powerman is a fake one. This is the, my lord, point. And this was consideration was given, my lord. Point number 1. That is not required, my lord. The detail it has been urged. Lord, your lordship may come to Lord 20, my lord, page para 20, page number 946.
Yes.
I may permit it to read, my lord. The DBE was given the roll number because what I said, my lord, roll number, he was permitted to take the practical examination, was issued with the hall ticket, was permitted to write the written examination. There was a evolution of the answer sheet. There was also translating the marks to the software, to the department, and also the declaration of the results. After all this, now the department wants to allege that the candidature of the DBE was not approved. This is not acceptable. The department wants to depend upon the name shown in the sessional marks card list sent by the college conducted. The DBE was not an approval candidate. It must be noted that there was no elimination of possibility of the college entering the wrong names in the sessional marks card list. It cannot be accepted as a final. In the absence of any explanation about the non-production of the marks card pertaining to the same roll number in the name of the other candidate shown in the sessional marks card list, and when there is no explanation as to how the name of the DBE came in the list, and when there is no explanation as to how the name of the DBE came into the knowledge of the department. In the following para, I call out how there was a wrong recording of the names of the candidate in the other inquiry before the me. Show that the recording of the data by the department was not error free of except to gospel truth. Next, my lord. Quite interest in the exhibit P1 marks card produced by the department. This is one of the, my lord, issue which a marks card itself. Because of that, I'm reading. Department is dated 3/3/2012. The results were declared in November 2013. Exhibit R2 marks card produced by the DB was issued on 21/2013. There is no likelihood of exhibit R2 being more reliable as it is bears date of issue of was on 21/23, while the result was declared in the November 2013. Hence, I cannot accept exhibit R2 as correct document. However, the question is whether the department has established the exhibit P1 marks card are producing by its fake. There is no violation between the marks shown in the C form and exhibit P1 marks card. PW2 was admitted this both are the documents of the department. The department has not produced the copy of the marks card to compare the same with exhibit P1. The C form at least is the document of the department. The marks shown in the same are also available in the marks card. Therefore, the department cannot blow hot and cold at the same time. Exhibit R1 is the letter allegedly sent by the department stating that the marks card is not fake. It contains the signature of the Srimati K. Jyoti, who is the present commissioner. Neither Halappa Shetty nor Srimati Jyoti are examined to establish that the signature of there is alleged are fake. There is no scientific evidence is established the same. Lord, next para 25. Lord. I must be observed that while feeding the data of C forum, there were errors which are brought to the fore in the other contended inquiry. It is alleged that D34 Mr. Santosh Hirangi and 50 of Mr. Ramappa Bhimappa Karadi, their names are not available in the sessional marks card, but the name of Sharabaya is shown. If it was argued that instead of one of the said person, the name of the Sharabaya is recorded, probably I would have accepted the same, but cannot be both the Sharabaya is a candidate, then they either Santosh or Ramappa should have been the wrong persons, but not both. This only evidence that there was an error in feeding in the data into the computer by the department and the DB, and such other student cannot be blamed. Not only that, even the case of DB39 Parshuram Patrota and D16 Basappa Ulmanavar, I find the name of the Mullikarjun is shown in the earlier case of Sharvaya. There is also similar case of DB46 of Devraj Dambala and so on. So these are the findings which has been given. Not para 27 is a conclusion by the inquiry officer. There was a reliance on the decision of the Honorable Appeals Court of India, deported so and so. Lord, it was case of where the candidate was permitted to write the examination, and later the university contended that the candidate had played a fraud on the university as is contended the candidate had played a fraud on the university as this application was not valid for admission. The candidate could not attend the required number of classes, and the university had authority to withdraw of the certificate. The court held that it cannot be done only before the candidate wrote the examination, as it was the duty of the university to scrutinize the form of the admission. When that was not done by the head of the department, question of fraud does not arise. It was also held when the department is able to discover the truth of the due diligence, allegation of fraud cannot be accepted. The said analogy is also applicable in this case. The officers of the department were capable of discovering the truth with necessary diligence, but they have failed to. Hence, the balance blame could not be attributed to the DB candidate. So on some not order, I hold that the disciplinary authority has failed to prove the charges made against the DB. Respondent as assistant lineman that the marks card produced by him in the disciplinary authority is a fake one. But now, in the before the inquiry, because the complaint was given before the inquiry, charges is also under the same.
The report has been accepted. It's not been challenged.
Lord, they have not, now what they have now done, my lord, as per the Lord C&R rules, there is a provision of 11E. Lord, they are not accepted this because the inquiry was conducted, my lord, as per the will and which choices of the my lord, the PESCOM. Now, my lord, they say the 11A notice has been issued, but what we, my lord, the employees, they have come before the my lord, challenging that 11E, my lord, everybody has taken the my lord stay order. Now, question is, my lord, before your lordship is that, my lord, the same.
So this is not attained finality.
Lord?
This is not attained finality. It's They're not accepted.
No,
it's
now what
challenged.
happened, my lord, in similar 10, my lord, this honorable court, my lord, in the respect of, my lord, same 10 employees who have filed the writ petitions. Lord, the communication, similar communication which has been sent, Lord, recently, which has been questioned before the court, my lord, has set aside and order to be that, my lord, give fresh marks cards. That I've produced the memo along with the memo.
You filed a memo of citation. Yavat file, madam. When did you file it?
Lord, 17. 17, Lord, page number 77. Recently, my lord, 29/4/2000, this order came to be passed. Similar issue which has been held, the order to, my lord, the same, the communication which has been given by the ITA board, that, my lord, saying that the marks card produced by the petitioners, my lord, in that case are not the same issue. Lord, that was allowed by this court, my lord. The petition, my lord, page number 104, my lord, order portions. The petition is hereby allowed. The impugned communication dated 1/4/25, annexure L issued by the respondent is hereby quashed. Lord, the concerned respondent are hereby directed to
This is
issue.
not challenging the D.
Lord?
This is not challenging the D.
No, not challenging the issue, my lord, where in the present case also issue is also, my lord, the same one, because the marks card, because as your lordship has posed the questions whether the issue which has been dealt by this court or not. Regarding same issue, my lord, the detailed order which has been passed, issue is only the same, my lord.
Where is the finding?
Lord. Lord, para 9, my lord. Onwards. Page number 88.
But this refers to the joint director. This does
Even,
not refer to the inquiry conducted in furtherance of the orders passed by the division bench.
Yes, my lord. Because to testify that, my lord, because BESCOM cannot testify the marks card issued by the, my lord, the ITA board. Lord, only their employee. The marks card which has been, my lord, given to me by the ITA board, which has been submitted to the that.
Correct, Mr. Rabindranath. What this judgment deals with is the earlier report of the joint director. That has anyway been set aside by the division bench. And Ms. Nanjun was appointed as the inquiry officer.
There, my lord, not communication. Because without holding the inquiry, my term service came to be, my lord, dismissed. That has been challenged without holding the inquiry, but conduct the inquiry, my lord, afresh.
But subsequently, for all of you, there was a separate inquiry officer who had been appointed by the division bench.
Earlier, my lord. Now, because when inquiry, in the inquiry, my lord, detailed, my lord, evidence, cross-examination, document was also placed by the ITA board. Lord, here, BESCOM has nothing to do with in the matter. My lord, only they are the employees. Because when they found that, my lord, after getting the report or endorsement by the ITA board, they say, my lord, your marks card produced by his effect, then they filed a complaint before the lord, the concerned jurisdictional police stations on the same issue. Before holding the inquiry, my lord. After the holding inquiry, my lord, the inquiry officer, my lord, detailed inquiry, held that, my lord, there is no fault on the part of even college as well as the, my lord, the students.
Yes.
My lord, even a report has also been filed.
Still not accepted. No. That report has not been accepted by the employer.
The employer, my lord, that is a 11-year because they cannot invoke. That is a, my lord, question which has been there before the, my lord, the coordinate bench of this court. The matter is pending, my lord.
Yes.
But issue, my lord, in this case, because because that has been given by the, my lord, 11 has been invoked by the BESCOM in respect of the marks card which has belongs to the ITA board. Lord, if ITA board, that's why, my lord, this judgment. Now ITA board has been directed to give, my lord, the marks card.
Yes. Which para do you want to refer to?
My lord, para 9, my lord.
Para 9. Yes. Yes.
Page number 88. A pursuant of the material on record, permitted to read, my lord.
Yes, please.
Will indicate that in the pursuance of the aforesaid order passed by the court, the respondents have issued the provisional trade certificate marks card in favor of the petitioners. So also remaining documents produced by the pertaining to the petitioner comprising the hall tickets for having taken SCVT examination, C form, SCVT trade test, list of approval student signed by the college authority as well as the joint director containing the names of the petitioner. Sorry to I'll stop for a moment because the issue now I read out in the inquiry, one and the same. Lord, trade test list approval list students signed by the college authority as well as the joint director containing the names of the petitioners. Receipt for having paid the examination fee, certificate issued by the college in favor of the petitioner for having undertaken and successfully completed the course, etc. Cumulatively established that the petitioners had undertaken the successfully completed and passed the ITI course, and that the respondent having been party to the opposite order passed by this court and also having issued the provisional marks card trade certificate in favor of the petitioners. Respondents were stopped from the subsequently contending that the petitioners were not entitled to obtain marks cards, trade certificate, and the various contents urged by the respondents that the marks card are fake, bogus, cannot be accepted, and that claim of the respondent is barred by the principle of estoppel, acquiescence, abandonment, and waiver, and the same are liable to be rejected. A pursuit of the material on record will be indicated that the only reasons assigned by the respondent is coming to the conclusion that the marks card of the petitions were fake, bogus is by placing the reliance upon by reports of the joint director and marks card verification committee dated 7/11/23 and 13/11/24, wherein it is stated that the names of the petitioners were not found in the approval admission list of their respective institutions. In this context, it is relevant to state that having regard to the cumulative effect by the material on record, comprising of all tickets for having taken a CBT examination, C form for a CBT test, list of approved students signed by the college authorities as well as the joint director containing the names of the petitioners, a receipt for having paid the examination fee, certificate issued by the college in favor of the petitioners for having undertaken and successfully completed the course, etc. The mere alleged technical defect, if any, in not mentioning or stating the names of the petitioners in the approval admission list cannot be make the basis of come to the conclusion that the petitioners had not undertaken or successfully completed the CBT examination, which fact stands established by the aforesaid material on record, and consequently no reliance can be placed upon the said reports by the respondent to contend that the marks cards of the petitioners were bogus or fake and not genuine as sought to the contended by them, and the various contentions urged by the respondent in this regard also cannot be shown. So, my lord, they relayed this judgment. Now, my lord, come to last. Lord, the coordinate bench has relayed many judgments. Lord, lastly, my lord, kindly come to the Lord, the page 101. The similar context, my lord, where the communication endorsement was given even to the petitioners also before your lordships. This has been extracted, my lord, the contents. Lord, that para 12 and Lord, these are the thing. Now 14, Lord, page number 102.
Yes.
As can, your lordship.
Yes.
As can be seen from the aforesaid judgment passed by this court, it has been held that a non-issuance of marks card in favor of the student who had successfully undertaken and completed the ITI courses by passing the CBT examination would result in the irreparable injury and hardship to them, and accordingly this court directed issuance of marks card in favor of the said petitioners. Further, as stated, the reports of the joint director and marks card verification committee could not have been made the basis of the respondent to issue the impugned communication dated 1/4/25, which deserves to be quashed, and necessary directions are to be issued to the respondent to issue the trade certificate, marks card, in favor of the petitioners. Under these circumstances, I am of the considered opinion that impugned communication dated so-and-so deserve to be quashed, and consequently directions to be issued to the respondent regarding issuance of trade certificate, marks card in favor of the petitioner within a stipulated time frame. As rightly contended by the learned counsel for the petitioner, several identity similarly placed, these are all comes in the one, situated persons including Ramanjan, Nadav, HK Manjula, Mallappa Gowda, Chicholi, etc., whose names were also not found shown in the approved admission list of their respective institute, have been issued a trade certificate, marks card by the respondent. And consequently, by invoking the doctrine of parity, I am of the considered opinion that the petitioners are entitled to obtain the trade certificate, marks card from the respondent by quashing the impugned communication dated 1/4/25 in this ground also. So-and-so, the petition is hereby allowed. The impugned communication dated so-and-so, annexurally issued by the respondent is hereby quashed. The concerned respondent are hereby directed to issue the trade certificate, marks card, as sought by the petitioner within a period of 1 month from the date of receipt of the copy of this order. Lord, now kindly see, Lord, for 90 peoples, because 173 was earlier, Lord, 90 people, Lord, even the by order of the division bench, Lord, the CAD has conducted across the states. Lord, every petitioner's matter was, Lord, sent to the CAD to investigate by the government. Lord, investigation has been conducted. Lord, a report was filed in the same issue, A report was not filed by the CID that they have not committed any mistakes.
For those
That is
90
also placed.
For those 90 people.
Yes, ma'am. Kindly see, that is also not filed along with my memo, my lord, it has been filed on 17, in the same memo, my lord, page number 22, my lord.
Page number?
Final report. In the same memo, my lord.
CID report, yes.
Final report which has been placed. Issue is one of the, my lord, to verify this only, my lord, to inquiry or conduct the investigation. Same thing, my lord, the 90 people were.
Relevant page?
Lord, I'll come. Lord, 34, my lord.
Yes. What do they say?
Lord, these are the names of the, my lord, by accused, the rank of the accused which has been mentioned, my lord, first para. Lord, next, my lord, next line. Email kanda, my lord, your lordship. Your lordship got that?
Yes.
ಈ ಮೇಲ್ಕಂಡ ಎಲ್ಲ ಆರೋಪಿಗಳಿಗೆ ಸಂಬಂಧಿಸಿದ ನೈಜತಾ ಪರಿಶೀಲನಾ ಸಮಿತಿಯವರು ತಮ್ಮ ವರದಿಯಲ್ಲಿ ವಿಭಾಗೀಯ ಕಚೇರಿ ಹುಬ್ಬಳ್ಳಿಯಿಂದ ನಮೂದನೆಯನ್ನು ಪಡೆದಿಲ್ಲ ಎನ್ನುವ ಕಾರಣಕ್ಕೆ ಸದರಿ ಆರೋಪಿಗಳ ಅಂಕಪಟ್ಟಿ ನೈಜತೆ ಕೂಡಲವೆಂದು ವರದಿ ನೀಡುತ್ತಾರೆ. ಸದರಿ 2011-13 ಸಾಲಿನಲ್ಲಿ ಆಯುಕ್ತಾಲಯ ಕೌಶಲ್ಯ ಭವನವರು ತಮ್ಮ ಟಿಪ್ಪಣಿಯಲ್ಲಿ 2011-13ನೇ ಬಾರಿಗೆ ವಿಶೇಷ ಪ್ರಕರಣವನ್ನು ಪರಿಗಣಿಸಿ ತರಬೇತುದಾರರ ಹಿತದೃಷ್ಟಿಯಿಂದ ಸಂಬಂಧಪಟ್ಟ ವಿಭಾಗದಿಂದ ಅನುಮೋದನೆಯನ್ನು ಪಡೆದಿದ್ದರು. ಕೇಂದ್ರ ಕಚೇರಿ ಬೆಂಗಳೂರಿನವರಿಂದ ಅನುಮೋದನೆ ಪಡೆಯುವುದು ಹಾಗೂ ಕಾಲೇಜಿನವರ ಇತರ ಮುಚ್ಚಳಿಕೆ ಬರೆಸಿಕೊಂಡು ಈ ರೀತಿಯ ಪ್ರಕರಣಗಳನ್ನು ಅನುಮೋದನೆಯಾಗಿರುವ ಹಾಗೆ ಪರಿಗಣಿಸಬಹುದು ಎಂದು ಟಿಪ್ಪಣಿಯಲ್ಲಿ ಸೂಚಿಸುತ್ತಾರೆ. ಹಾಗೂ ಮೇಲ್ಕಂಡ ಆರೋಪಿಗಳಿಗೆ ಸಂಬಂಧಿಸಿದ ದಾಖಲಾತಿಗಳು ಟ್ಯಾಬ್ಲೆಟೆಡ್ ಮಾರ್ಕ್ ಶೀಟ್, ಸಿ ಫಾರ್ಮ್ ಅಂಕಪಟ್ಟಿ, ಪಠ್ಯಕಾಲಿಕ ಅಂಕಪಟ್ಟಿಗಳು ಪರಿಶೀಲಾಗಿ ಮೌಲ್ಯಮಾಪಕ ನೀಡುವ ಅಂಕಗಳಿಗೂ ಸಿ ಫಾರ್ಮ್ ಅಂಕಪಟ್ಟಿಗಳು ಒಂದೇ ಅಂಕಗಳು ಇದ್ದು ಸದರಿ ಸಂಬಂಧಪಟ್ಟ ಇಲಾಖೆಯಿಂದ ಲೋಪದೋಷವಾಗಿರುವುದು ತನಿಖೆಯಿಂದ ಕಂಡುಬರುತ್ತೆ. ಹಾಗೂ ಇವುಗಳಿಂದ ಯಾವುದೇ ಸಾಕ್ಷ್ಯಗಳು ಲಭ್ಯ ಕಾರಣ ಆರೋಪದಿಂದ ಕೈಬಿಟ್ಟಿರುತ್ತದೆ. That individually, my lord, which has been given even in respect of some of the, my lord, marks card and other variations also, my lord, from 91 to, my lord, 98, next para, my lord. The same, my lord, one of that Saibana Biradar, my lord, page number 35, my lord, accused number 36, my lord. I'll read out one, my lord, why. ಇವರು ಸಿ ಫಾರಂ ಮತ್ತು ಅಂಕಪಟ್ಟಿಯಲ್ಲಿ ಅಂಕಗಳು ಒಂದೇ ಇದ್ದು ವರ್ಕ್ಶಾಪ್ ವಿಷಯದಲ್ಲಿ ಮೌಲ್ಯಮಾಪಕರು ನೀಡುವ ಅಂಕಗಳಿಂದ ಒಂದು ಅಂಕ ಅಂಕಪಟ್ಟಿಯಲ್ಲಿ ಕಡಿಮೆಯಾಗಿದ್ದು because they in that valuation, my lord, it is correct, but in 1 mark was reduced for him by the, my lord, the department itself only. In the cross examination even it is admitted. ಒಂದೇ ಇದ್ದು ವರ್ಕ್ಶಾಪ್ ವಿಷಯದಲ್ಲಿ ಮೌಲ್ಯಮಾಪಕರು ನೀಡುವ ಅಂಕಗಳಿಂದ ಒಂದು ಅಂಕ ಅಂಕಪಟ್ಟಿಯಲ್ಲಿ ಕಡಿಮೆಯಾಗಿದ್ದು ಇಂಜಿನಿಯರಿಂಗ್ ಡ್ರಾಯಿಂಗ್ ವಿಷಯದಲ್ಲಿ ಮೌಲ್ಯಮಾಪಕರು ನೀಡುವ ಅಂಕಗಳಿಂದ 5 ಅಂಕಗಳು ಅಂಕಪಟ್ಟಿಯಲ್ಲಿ ಜಾಸ್ತಿಯಾಗಿರುತ್ತದೆ. ಆದರೆ ಸದರಿ ಆರೋಪಿಗೆ ಸಂಬಂಧಿಸಿದ ದಾಖಲಾತಿಗಳಾದ ಪಠ್ಯಕಾಲಿಕ ಅಂಕಪಟ್ಟಿ, ಸಿ ಫಾರ್ಮ್, ಟ್ಯಾಬ್ಲೆಟ್ ಮಾರ್ಕ್ಶೀಟ್ಗಳನ್ನು ಜಂಟಿ ನಿರ್ದೇಶಕರು ಪರೀಕ್ಷೆ ಪರಿಶೋಧಕರು ಟ್ಯಾಬ್ಲೆಟ್ಗಳಿಗೆ ತೋರಿಸಿದ್ದು ಸದರಿಯವರುಗಳು ಟ್ಯಾಬ್ಲೇಷನ್ ಮಾಡುವ ಸಂದರ್ಭದಲ್ಲಿ ಕಣ್ತಪ್ಪಿನಿಂದ ಆಗಿರುವ ಸಾಧ್ಯತೆ ಇದೆ ಎಂದು ತಮ್ಮಲ್ಲಿ ಹೇಳಿಕೆಯನ್ನು ದುಡಿಯುತ್ತಾರೆ. ಆದ್ದರಿಂದ ಸದರಿ ಆರೋಪವನ್ನು ಕೈಬಿಟ್ಟಿರ್ತಾರೆ. Lord, these are the issue in the same issue, Lord, in all this, because it is not the fault of, Lord, the petitioners. Lord, they have permitted one, Lord, I'll repeat it, Lord, they have permitted to, Lord, they have paid the examination fees. If at all, my lord, if I am not approved, I have not taken the approval from the Hubballi, my lord, they themselves only, my lord, they should have rejected my admission without giving the hall ticket. They have provided the hall ticket, permitted to, my lord, they allotted himself only, my lord, to write the examination in the particular center. Then, my lord, I have written the examinations as per there. Then, my lord, marks card was verified, validated by the, my lord, department. My lord, after 6 years, they have kept quiet. Even, my lord, immediately, my lord, when I joined the company, my lord, the Vescom, in the year 2015, as per their notification, I joined 2015. Immediately, my lord, it is not the fault of the, my lord, Vescom. They communicated to verify whether the marks card which has been given by the petitioners are not genuine or not, to verify. They have kept quiet. They have not even sent. From 2019 or 20, they started, my lord, issuing these communications.
Yes.
Lord, even the issue before the, Lord, even in the criminal case and the, Lord, as well as one and the same, Lord, charges are not different. There is no extra charges. There is no modified intention. Nothing has been done. Whatever the charges are, Lord, completed in the or concluded in the inquiry, same charges. Lord, even the Supreme Court, Lord, is Rashid, Lord, in GM tank cases, Lord, held, and other 2 cases. When, my lord, similarly, my lord, even in the inquiry, as well as, my lord, the department inquiry, as well as in the criminal cases, the charges are one of the, my lord, if one way it is acquitted, so that has to be considered. That is what, my lord,
What else?
What else?
Yes, GM10. Para? ಇಂಡಿಯಾ ಕಾನೂನು ಕೊಡಬೇಡಿ
And Paul Anthony Miller. One more.
ಅದೇ ಕೊಟ್ಟಿದ್ದೀರಾ ಇಂಡಿಯಾ ಕಾನೂನು ಕೊಟ್ಟಿದ್ದೀರಾ ಇಂಡಿಯಾ ಕಾನೂನು ಕೊಟ್ಟಿದ್ದೀರಾ ಯು ಶುಡ್ ಗಿವ್ either from the Supreme Court website or
Sorry, where my
there's
GM
no
10.
para
It is-
number
it
which
is
will be
here.
mentioned in
Sorry,
India
it is
Canon
here.
reference.
It is here.
becomes a
It is here.
problem.
From the Supreme Court, it is here. I have taken. Sorry. Ma'am.
Yes. Para? ಇದು judice.nic. ESCR ಅಂತಿದೆ. All these judgments are available free.
Sorry.
With the neutral
I told
citation.
my colleague to download it when I.
When you take printouts like this, there's no para number which is mentioned.
Sorry, Miller, then I'll take it.
How to refer to it becomes a
Sorry,
problem.
Miller, sorry, I'll give.
ಹೇಳಿ ಎಲ್ಲಿ ಪೇಜ್ ನಂಬರ್ ಆದ್ರೆ ಹೇಳಿ. Let's finish it.
Lord, page 9, my lord.
Page 9. Yes.
Sorry, my lord, it is not with the memo. Paragraphs are not, sorry. Lord, the judgment laid upon the learned counsel, Lord, appearing for your lordship, Lord.
Yes.
Respondent are not distinguishable on the facts and law. In this case, department proceedings on the criminal cases are based on the identical and similar set of facts of the and charges. In a departmental case, the case appellant in the appellant and the charges before the criminal court are one and the same. It is true that the nature of the charges in the departmental proceedings and in the criminal cases are grave. The nature of the case launched against the appellant on the basis of the evidence and the material collected against him during the inquiry and the investigation, and it is reflected in the charge sheet. Factor mentioned are one and the same. In other words, charges, evidence, witness, and circumstances are one and the same. In the present case, criminal and the departmental proceedings have already noticed or granted the same set of facts, namely raid conducted on the appellant's residence, recovery of articles therefrom, the investigation officer Mr. V.B. Raval and other departmental witnesses were the only witnesses examined by the inquiry officer, who by relying upon their statement came to the conclusion that the charges were established against the appellant. The same witnesses were examined in the criminal cases, and the criminal court on the examination came to the conclusion that the prosecution has not proved the guilt of alleged against the appellant behind the reasonable doubt, and acquitted the appellant by the judicial pronouncement with the finding that the charges has not been proved. It is also to be noticed that the judicial pronouncement was made after the regular trial and the hot contest. Under these circumstances, it would be just and unfair to rather oppressive of the allow the findings recorded in the department proceedings to the stand. In our opinion, such facts of evidence in the department as well as criminal proceedings are the same without there being any iota of differences. The appellant should succeed. The distinction which is usually proved between the departmental and the criminal proceedings on the basis of the approach of the burden of proof would not be applicable in the instant case. Though findings recorded in the domestic inquiry was found to be valid by the courts below, when there was an honorable acquittal of the employee during the pendency of the proceeding challenging the dismissal, the same required to be taken note of the decision in the Paul Anthony's case. Supra will be applied. We therefore hold that the appeal filed by the appellant deserve to be allowed. These are the findings which has been given. Even the Paul Anthony was also case was also relied by the Honorable Supreme Court. In the instant case, the appellant joined the respondent in the year 1953. He was suspended from service on 8 to 79 and not subsistence allowance of rupees 700 per month, that is 50% of the salary. On so and so dismissal order was passed. The appellant has put 26 years of services with the respondent, that is from 1953 to 79. The appellant would now superannuated in February 1986. On the basis of the same charges and the evidence, the department passed the order of the dismissal on 21/10/1982, where the criminal court acquitted him on 31/2002. However, as the criminal court acquitted the appellant as on 31/22, and until such acquittal, there was no reason on the ground to hold the dismissal to be erroneous. The relief monetarily can be only with effect from 31/22, but by then the appellant had retired. Therefore, we deem it proper to set aside the order of dismissal without back wages. The appellant would be entitled to pension. Lord, then this is the order has been passed. The Supreme Court, my Lord, in this said, the inquiry, my Lord, even the charges are same in the inquiry proceedings and other things. If one, my Lord, were find that, my Lord, there is no basis, then, my Lord, this is what, my Lord, even our division bench of our two courts, my Lord, also held in the similar issue. No, sorry, my Lord, the same thing was followed out.
Then you get proper citation. One citation is fine. All
No.
of them are like that, then they also will have difficulty referring to.
Even in the Nagaraj case, the
ನೀವೇನೇನ್ citation ಇದೆಯೋ correct copies ಅವ್ರಿಗೆ ಕೊಡಿ. ಯಾವಾಗ ಕೊಡ್ತೀರಾ?
any, my Lord, within 2-3 days I'll give. Sorry,
By Saturday you will give it.
Yes.
When will you get ready, madam? Well,
Same marks cards issue early, Your Lordship.
Serial number 12 is another kind of case in which the case of an employee of Department of
we'll first let's finish this. Learned counsel for the petitioner seeks for and is granted 3 days time to furnish copies of all judgment that the petitioner relies upon.
I'm sorry,
on the
madam.
counsel for respondents. Relist on adjourn ಮಾಡಿದ್ರೆ date ಸಿಗೋದು problem. Relist on 13th at 2:30 p.m.
Please. Please pay.
I'm sorry, my Lord.
Yes.
Serial number 8. For the Shailaja party in person, connected matter.
Respondent number 1.
I am representing petitioner in 8.1, my lord. I am not related to 8 and 8.2.
You are in 8.1,
my lords.
1 for Shashikala. Shailaja is party in person.
Yes, my lord.
Yes. What happened to CCTV footage?
CCTV footage ಅಲ್ಲಿನೇ ಎಲ್ಲ ಗೊತ್ತಾಗುತ್ತೆ ಮೈ ಲಾರ್ಡ್.
Report is ready.
For the entire state also it's ready, my lord. It's being numbered.
In Paso or in Paso?
Tomorrow day after, my lord.
Day
It's
after
being
tomorrow.
numbered.
Today you are filing it.
Yes.
Learned AGA submit that the report will be filed by by the end of day tomorrow. Relist on 10th August.
My lords, interim order may be extended
Interim
in
order
8.
wherever granted is extended till next day.
Great.
Serial number 9. K. Ram Singh.
For petitioner in this, Your Honor. I am for, I have filed an application under A. So I have come, sorry, A2 and A3 I have filed application, Your Honor. Previously, the court had given liberty to me file before civil court after discharge application. I had filed a discharge application. The discharge application was dismissed. And hence I have appeared before this court. Here, the section is only on 506 has been booked in my charge sheet against me, Your Honor. And the main allegation is against A1.
Who appears for the state?
And A4 has been dropped.
Ready?
Please, Your Lordship.
Mr. Shamir Ahmad.
Has not appeared.
He is the complainant. Idara?
Bandila, sir.
ಇಲ್ಲ sir. ತೋರಿಸಿದ್ದೀರಾ?
None appears for respond number 2. If none were to appear for respond number 2 on the next date of hearing, matter would be taken up for consideration on the basis of submission made by counsel for the petitioner and learned ACGP. Relist on 19th August.
Till then stay into the entry.
You have his number, Mr. Shamir Ahmed's number in Aridya?
ಇಲ್ಲ ಸ್ವಾಮಿ ನನ್ನ ಹತ್ರ ಇಲ್ಲ.
Just inform him. Check from the Wakalatnama. Inform him to be present. Yes. Interim order 5, 7 interim order.
Till then interim order can be granted.
We'll consider it on that day. Notice has been ordered.
Serial number 10, HP Leeladhar.
Yes, Mr. Leeladhar.
Charge sheet has been filed against the petitioner.
Mr. Somshekhar.
Against KPID Act.
There are Somshekhar.
ಇಲ್ಲ
Ilva.
ಇಲ್ಲ
None appears for respond number 2. If none were to appear for respond number 2 on the next date of hearing, the matter would be taken up for consideration on the basis of submission made by the counsel for the petitioner and learned HCGP. Released on 19th.
Interim order.
Interim order.
ಇಲ್ಲ.
serial number
ಏನಾಗಿದೆ
11.
ಸರ್ ಸ್ವಲ್ಪ ಅವ್ರು ಚಾರ್ಜ್ ಫ್ರೈ ಮಾಡಿಬಿಟ್ಟು ಕಷ್ಟ ಅಷ್ಟೇ ಇನ್ನೇನು.
ಅದಕ್ಕೆ ಇವತ್ತು ಅವ್ರು
ಹಾ,
ಇಲ್ಲ
ಈ
ಅಂತ
case-
we have observed.
ಈ case.
Next time ಬರ್ಲಿಲ್ಲ ಅಂದ್ರೆ we'll take it.
ಆಯ್ತು.
Serial number 11 urgent 12.
It's 12, what is
It is similar to serial number 7, Your Lordship.
It's different ಅಂತಾರೆ.
It is different to the extent that, my lords, it involves an employee of the Department of Employment and Training, my lords. The allegation as against the petitioner in the instant case is that she had tabulated the marks with respect to the candidates who have received the marks cards.
This is about BESCOM or
The same BESCOM issue only, my lords, in
Huh.
which what has happened is there are 4 complaints which have been registered, 2 at Bangalore and 2 at Chitradurga and Hiriyur respectively. Now, before Hiriyur and Chitradurga, my lords, the officials of BESCOM have registered a complaint as against the students as well as the officials who have involved in the fraud is what they have alleged. And subsequently in Bangalore, my lords, the Department of Employment and Training, they themselves have filed a complaint in which they don't give my name. Basically, during the course of investigation, my lords, they say that I have tabulated the marks cards. Whereas the marks cards, my lords, which have been contained as a part and parcel of the charge sheet itself, does not contain my signature anywhere. And I was not in that section at all during the relevant course of time.
We'll consider it
My
along with
submission.
that matter only. ಯಾವತ್ತು ಇರ್ತದೆ? 7,
13.
released on 13th.
My lords, in the interim, my request is this, my lords, there is no interim order in this operative in this case.
13th is next week only.
The trial is coming in all the different corners of Karnataka, my lords.
When
That
is
is why.
When is it
My
posted?
lords, one matter I believe is in the next week itself, my lords.
13th we'll consider it. So you could inform the court on that. Yes.
Much up.
Serial number 13. Latif, please.
Yes, the case plot, the other accused is concerned, Lord, the similar charges are framed. The allegation that on the information received by the police, they arrested the accused number 1 to 6. They are preparing to commit dacoity.
What is the
Lord,
facts, Mr. Latif? Start from the swan. Yes.
Petitioner is accused number 1. He has not appeared before the court and his case was split up. Other accused, Lord, they are tried and one of the accused had approached this honorable court directly. Wherein, Lord, this honorable court has considered this application, this petition and allowed the proceedings were quashed.
482.
482. And similarly placed, accused number 3 and 6 are concerned.
Page number.
Please, that at page number 95, Lord.
We know nothing about your case.
Please, 95.
You know everything.
Yes.
Page number?
95.
95. Yes.
Then, Lord.
That was accused number?
7, Lord. Now, other accused are concerned. 3 and 6.
This order has been challenged or this has
Not
attained
challenged.
finality?
It attained finality. Now, so far as accused number 3 and 6 is concerned, Lord, the trial court has proceeded and they both of them are acquitted in SC number 119/19 dated 1/4/2025, wherein at paragraph 25,
Yes, what do you want us to see?
Now, kindly, my lord, page number 65 is the acquittal order insofar as accused number 3 and 6 is concerned, my lord. Kindly come to page number 20, para 25 of the trial court judgments, my lord.
3 and 6.
Please.
Para?
25.
Page?
Page 87, my lord.
Yes.
Further, PW2 is the Daniel eyewitness, Mahazar witness PW3 and 4, Lawrence Lebo are both are the eyewitness to alleged incident. However, they have completely turned hostile to the case of prosecution. In the evidence of PW7, Imtiaz is the owner of the car so and so clearly stated that his vehicle not given to the accused number 3 to 4 use. Same has not been known to him whether the accused number 3 has used the car. Then PW8 Riaz came to the scene, sold the car so and so to PW7, and he does not know whether the car is used for the by the accused number 3 along with the other accused persons to commit an alleged offences. Further, during the course of cross-examining, investigation officer PW12 also clearly admits that there is no offence of punishable under section 307 of IPC was committed by the accused persons as verified from the complaint. Further admits that the alleged spot of incident shown from this case is not the native of Ilyas or many cases registered against him, and he is a politician so and so. Further, the next paragraph, Lord, even MO is also concerned, Lord, the prosecution has miserably failed the way when the eyewitnesses and mother witnesses are turned hostile. The similarly placed evidence are placed and charges are framed against this petitioner, conducting one more trial. While in the examination chief also, Lord, so far as this petitioner is also concerned, they have turned hostile. Those witnesses relied by the prosecution. The prosecution even confronted the name of this petitioner. While placing the judgment of the Honorable Appeals Court and the coordinate principle in the similar facts, when the main accused, the charges are one and the same, the allegations and witnesses are the same, conducting one more trial, my lord, which is abuse process. Though, my lord, he is in.
The other accused, this is 3 and 6.
Others are not appeared before the court.
So 1, 2, 3, 4 and 5 are split up.
How?
And 7 was quashed.
Yes. I'll pass on the judgments, my lord. The first judgment, Lord, CB versus Akhleshing, wherein, Lord, the paragraph number facts, Lord, in main accused, Lord, was acquitted, discharged from the by the trial court, and para 5, Lord.
Para 5.
5. The fact. The police has recovered some bullets from the place of occurrence and also the dead body of the deceased Sayed so and so. Police also recovered a 38-bore revolver pursuant to the confession of the Amar Bahadur Singh. A9 pistol was recovered from the instance of accused Bhagavad so and so. On the basis of material available from the investigation agency, they filed a charge sheet against the respondent. It is interestingly noted that the original accused number so and so Singh and Amrita Kulkarni were implicated, but both of them were discharged by the order of the session judge, and that order of discharge was challenged by the state before the High Court unsuccessfully. A special PU petition was also filed by the before this court, and that too ended in a dismissal of 1992. Therefore, the very basis of alleged conspiracy by the respondent and Dr. Sanjay Singh has lost the substratrum. Admittedly, the respondent was not present in the Lucknow when the incident happened. The respondent was implicated in the case on the basis of alleged conspiracy between himself and the original accused so and so. There is no other material is placed by the court to prove that the complicity of the respondent. Then, Lord, the next paragraph. Another contention urged by the appellant was that the High Court has exercised the jurisdiction under 482 of Criminal Procedure Code after long lapse of time. It is true that respondent challenged the framing of charge against him after considerable delay, but it seems that the order of discharge passed in favor of the main accused attained finality. only in the 1994 when the court has dismissed a special leave petition. It is further only that the respondent approached this court with an application of 482 of CRPC and learned single judges those circumstances condone the delay. We do not think that the power exercise the High Court suffers from any illegality or perversity. The next judgment plot, in that case plot, the proclamations were issued against the very accused in a split up case, wherein also the Honorable Apex Court in para 3 plot, he was the proclaimed offender. Paragraph 3 at page number 7, the second judgment.
Yes.
Then also the Honorable Apex Court considered the acquittal of the other accused and quashed the proceedings of the split up accused. The para 3 is and what are the last two paragraphs, 9 and 10. We do not find the prosecutor and the complainant before the court as that no allegation whatsoever against the appellant. Main allegation against whom the Vikram Singh and prosecutor has married him on 4/8/2000 has given birth to the children in the wedlock.
No allegation against the appellant.
Yes. Here it is exercising the power under even the proclaimed offender is also the court has
proclaimed.
Yes. The next judgment plot, our own High Court plot, the division bench.
Yes.
Para 5, Lord, relying on this judgment of this Apex Court. It is well para 5.
Yes.
It is well settled the canon of the judgment so and so, Lord, wherein the evaluation of the case, no conviction or the accused is possible. Benefit of doubt is extended to the co-accused. Similarly situated is also available for non-appearance of the accused. The present case, in this case, dealt with the details insofar as evidence against the accused number 229 were concerned in criminal appeal so and so, found that prosecution miserably failed to bring the home of guilt against those accused. On going through the facts and circumstances as well as the reasoning of the court, we hold that entire material evidence of the prosecution is one and the same against all the accused, including the non-appearing accused number 1, who said to be in absconding. There is no second opinion that he would have entitled for. He is also entitled for the same benefit of doubt as extended to the co-accused in the light of law laid down by the Apex Court in Suresh Chaudhary case.
Yes.
Then another reported judgment plot, criminal petition 770/2017. That is para 23.
23.
Yes.
Yes.
Then one more judgment plot at page number 38. Writ petition 709/2018. There plot para 6 onwards.
Yes.
Page number 41. Another decision of so and so, Munir and so and so. Entire case of the prosecution is against 6 accused, particularly inseparable and identical one, especially when the judgment of acquittal is passed, when the PW denies the entire incident of role of accused. This reasoning of acquittal would be definitely ensure the petitioner. Even if the petitioner tried there cannot be any other material other than what already produced. Considering by the trial court, in such circumstances, it will be exercised the futility for the petitioner to undergo ordeal of the crime to be acquitted, holding the proceedings against the accused person who was absconding, subsequently against whom the sit-up charge sheet was filed, was quashed. In view of the above decision, the crystal clear the allegation against the accused person and co-accused were tried, acquitted by the court, one and the same, and they are not separate in nature. The prosecution already led the evidence one of the case and said the evidence is projected by the prosecution was also in respect of the absconding accused. There is no separate better evidence than the produced by the prosecution. In such an event, the court can quash the proceeding against the accused which was not available for, if accused who was not available for the trial. In this background, it is worth to refer the factual matrix of the case and so. And petition was allowed. Then brought the another judgment at page number 46.
Yes.
There also, my lord, the another judgment was followed and proceedings were quashed. And the last, my lord, one more judgment at page number 50. The criminal petition 4796/2017. There, my lord, they held that, my lord, even though if he is not surrendered, such an accused also entitled. Here is the case, my better, my lord, he has surrendered, he is in custody. Para 8 onwards.
Para 8.
And 9 is the relevant portion. Prosecution after placing the record, para 9. Prosecution after placing the case on record sought for conviction. Learned session judge, after appreciating the evidence rendered by the parties, acquitted all the 32 accused on the ground that no consistency, cogent or corroborative evidence referred to the prosecution creates a doubt about the case of offense accused. It is the contention of PP that the accused appearing for the petition, namely A3, who has now been arraigned as accused in the same crime, so and so, that charge sheet against the accused in Sessions case is general and common against all the accused persons, including the petitioner herein, that they have committed a murder of an Ibrahim so and so, when all the accused persons have been acquitted by the common judgment of so and so, which has reached finality. The continuation of further proceeding against the present petitioner would be abuse process of law. It is also submitted that even though after the conduct of fresh trial against the petitioner, same would be a waste of judicious time and would not serve the judicial purpose, and seek to quash the proceeding. Then para 12, by relying the judgments of the Apex Court CBI versus Akhilesh and Muhammad Ilyas, the court has held at para 14 and 15. And last finding at para 17. In view of the above said para 17, the law laid down by the discussion above, it would be emerges from would be no harm or injustice would be caused to the prosecution if the benefit of acquittal order passed by in favor of the accused petitioner, since the accused number 1 to 33, 25 to 33 against whom similar allegations have been made is already acquitted. Though there is a contention of the so and so appearing for the state for the petitioner should not be extended to said benefit, since he is an absconder. That is the difference from the other judgments. There, here he is still absconder, he is not surrendered. By the relying of the judgment of
only for the absconder.
here, yes, and present kid he is surrendered.
Yes.
By the relying of the judgment, coordinate bench not entitled to accept the contention of single reasons that judgment has been rendered based on the judgment of Deepak so and so, wherein the Apex Court, after noticing the facts and obtaining the case, he had held that benefit of acquittal should not be extended to the appellant. Since the co-accused has been acquitted, held departure can be made to the other case, where the accused is not surrendered after conviction, in the addition to filing of appeal against the conviction. Such noticing of earlier provision of law, it is laid down by the Apex Court in case of acquittal of the accused for the same offence and the same set of facts on the similar accusation. If considered, it would be entitled for acquittal of the co-accused also. Here, Lord, the allegations are that on the information received by the police, they apprehended accused number 1 to 6 together. Their recoveries were made effective. From the accused number 1 and 2, there is an allegation of the pistol was recovered from both. And accused number 3 and 4 and other accused concerned, the recovery of the one knife from accused number 3, 4, 5 and 6. 7, my lord, the allegation that he has absconded from the place that the lordship has quashed the proceeding.
Yes.
Therefore, the eyewitnesses and mother witnesses are one and the same for the entire prosecution case.
Yes.
And once they turned hostile, they cannot improve their own witness, my lord, and evidences in conducting one more trial. Even in the examination chief, also the PW2 to an extent of the presence of this petitioner is also that he had denied. I'll pass on that evidence also. I not placed it in the compilation. The prosecutor has confronted the name of this petitioner also. He has denied the presence also. Yes.
File it with the memo.
Please.
Yes. Yes, madam.
Your Lordship, this petitioner was arrested on 19/2/26, Your Lordship. Till then, it was a long pending case.
Yes.
And now it is CC numbered as 605 of 26. And as per the antecedents reports, 32 cases, and he is convicted in one matter, Your Lordship, 302 offense.
In this particular matter, what is the additional evidence that is available on record which is not available for others? Nothing.
Only the recovery of the weapon and the live
That was
bullets.
available for both accused 1 and accused 2.
That's
Third reserved. See, Latif, yes.
Serial number 14. Vivek Holla on connected matter.
Yes, Mr. Ron. Oh, Mr. Orla has to still finish
Still have to
another
finish.
half an hour.
Yes, please. Yes, yeah. Actually, this short password, is.
Short password ಆದ್ಮೇಲೆ reach ಆಗಲ್ಲ ಅದಕ್ಕೆ.
We just have 2 minutes answer to the arguments that was advanced on behalf of the state.
Yes, Mr. Orla. If we adjourn it, it goes.
But I know this. Lord, it's you have spent so much of time. It's my duty to be here.
Yes, please.
My Lord, I've taken Lordships through the list of dates.
Yes.
Now we have to, my Lord, the submissions. First of the submissions, my Lord, was as per Rule 143 of the Karnataka Land and Revenue Regulation.
Yes.
There was an amendment.
Yes.
That amendment, my Lord, empowered the government to
reduce the period.
No, it did not reduce the term, my Lord. Please have a look
Format
at.
was changed.
Rules can be changed, that's all. Please have a look at, my Lord. Your Lords may have a look at, my Lord, page 49 of the
49
of the, my Lord, the rejoinder.
- 4706 codified.
Please, my Lord. ಎಲ್ಲಿದೆ 147 ಇದಲ್ಲ 49 of what regulation
Page
compilation
49.
ಇದಲ್ಲ regulation compilations ಒಂದು ಇನ್ನೊಂದು ಹಾಕಿದ್ದಾರೆ ಸಾರಿ
ಅದು ಬೇರೆ.
rejoinder ಅಲ್ಲ
Regulation compilation is different.
state on regulation compilation
Photos.
317.
ಮ್ಯಾಮ್ ಅಲ್ಲೇ ಇರ್ಬೇಕು ನೋಡಿ ಪಿಂಕ್ ಕಲರ್ ಮ್ಯಾಮ್
ಇವರು ಫೈಲ್ ಮಾಡಿದ್ದಾರೆ.
ಹಾ ಕೆಪ್ಟ್ ಇಟ್ ಬಿಲೋ
Status file.
ಇನ್ನೊಂದು ಹಾ ಅದಿರ್ಬೇಕು ಎಸ್ 49
Yes.
please come to Lord page 49 it's not that Lord page 1 in the page 49 and 147.
147 reservation of rights.
Yes.
Yes.
It says the right to withdraw, alter above rules from time to time as may be necessary.
Yes.
It doesn't empower them to alter the
The submission made in terms of 146 is that the demise in Form E Appendix 2 has undergone a change. Therefore, from 999 years, it will become 99 years. And the new form will be applicable. Your submission earlier was that this Form E can only be prospective, not retrospective.
This amendment is in year 1940.
Correct. Yes.
Sorry, this is the original Please come to Rejoinder election.
Rejoinder election.
128. 128 ಅಲ್ಲಿ
128 ನೀವು ಹಾಕಿದ್ರಲ್ಲಿ ಇದೆಯಾ? ಅಲ್ಲ ಇದರೊಳಗೆ 128 ಅಲ್ಲಿ ಇದೆಯಾ?
128.
128.
Yes. At 136, which is the Form E.
Yes. This rule is made prospective. Which are here. Now, please come to page 129.
129. Yes.
Now, 128 ಬಂದ್ರೆ bottom ಅಲ್ಲಿ bylaws ಕೊಡ್ತಾರೆ.
Shall take effect from 1st July 1940.
Correct. Please come to page 129. ಮಧ್ಯದೊಳಗೆ 15th of June 1940 after 1, 2 ಅಂತ ಆದ್ಮೇಲೆ next.
Yes.
The lordship got that one?
The amendments will take effect from 1st July 1940 again. ಅದೇ ಹೇಳ್ತಾ ಇದ್ದೀರಾ?
Yes, after that.
Yes.
Chief Commissioner is pleased to issue the code land and regulations so and so and section 4 of the code so and so in section 1940 in supersession of the rules on the subject issue with notification noted in the margin. These rules will come into force on 1st of July 1940. Provided that nothing contained in these rules shall be deemed to invalidate any order passed under the rules in force immediately before the commencement of this.
Correct.
Therefore, whatever if it is 99 years, it will continue as 99 years. This has a prospective effect and will not apply or invalidate anything that was already done. Would be my submission, first submission.
Yes.
When it specifically says it does not invalidate, they can't now say I've reduced it to next 10 years. 999 years continues.
Continues.
Then, my lord, the second submission is document executed is not a contractual lease but a statutory lease. Under the government governed by the rules. For me, my lord, in page 82 of the regulation speaks of 999 years. Regulations not, my lord, the rules indicate 999. Ultimately, my lord, if your lordships come to my lord page 82 of the same compilation.
Yes.
This is the form. My lords get that, my lord. 155 month, 155 month. 82.
For me.
My lord, right side in 150.
That is for me.
Correct. Witnesses, my lord, please come down to the second unnumbered paragraph. Witnesses, the lesser in consideration sum of rupees so and so paid by the lessee, the receipt of which hereby acknowledged, doth hereby release, demise unto the lessee, his heirs representative for a period of 919 years from now on, parcel of so and so. And my lord, it forms a part of the rule itself. This form is a part of the rule. My lord, if your lord says again, my lord, have a look at that 89. Sorry, 82.
It forms part of Rule 146.
So it is, my lord, a part of the rule itself. Or, my lord, prescribed is a part of the rule. Rule is amended, and specifically, my lord, it states and holds, and, my lord, specifies that the rule, my lord, is prospective, does not invalidate anything that has been done earlier.
Yes.
Page
129.
Yes. Therefore, my lord, my submission to your lordships is
yes.
The submission that, my lord, these rules, my lord, have now been amended, and therefore, my lord, 999 years have got reduced to 99 years. My lord, is not able to be my second submission. Third submission, my lord, that has been made before your lordships. 139 to 147 should be read into form E of the indenture. Therefore, my lord, I have the power to withdraw. My submission is, the answer is very simple. Rule is prospective and says it will not invalidate anything else done earlier. Therefore, my lord, my submission is, whatever amendment you may do, when the rule itself, the amended rule itself says that, my lord, it is prospective and does not invalidate anything that has been done earlier, they can't now say it is reduced to 99. That would be the third. Fourth is that, my lord, the next contention is, it is governed by the government, my lord, grant rules of 1895. Can I persuade you not to get, my lord, that act?
Grant rules, could he?
Government Grant Act.
Bharti. Government Grants Act.
Government Grants Act of 1895.
Doubtful whether it will be here. Have you produced it, Mr. Ron?
I have a copy, may I just?
Yes, please. Government Grants Act 1895.
Clause 3 of the section.
Yes.
What my learned friend says is, this act, Lord, governs. Why? Because clause section 2 says Transfer of Property Act does not affect government grants. Section 2 will not permit me. Nothing in the Transfer of Property Act contained shall apply or deemed ever to have applied to any grants or other transfer of land or any interest therein, heretofore made or hereafter to be made, or in favor of any person whomsoever, But every such grant transfer shall be construed or take effect as if the said act has not been passed. That is, as if transfer of property is not passed. Look at section 4. Government grants take effect according to their tenor. All provisions, restrictions, conditions, limitations over contained in any such grant or transfer, as aforesaid, shall be valid and take effect according to their tenure. Any rule of law, statute, enactments of the legislature to the contrary notwithstanding. Therefore, my lord, this section saves, my lord, the grant which is already made. Doesn't mean, because, my lord, Transfer of Property Act doesn't apply. Doesn't mean, my lord, that the validity of, my lord, what has been granted, namely the grant order or the lease deed, which is for 999 years, my lord, evaporates. Continues.
So
That's
it's
why, my lord,
according
section-
to their tenor.
Yes.
Notwithstanding any rule, statute or enactment of the legislature. So your submission is 1940, notwithstanding the amendment in 1940, the tenor indicating 999 years.
Absolutely.
Yes. Yes, please.
Second submission, my lord, even in this regard itself, it is not granted under the Government Grants Act. My lord. What is being granted to us is under the Core Land Revenue Regulations of 1899. Lord, your lordships have seen, my lord, that
146 for me.
Therefore, it is not the Government Grants Act which will apply, but this will apply. My lord, that's the alternative argument, my lord, that I am placing before your lordships. Thirdly, my lord, the Section 202 of the Karnataka Land Revenue Act, my lord,
Land Revenue Act.
Sorry, my apologies. I should have told her not earlier. We also not run like mad. Sometimes we make
Sometimes some of these books are not available because all iPads will be confiscated. 202.
202.
Yes, repeal and saving.
Yes, the enactment specified in the schedule and any other law corresponding to this act are hereby repealed. B1. Any right, privilege, obligation, liability acquired, accrued, or incurred under such enactment or law, and any such investigation, legal proceeding, remedy by way of instituted, enforced by any such penalty, forfeiture, punishment may be imposed as if such enactment or law has not been repealed. And if your lordships come to the Lord, the repeal acts.
Poor land revenue is there.
Yes.
Seal number 15. Seal number 15. Yes.
Therefore, my lord, it does not empower the government to withdraw. Will be the third submission, lord, that I am making in this connection.
Yes.
Then, my lord, sorry.
Yes, good.
Then, my lord, the next submission is that petitioners' lands are, my lord, are all reserve forest lands. They fall within the Brahmagiri Ghat, Patti Ghat, Kadamkal Ghat, Kirti Ghat, etc. As per notification, my lord, they produce, my lord, under the compilation. Lord, our submission is the lands given are not reserve lands. In fact, my lord, they are also relying upon Justice Bopanna's order. That has been, my lord, set aside by the division bench, saying that this issue as to whether it's a reserve forest or not will be considered, my lord, at the appropriate stage, not at this stage. Lord, all lands in question have been shown to be Paisari lands. In, my lord, the Jamabandi extract, even before the lands were granted to us, Jamabandi extract, my lord, specifically show this.
Yes.
But Jamabandi extracts are at pages. of the edition documents dated 23/7.
Dated
23/7/2025. Edition documents and
7/25. Alidia number 23,725.
Sorry, reply to the, by the petitioners to the affidavit of CCM. Sorry.
Reply, but the date is 25.
23 without 6, sorry, 3/6/2026.
3/6/26.
That seal is 3/6, though my lord, we have put it as 9/12/2025. 9/12 would be the date for a type cover.
The reply by the petitioner to the affidavit of CC.
Correct.
Yes.
6 to 16,
6 to 16.
all lands are not shown as Paisari lands.
Well, 6 is your affidavit. Documents start from 12.
Page 12, my lord.
Yes. Form number 3.
Correct.
Jamabandi.
Paisari, the third column. Then my lord, next page.
Paisari. Tenure is Paisari.
Yes. Next page. All these will not show the lord that it is Paisari land. 3, sorry, 30. Then my lord, 15. Redeem Sagu anta barutte nodi, left side alli.
Redeem
Sagu Jaga.
Jaga.
All these will not are redeem Sagu Jaga. Then will not, same thing will not in page 17.
17 redeem
Redeem
Jaga.
Sagu Jaga. Then will not 18. Column number 2. Redeem Sagu Jaga.
Yes.
Current rubber indicator goskara modify. Next page 19. Redeem Jaga. 20. Redeem
Redeem
Sagu.
Sagu.
Then will not 21 onwards. Redeem Sagu Jaga. Column 6.
This is the RTCs. So Patta is Redeem Sagu.
Next page 22. 22, 23, 24, 25, 26, up to 34. All these are not same. Up to 34. Redeem Sagu Jaga.
Yes.
Hello.
Yes.
Up to 34. Then will not page 35 Bandartavu. Sagu will not and bottom 62. Redeem Sagu. Second column only. 62 will not 62 barutte. Bottom only 62 antidan. Page will not 35.
Page 35.
Left side, left extreme.
35 only.
Tenure Nibandhane anta barutte.
Patta number 44. Name of the Pattadar or holder as recognized.
Cochin Malabar rubber estate. Is there a number?
There's number must be some.
Page 35 or
Page 35 is this is what we have. This looks a little different from what you're reading. This is Jamabandi for the year 1958 to 79.
Correct. That is page 36. Redeem Sagu. Second column. Cochin Malabar rubber estate.
Cochin Malabar is there.
Redeem Sagu.
Redeem Sagu is there's a seal on top of it.
Previous page will not be a lot of come.
This is Sagu.
Sagu Cochin Malabar rubber estate.
Yes. Yes.
Redeem Sagu Cochin Malabar rubber estate.
Yes.
Next page. Page 37. Bottom my lords, you get 6 and the
Redeem Sagu.
Redeem Sagu. Cochin Malabar estate. Then my lord, next page. 38 or 39. I'm sorry, my lord, there is one page.
There's one page difference.
Yes, I'm sorry. Redeem Sagu. Left side is 2.
Yes.
Sampaja rubber syndicate. Then my lord, 40. Cochin Malabar estate. Redeem Sagu ಅಂತ ಬರುತ್ತೆ ನೋಡಿ. Second column
Yes.
Redeem Sagu.
Redeem Sagu.
ಮೇಲ್ಗಡೆನೂ Redeem Sagu ಅಂತಿದೆ. ಅದರ ಮೇಲೆ ಒಂದು ಸೀಲ್ ಬರ್ತದೆ ಸರಿಯಾಗಿ ಕಾಣುತ್ತೆ. ಫಸ್ಟ್ ಮಲಾಟಿ ಲಾಟ್ಸ್ ಗೋ.
Yes.
Redeem Sagu. Then my next page 41. Redeem Sagu Sampaja rubber.
These are the RTCs from 21.
Correct. Then my all are up to my the page
71.
60 or 59 if I'm not mistaken.
59.
Last is 59 of that. All are not Redeem Sagu.
Yes.
60. Redeemed Sagu, my lord.
Then it is Nilambur.
Correct. And Paisari, my lord, also on the third column also they say my lord it is Paisari.
Third column Paisari.
Then my lord, page 61 onwards. Sorry, 61, not that, 61. Redeemed Sagu, my lord, Kadamkal Rubber Syndicate. 61 on the left side and 2, column 2.
61.
60 or 61, my lord, I'm sorry. 193 is the page, after that, the page number in the ink.
193, yes, that is 59.
59.
Yes.
1938, 1942, no dear. That old.
Yes.
Redeemed Sagu. Then, page 61 onwards, till 71. All are redeemed Sagu. RTC.
Yes.
Up to about 71 or 70, whatever, my lord, there's some page difference. My apologies.
Yes.
Then, my lord, up to my lord 17, 80, sorry, 96 or 97. Sorry, 90, my lord, 4 or 95. ಎಲ್ಲ ಅಲ್ಲ ಇದೊಂದು ಒಂದು ನಿಮಿಷ ಅಪ್ ಟು ಬಲಾಟ್ ರಿಡೀಮ್ಸ್ ಆಗೋ ಅನ್ನೋದು.
This is Redeemed Sagu is
up to about 78, 79. 78 or 79, they are all not Redeemed Sagu.
till 85 is Redeemed Sagu. 86 it becomes Forest Sarkari.
And if you look at
Paisari.
at the top, they started saying it is a forest land. But Aranya Irak and Surma Bhutto, 83 or 84, not, I'm sorry,
Yes.
page number. Forest Paisari.
Forest Paisari.
They say Aranya Irak is Swadi Naldara.
And Aranya Ilake. So your name was deleted.
Yes, absolutely. And state Sarkar Jaga and Sakito.
On what basis of this deletion? Any order has been passed?
I don't want to say anything more. Notice will not appear. Straight away they change all that.
This aspect has been considered by Justice Bopanna. And this says when the reserved land, when it's reserved forest land, concept of redeemed and unredeemed does not apply. That's a categorical
Name
finding.
is there in the records. You can't
Sorry,
you can't go unilaterally change it by yourself.
The
name has been
RTC
there
entry, insofar as RTC entry, that I'll
Nearly
come back.
100 years it is there in the records. Suddenly one day you wake up and say we'll put Forest Department. Without
Anyway,
even a
it's
notice.
subject to the lease itself. Anyway, as landowner, the name can be reflected. As a landowner, where
Yes, Mr. Ron.
Yes.
That's all. I'll point out to the Honorable Justice Bopanna's paragraph.
Yes, Mr. Ola, anything else?
Then the next submission that has been made is that the lands given, forest land, I pointed out all that. Please come to the order of justice open number.
Page
187 note is of the writ petition.
Writ petition.
Order of justice open. Please come to paragraph 22 and 20.
Yes, 23.
On this aspect of the matter, DCF on reckoning the notification dated so has come to the conclusion this period was brought down from
Where are you reading?
Sorry. Page para 22.
22. Yes, 22. On this aspect of matter.
regarding the period of lease. On this aspect, the DCF on reckoning, the notification dates also come to the conclusion that the lease period was brought down from 999 years to 999 years, determining the end of the lease period. Though the set period has also not been completed, contention learned from severe and offset is that DCF did not have the jurisdiction to decide this matter. In this regard, it is contended lease has been executed by the Chief Commissioner of Court, representing the government, Secretary of the State for India in Council, and as such, the government alone which can determine this aspect. Forest Department being only for the purpose of administration, same cannot decide on this aspect independently. It was incumbent on it to seek the opinion of Law Department as contemplated in Rule 60 of the Karnataka Government Transactional Business Rules of 1977. Certain file notings from the year 1990 onwards, which is obtained under the Right to Information Act, is also referred to content. The same would indicate that it is the government which was dealing with regard to the lease, and the same could not be dealt with by the DCS, who has no authority. It is further contended that even otherwise the rules prevailing at the time of lease, form of device indicated the lease was 999 years. Opinion of the Land Advocate General of Bengal is referred to content, even though the lease was in perpetuity. Same was treated as 999 years for technical requirement. In any event, reduction of the period in the subsequent demise of the rules cannot be made retrospective, when more particularly the earlier long duration of the lease is agreed upon. The proviso to set rule itself to state that the rule does not invalidate any order passed under the ruling force. Learned Advocate General sought to justify the action by contending power is available under Section 82 and Rule 69 of the Act of 1960, that's the Land Revenue Act, and table contended. Insofar as the reduction of the period, it is contended that under the rules of 1909, by which the lands were leased, while clause 9, government had reserved to itself right to withdraw and alter the rules from time to time as may be necessary. Accordingly, the altered rules came into force in 1940. That I pointed out, Lord. It is not Lord, it is prospective, does not Lord, invalidate anything that has been done.
Yes.
Though several contentions and merits have been heard on this aspect, at the outset, the jurisdiction of the DCF to decide on the period of the lease requires to be considered. Power is placed to Section 8, but a perusal of the said provision would indicate same relates to forfeiture of the lease in the circumstances mentioned there. Even with regard to the authority of the state government, powers given to the respective officers is indicated in the table to Rule 69 of the rules. Power relating to 82, Section 82 is assigned to the Chief Conservator of Forest and Conservator of Forest. That apart, proceeds to the government, which is produced by the petitioners by obtaining a copy under the Right to Information Act. It is seen that the proceedings commenced in the year 1990. We have the tour notes put up by the then Honorable Minister for Forest and Animal Husbandry related to the very same petitioners here. Though the said proceedings were basically related to certain alleged violation of the condition, in the said noting Act note that the period of lease was also referred to and the doubt is expressed with regard to the validity of reducing the period. Be that as it may, no final decision appears to have been taken by the state government, nor is any material relied on by the DCF to indicate that pursuant to the rule made in 1940, demise made in favor of the petitioner, which was in the nature of contract, had been altered between the parties. That apart, Annexure 13, R13, produced by the respondent along with the objection statement in an extremely dated soon written Government General, Governor General, India in Council, and some by the company. Same refers to the earlier endangered lease deed dated 12/9/1980. Certain exchange of lands are made by granting Schedule B instead of Schedule B, but the documents indicate refers to the lease deed dated for 999. Thereafter states that Schedule B property is transferred to the lessee under the terms and conditions and for the period stipulated in the said lease deed dated 12/8/1980. This exchange deed was made after the 1940 rules came into force. These aspects have been referred only to indicate that insofar as the period of the lease, the government has been treating it as a particular manner, and as such, the government would have to take a decision. And when no such decision is taken, no such decision is shown to have been taken by the state government, order DCA with regard to some situation. When the authority whose order is questioned did not have jurisdiction, order requires to be filed, and that on that aspect only, on that ground, this court venturing into the merits to come to a conclusion regarding period of lease would be like putting the cart before the horse. It is only the state government takes a decision contrary to the interest of the petitioners, correctness or otherwise would rise for consideration in an appropriate proceeding, since until such time petitioner's interest in the endangered of lease will remain undisturbed unless the order. The argument was that judicial assessment will apply, but this doesn't would not do so. Is my submission.
Yes.
But page 261, his lordship will not cautious that order will not be, it was reduced to 99 years. As
To
far as
reduce
my lord-
reduction to 99 years is quashed.
As far as my lord reserve forest is concerned, my lord, I pointed out my lord that.
That has been set aside.
Then my lord, next submission was National Forest Policy of 1988 has statutory force and Conservation of Forest Act, my lord, FC Act will apply. My submission is indenture release has been executed my lord, in 1899 or my lord, 1910. Therefore, my lord, this forest policy of 1988 can't have any effect to be my submission. Then, my lord, they refer to my lord Godavarman's case. Godavarman, my lord, strictly my lord, has no application to be my submission. In fact, as I pointed out on the last occasion, these trees, my lord, are my lord like a forest. My submission is it is my lord dense forest because my lord is full of rubber trees. Greenery, my lord, ultimately, my lord, what is it? In fact, my lord, that's why I pointed out the rubber, my lord, ultimately, my lord, rubber board is a government entity, not my lord, a private entity. They themselves say, my lord, that it is far better than even the forest because, my lord, the regeneration of oxygen and all that much more is on. My lord, I leave it at
That may
that.
not be.
I leave it at that.
Your contention only is that just because there are trees doesn't mean it will come under para 4 of Godavarman. These trees are plantation trees and planted man-made plantation.
Their own, my lord, Karnataka Forest Development Corporation, 11,000 acres. Not, my lord, this is some 1,900, 11,000 acres, my lord, they continue even now. Though, my lord, it expired, my lord, some 20 years back. Therefore, all this, my lord, is, my lord, a matter, my lord, which requires, my lord, reconsideration. And, my lord, the orders that have been passed, my lord, is contrary to, my lord, the rules, regulations, and, my lord, the lastly, my lord, they refer to, my lord, 56 acres was, my lord, de-reserved and subsequently re-reserved, my lord, by a notification. In respect of, my lord, one of the Thompson plantation. Very fact, my lord, they
That is the exchange.
correct.
Yes.
That itself shows, my lord, that these are not reserved forests, would be my submission, and leave it at that. That's all. Then, my lord, judgments, compilation.
Inna judge. Study.
ಇಲ್ಲ ಇದೆಲ್ಲ ನಿಮಗೇನು ಸುಮ್ಮನೆ ನಮ್ಮ ಇದಕ್ಕೆ ಅಷ್ಟೇ ನಾನು ಅದಕ್ಕೆ ಒಂದು ನೋಟು ಹಾಕಿದ್ದೀನಿ ಮೇಲ್ಗಡೆ.
Yes, please.
First is my lord, right to property. First, I don't think my lord, I should come here lot with that. ಏನು ಹಾಕಿಲ್ವಾ? ನಾನು ಕೊಡ್ತೀನಿ. Second, my lord, third judgment, my lord, then registered document cannot be varied by an unregistered document. ಮೂರು judgment, ಎರಡು judgment ಹಾಕಿದ್ದೀವಿ.
Yes.
Then please turn the page 2. ಅದೊಂದು ಕಾಪಿ ಇದೆ. ನಾನು ಒಂದೇ ಕೊಡ್ತೀನಿ. Yes. Page 2, my lord. Government cannot illegally terminate the lease. Supreme Court has allowed in 2001, 8 years. Government cannot act like private individuals. That is the next judgment. That's serial number 6.
Yes.
Page 98. Then government has to honor its obligation under the contract. We have kept a lot some judgments. Yes. Then of course, my lord, their argument was that these are all contractual. Therefore, my lord, you can't page 3 onwards.
Yes, you're given the para numbers. We'll go through that.
But I know
Only they'll have to.
it is not easy, my lord, because I put the para number so that your lord's is
Sitting here, we have taken that obligation. So we'll have to do that.
just to assess, my lord. You
Yes.
know that ಅಲ್ಲಿ ಹೋದ್ರೆ ನಾವೆಲ್ಲ ಮಾಡಿ ನಾವಿಬ್ಬರಲ್ಲಿ ಹೋಗಿ ಕಾಫಿ ಕುಡಿತೀವಿ, ಜಗಳ ಆಗ್ತೀವಿ, ಆಮೇಲೆ ಕಾಫಿ ಕುಡಿತೀವಿ.
ರೆಡ್ಡಿ ಅವರು ಎಲ್ಲರಿಗೂ ಕಾಫಿ ಕೊಡಿಸ್ತಾ ಇದ್ದಾರೆ ಬೆಳಗಿಂದ. ಅಲ್ಲ ಮಿಸ್ಟರ್ ರೆಡ್ಡಿ? You are giving coffee, getting coffee for everybody. So one more. Yes.
Page 4 ಬಂದ್ರೆ ಎರಡು.
We'll go through that. Yes. And section 3 of the Government Grants Act.
And Lieutenant's area, my lord, will not be treated as forest ಅಂತ ಹೇಳಿ that. ಅದರ ಬಗ್ಗೆನೂ ಎರಡು ಜಡ್ಜ್ಮೆಂಟ್ ಇದೆ. They say that, my lord, Government Grants Act section 3, my lord, overrides everything else. 2014, 14 SEC 304.
According to the terms of the grant, notwithstanding.
Must take effect according to tenor of the grant.
Tenor.
And Government, my lord, grant is governed entirely by the terms of the grant. That's, my lord, 2012 7 SEC 27. Yeah. That's all.
Yes, Mr. Ron, you want to make any submission on these judgments?
there are other petitions with regard to rent, my lord. Whether they want to make submissions, because, no, that's, I had requested, my lord, that these petitions can be heard little later, because what rate of rent will be applicable will depend on the nature of land, my lord, whether revenue.
4706 succeeds.
Yes.
Then
Four petitions can be taken up, my lord. 4706, 40364, 47317, 44445, which are all CCF order. After his lordship, Justice Bopanna's order went in appeal. Court said CCF should give a finding. He has given a finding, it's reserve forest. Those have been challenged. So if these four are taken up, Lord, the others are all pertaining to where we have made a demand for rent. That depends whether it's a forest or revenue, Lord. Because
Once
they are
there is
saying
a
they are liable to
finding
pay
on
only
four-
assessment.
If they succeed in 4706, you can't
Correct.
claim
Then
any
the rent also will
If they
change.
fail in that, then you can claim whatever.
Correct.
4706 on Tramale.
Allah, with the, it has to be considered together, because now the CCF has come to a conclusion that it's reserve forest based on the
CCF order in all these leases is only in 4706.
No, no, no.
That is what you argued.
Four
till now.
writ petitions are there, my lord.
4 writ petitions.
4706.
What happens is, in those, my lord, there are also lease renters.
No, no, no. No, my lord.
So
4706 pertains to 999 to 99, my lord.
Yes.
3 writ petitions, 406, 40364, 47317, 44445 of 2013. That would be, my lords, 14.2, 14.3,
What is that
14.4.
about?
So if these four are first,
No, what is 364, 317, 445?
these are all pertaining to CCF order. After the writ appeal direction,
So similar orders have been passed in this.
CCF has now said that these are reserved forest. What just Honorable Justice Bopanna had held, my lord, that was carried in writ appeal by them, my lord. And writ appeal
4706 reduced it to 999 to
299.
364, 317, 445 said it's a reserved forest.
Reserve.
Both will have to be.
So all these four, if decided together, my lord, then rent and other aspect can be decided later. My lords may have it on 12th or 13th. I'll give my reply. Sorry, I just, ಅವರೆಲ್ಲ ಅಷ್ಟೆಲ್ಲ produce ಮಾಡಿದ್ದಾರೆ just ಒಂದ್ಸಲ.
Now there's judgments if he has to.
I'll just take a look and.
You can find your written submissions if you want.
Yes, I'll prepare by then and I'll submit.
We also like to listen to him, so where is he? On 12th, you ask him to make a submission. Heard further arguments of Shri Udayawala, Learned Senior Counsel, rejoinder arguments of Shri Udayawala,
Yes.
Learned Senior Counsel. Since a memo along with citation has also been filed, the same is taken on record. Since citations have been filed, the Additional Advocate General seeks for accommodation to go through the same and make his submission. Released on 12th at 2:30 p.m.
ಮ್ಯಾಟರ್ 4:30 ಸೆಟಲ್ ಮಾಡಿದೀವಿ. ಮಾರ್ನಿಂಗ್ ಮೆಮೊ ಹಾಕ್ಬಿಡ್ತೀವಿ. ಇನ್ ದ ಮೀನ್ ಟೈಮ್ ಲೆಟ್ ದಮ್ ಓಪನ್ ದ ಅಸೋಸಿಯೇಷನ್. ಅದೊಂದು
Shaman said he'll get it open.
I think he'll get it done. We'll follow it up.
Where's Shaman?
No, I'll follow up with him.
Said he'll give instruction. A serial number?
Serial number 34, 38.
List one, serial number 38, release tomorrow at 2:30 p.m.
2:30. We'll bring the joint memo and we'll close. ಅವ್ರಿಗೆ ಕೋಲ್ಡ್ ಬಿವರೇಜ್ ಕೊಡ್ಸಿದೀವಿ.
ಅದಕ್ಕೆ ಕೂಲ್ ಡೌನ್ ಆಗಿದ್ದಾರೆ. ಕಾಫಿ ಕೊಡ್ಸ್ಬೇಡಿ ಅಂತ ಅದಕ್ಕೆ ಹೇಳಿದ್ರು.
ಕರೆಕ್ಟ್ ಆಗಿ ಹೇಳಿದ್ರು.
Weather was not easy for us to handle, but
We have to ultimately.
Don't let a third party get in.
Yes.
that's essentially the whole concern.
If that
In our
happens,
affairs.
then
Correct.
Anyway, we are also happy the cooperation of the Raghavendra advocates. They have agreed to some suggestions which came about. We could arrive at a point.
We'll reduce it into writing, Lord, and then submit it.
And then we'll have to see what is to be done if a fresh election is to be held.
Oh, set aside the administrator. We have asked. ನಾಳೆ ಕೇಳ್ಬಿಡು.
But then who will be the officer?
Lord, they have.
Even that, what we have done is, we have taken a decision in this form. We'll stick to this side. And while there is 26th of September, we hold the elections. 25th of August is the last day for payment of subscription. Returning officer will be appointed by the Advocates Association Bangalore President to ensure neutrality in the elections. So election responsibility we are undertaking. And we have the association advocates. They will.
Returning officer was Justice Adi Alva. He can be there.
ಅದೇ ಯಾರೋ ನ್ಯೂಟ್ರಲ್ ಪೀಪಲ್ ನ ಒಂದ್ ಮೂವರ್ನ ಕಳಿಸ್ತೀವಿ ಇಲ್ಲಿಂದ.
By change, he could continue. And all the enrollment and in terms of Supreme Court direction as regards the reservation, everything has
Yes,
been followed.
that will comply, my lord. 3 persons, neutral persons, I'll consult everybody and we'll send it. Neutral. They'll handle it.
That is also addressed.
Our council or no, ಇದು ಮಾಡಿ.
We'll consult everybody and
they will have to give you the.
Yeah, yes.
Recognition.
Advocates Association Bangalore, we have taken a stand that the Bar Council cannot regulate the advocates associations. So we have filed writ petitions and in that we are having interim office. But there are other bar associations belongs to which the Bar
ಇಲ್ಲ ಅದೆಲ್ಲ subscription
Council
open
we are
ಮಾಡಿ.
not going to give you the weapon and stance. If you don't adopt our bylaws or don't become regulated in terms of our bylaws. They have adopted their bylaws. We have taken a stand on behalf of Advocates Association Bangalore that Bar Council cannot regulate advocates association.
ಅಂದ್ರೆ except prescribing a model bylaw.
No, even that we have told is that he is.
For purpose of welfare act.
You adopt the model bylaws where you want, you don't want to do this. It is not.
Yes.
Have one common thing for everybody. Don't do this. Result in further complications.
ಅಲ್ಲ, we are not at loggerheads with Bar Council. We have no issue with
Both
that.
the Bar Council and the associations need to work together.
Yes.
For the betterment of for a lot of things.
Yes.
Nobody in Martin.
Lord, the association is unlocked.
Unlocked.
ಆಗ್ಬೋದು.
Please.
Morning we'll give that.
2:30.
2:30.
Please.
List number 2, serial number 15. Varun J. Patil.
Pertaining to this, the amendment, I filed the amended petition on 29/7.
Have you carried out the amendment?
I'll take the file and carry out the amendment. It may be.
We have already argued even before.
Some written submissions were to be filed.
Complete, we have filed it also.
Been filed.
We have also filed it.
Now it comes to us. Both the councils submit that written submissions have been filed, reserved.
Please.
We place the judgments, your lordships. I'll serve a copy and place the judgments. I've extracted the paragraph numbers.
You can't file anything which was not referred to during the argument.
It was referred, your lordships. Your lordship said that extract the paragraphs in the memo.
Extract ಕೊಡಿ ಏನ್ ಅಡಿಷನಲ್ ಏನು ಕೊಡಬೇಡಿ ಆಮೇಲೆ ಅವ್ರಿಗೂ ಕೊಡಿ ಒಂದು ಕಾಪಿ. Yashwant Boyer was not referred to, Zenith was not referred. We don't know what about Yashwant Boyer was definitely not referred.
Yashwant Boyer. Please, I'll leave it to your lordship.
If you have not argued it, don't, otherwise then we'll have to give them an opportunity to make their submission on that. Don't just give it like that.
Please, I'll leave.
Yenamma, you want to make any submission on this?
My lords, I think we have explained in our previous submissions, all these things are covered.
These judgments.
Please.
The counsel for the petitioner has filed a memo of citations. The same is taken on record, reserved.
Great.
Serial number 16, A.V. Amarnathan.
Petitioner, my lordship.
Respond number 68.
Yes.
In this case, my lord, they have filed rejoinder. Copy is not served on.
Rejoinder has been filed by? You have filed.
We have filed a statement of objection for the report. They have filed the rejoinder.
Yesterday they have filed.
Yesterday.
Copy is not.
Copy ಕೊಡಬೇಕು. The counsel for the, you have filed it in the registry, is it?
Yes, my lordship. Yesterday only I filed in counter.
Received. The counsel for the petitioner has filed rejoinder to the statement of objection filed in respect of the commissioner's report. Copy thereof, you have received copy?
Yes, ma'am.
Copy
Today,
thereof
we have just
has
received.
been served on the council for respond number 1 to 3, as also learned AGA, who seek for and are granted a week's time to go through the same and make the submission. Relist on 17th August.
17, Siri Rajshekar.
Manas, this is a matter with respect to non-issuance of.
Fireworks.
Please, Manas, please. Manas. Now there is a gazette notification, my lords.
You wanted to go through it and make some submission.
My lords, it is very clear, my lords. I shall pass on that last occasion you have passed on.
Nothing more remains then.
My lords, it is only prospective. Kindly see, my lords, page number 4.
The last Deepavali is over.
Please, my lords.
Next
My lords, now
Deepavali-
they have to issue me the license, my lords. It says that in exception.
For next Deepavali, you'll have to follow these bylaws.
Yes, yes, but it says exception, the provisions of sub-rule 4 and 5 shall not apply to the existing fire shops covered under the license form LE5.
Yes, Ms. Shanti Bhushan.
Please, my lord, I
have
did
to go
not have
through.
the copy of the petition, I just received it.
That council
Just
for the
make my
petitioner submit that, what is this? The explosive rules 2008 have been amended, and the amended rules would be applicable to the petitioner. And DSGI seeks for a week's time to go through the same and make a submission. Relist on 17th.
Please, please.
Please.
18,
I-
date.
Last date, my lord. The election commission had sought for 1 week's time, my lord.
Yes, Mr. Dodwad.
इन्होंने मेमो जो दिया ना उसमें वो कह रहे हैं कि उसका एपिक कार्ड में नहीं है बट बाय बाय करो what is he saying? He's saying
My lord, page number 2 of the memo kindly be looked into, my lord.
Sitting leave. 44 ಕೊಟ್ನಲ್ಲ serial number 30ನೇ ತಾರೀಕು.
Epic issued is genuine, and that the family has been residing in India for generations.
ಅಲ್ಲಿಂದ list ತಗೊಳಕ್ಕೆ. 30ನೇ ತಾರೀಕು sitting leave ಬಂದು.
Aditya is not happy with it.
Certainly not for the reason it is, my lord. If you also could kindly turn to page 23 of the petition.
Now we can't reopen all these things. We
No,
can't
my lord,
look into all these.
In fact, my lord, I just brought
If you're
this.
saying anything would.
What if I'm saying something, be contrary to this.
Let me just show this, my lord. This is.
That is the reason, my lord, my submission in the previous case, my lord, if they come, if they file something, my lord, that would end the matter. Because now they have filed the petition. Yeah, they have filed the memo.
They're not coming, what to do?
They filed, my lord. They're saying that this is genuine now.
They're saying, my lord, I can't go contrary to this.
I just wanted to show, my lord, just this one paper. No, my lord, this is just to understand, just this one thing. This is my own SIR. I am trying to get my name linked, my lord. And the name that is allotted to me in the 2002 list, my mother is my sister. As per the 2002 voter list that is maintained over here.
He will be very happy.
My lord, she's very disappointed. But my point is, my lord, these kinds of mistakes. In fact, I spoke to several of my friends who are senior counsels over here. Each of them, their 2002 entries in the voter list, their names are spelled wrong. Of course, I didn't want to bring their printouts, but I verified it myself. Here, my lord, the only thing that was said is that there's a discrepancy in the name,
Why do you
discrepancy in
need to
the
get to
date
know
of birth.
This come. Both of you should know when to stop.
That apart, my lord, if your lordship could kindly come to page 23, annexure D. His own record, school certificate says, my lord, he was born on 1st January 1986. What is being produced here before my lord is now, my lord, date of birth is 2/1/1994. Both are his own documents.
Which are all been verified now by their government, my lord.
You're done your SIR.
My lord, now what, we'll have to accept it, my lord, that is different, sir. But my learned friend is pointing out, both are his documents now.
That is why we are telling him not to point out anything. We can go unless this is challenged.
That cannot be challenged by anyone, my lord.
Why anything can be challenged by anybody. The petitioner is before this court seeking for the following reliefs. By way of the impugned order dated 29/8/25 at Annexure A, the FRRO had directed the petitioner to be restricted to the home of Hope, Doddagubbi, Bengaluru, under the Kothnur police station limits.
On submission with regard to the judgment, my lord, if my lord can refer to it, my lord, that the voter ID card will not confer the citizenship. Because what has been said, my lord, that's it.
Para 39 and 40.
Suman, my lord, the facts are completely different. Where in fact the detainee's uncle had supposedly gone to court.
You are 230 list.
Now, voter identity card, Aadhaar card, PAN card, passport.
So that is the position. my lord. Actually, there is no document which says, which you hold, which is proof of citizenship today.
Which is the document for citizenship?
Citizenship act.
This is the document that we have to rely on.
Citizenship by birth. So the birth certificate would be the document under the Citizenship Act which one has to produce to prove citizenship. And
Many
if
of
you're
us here
claiming
don't even have a birth certificate. And the birth certificate would not reflect our name also.
Lord, with respect. With respect.
Get into all that.
But to give credit, my lord, my learned friend had said on the last date that if his SR is through, then this matter is closed. He did make that submission.
Sometimes instructing counsels are more restricted to the home of Hope, Doddagubbi, Bengaluru, under the Kothnur police station. This said order had been challenged before this court, and the aforesaid reliefs were sought. During the pendency of the above matter, various inquiry reports were filed, affidavits were filed by various initially the veracity of the SIR, veracity of the document produced by the petitioner would have to be ascertained. Since the respondent had contended that the Election Council of Commission of India was directed to verify and make the submission. Today, a memo has been filed enclosing the letter dated 22nd July 26 of the Election Commission of India to the Chief Electoral Officer, West Bengal, as regards the genuineness of the EPICs issued to the petitioner and his family members, as also the reply of the Chief Electoral Officer, West Bengal, dated 29/7/26. The reply of the Chief Electoral Officer reads as under. In view of this said reply, that the EPIC issued to the petitioner is genuine, the letter of the, as can be seen from the letter of the Chief Electoral Officer, Additional Chief Electoral Officer, an inquiry had been conducted by the Additional District Magistrate Nadia, and same was submitted on 29/7/26, along with all supporting documents, evidence, and field verification statements. As per the said report, it is indicated that the EPIC issued to the petitioner is genuine and that the family has been residing in India for generations. In that view of the matter, in view of the categorical statement made in relation thereto, the FRRO would not have any jurisdiction on the petitioner, and the order dated 29/8/2025 at Annexure A would not be sustainable. As such, this court passes the following order. Writ petition is allowed. A certiorari is issued. The impugned order bearing number so and so dated 29/8/25 passed by 5th respondent FRRO at Annexure A is quashed. Where are you now? Now you are out of the.
From December, my lord. In December, I was out. I had been let out. I continue to stay out.
Since the petitioner is no longer a resident of so and so, there is no need to pass any orders in respect of prayer number 2 sought for in the petition.
Grateful, my lords.
Serial number 19, PN Harish.
This matter was heard with regard to the COVID exemption.
Mulad, I appeared in item 18. Unfortunately, Mulad, because the item was showing 17, my video was not turned on. I couldn't assist your lordships. I was appearing for State of West Bengal in item 18.
What do you want to submit?
Mulad, your lordships have correctly recorded everything that was stated in the affidavit. Because of the change in government, the previous council had said that because there would be a change in stance probably by the government. So there is no change in stance by the government. Your lordships may record my statement, and your lordships may. There was an affidavit filed by State of West Bengal, respond number 6 to 9.
Have you filed Wakalatnama?
Yes, my lord, I filed my Wakalatnama, my lord.
When did you file? There's
Because I
nothing
am
on
the
the
new
file.
standing in the Supreme Court for.
There's nothing. Your Wakalatnama is not on the file. It's not come on the file. Yes, Mr. We'll have it on another day. We'll have date put together. MTP. MTP at 2:30. Report banta MTP.
Received. List number 2, serial number 43.
One submission I want to make, 19. You'll also permit me to file that amended petition in the office.
Serial number 19?
19.5 ನಾವು ಒಂದು amend ಮಾಡಿದ್ರು, ಒಂದು additional prayer ಮಾಡಿದ್ದಕ್ಕೆ. I will file it in the office.
Carry out the amendment, file it. Date ಕೊಡ್ತಾರೆ.
For petitioner and 43.
Yeah.
Report must
43.
Have.
Yes.
No, 43. Matters going on. Matters going on.
Yes, they have approved it. Please hold. Petition. Petitioner is before this court seeking for the following reliefs. The petitioner is a minor aged about 14 years and is represented by mother and national guardian, seeking for permission from this court for medical termination of her pregnancy, which arose on account of a sexual offense committed on her.
Page 16 is there.
Submission made by learned counsel for the petitioner is that the minor victim of the sexual assault does not intend to continue with the pregnancy resulting out of a sexual offense. His further submission is that the minor intends to exercise her right to body autonomy and terminate the pregnancy, which she cannot do without the specific orders of this court, since the pregnancy is 28 weeks. It is in that background that the petitioner was referred to the medical board constituted at respond number 22 hospital. A report of the medical board dated 4/8/26 addressed to the registrar judicial has been placed on record. A perusal of the said report indicates that the pediatrician has opined that medical termination of pregnancy can be carried out. However, in the event of there's a caution expressed that there may be a delivery due to fetal viability, in which case the admission of the baby to the NICU may be required. The radiologist has opined that the pregnancy would affect the mental health of the minor, would cause psychological stress apart from financial burden, and in terms of the scan done, a medical termination of pregnancy could be carried out. The anesthetist minor is fit for the proposed procedure. The obstetrician has indicated that the minor is not mentally fit and is not willing to continue the pregnancy. And for that reason, he has not said anything. Obstetrician has not said anything. It's only recorded there. This. The final opinion of the board is that the termination of pregnancy can be considered in view of the minor being 14-year-old survivor of sexual assault, and she not being mentally fit to carry on a pregnancy and care for a newborn child. The report of the medical board being categorical in that nature, to that effect, taking into consideration that the minor is a victim of sexual assault and she does not wish to continue with the pregnancy by exercising a right to body autonomy, this court passes the following order. Writ petition is allowed. The second respondent is directed to carry out the procedure for medical termination of pregnancy on tomorrow, on 5th August 2026. Respondent number 2 is directed to preserve the terminated fetus for the purpose of DNA examination and analysis in accordance with the requirement of investigation in crime number 250 of 2026, registered by the Annapurneshwari Nagar Police Station. The respondent are directed to comply with the directions issued by this court in WP number so and so. The Karnataka State Legal Service Authority is directed to consider the application of the petitioner for release of victim compensation as may be permissible at the earliest. A report of the medical superintendent of second respondent on completion of the procedure to be filed within a period of 15 days from the date of completion of the procedure. A report of the first respondent to be filed within 3 months from today, from the date of completion of the procedure as regards the compliance with the SOP and the action taken for the well-being of the minor.
My lord, serial number 90, my lord. My lord, yesterday also made a mention, my lord.
End of the list
One submission.
for the emergency.
Vijay Prasad.
Vinay Prasad,
Vijay Prasad.
Vijay Prasad.
Serial number 34, my
Kumar.
lords. My lords, I appear for the petition.
End of the list.
Please.
Yes.
My lords, the present petitioners are both major in age. They are present before this honorable court. And they had solemnized their marriage on 22/7, on 27/7/2026. The photographs and the receipts are present before the, my lords, at Annexure B1 and Annexure C series, please. And subsequently, the petitioners, sorry, the parents of the petitioner.
Made your submission in the morning. Yes. Madam, get the statement recorded. There is a threat from the parents. The intercaste marriage.
No, same caste.
Same caste.
Same caste.
Learned AG accepts notice for respond number 1 to 4. Submission of learned counsel for the petitioners is that petition number 1 and petition number 2 have married each other 27/7/26 at Sri Bajrangi Temple, Edure Village and Obli Kungal Taluk. Both of them being major in age. The marriage has been conducted of their free will and volition. There is no other condition existing which will make their marriage void or voidable,
please,
under the applicable law. The submission of learned counsel for the petitioner is that the parents of petition number 2,
please,
have not agreed to the marriage and are inimically disposed towards them. A complaint is alleged to have been filed by the parents with
respond number 4.
Respond number 4 police station. And is pursuant thereof that though no notice had been issued, the respond number 4 has been calling upon the petitioners,
please,
to attend to the said police station. Taking into consideration that the petitioners are married to each other, where is the certificate?
My lords, photographs and this one are there. 27/7. The certificate is not there.
Marriage certificate ಏನಲ್ವಾ?
Inna sadhyak bandila. It's been almost about 5-6 days.
There is the application at least.
Page number 27 and 28 are the photographs, please, my lords.
That we saw. You not submitted any application for registration.
No, right, as of now, no. It's been almost 5 days.
Submission made by learned counsel for the petitioner. That petitioners are married to each other. You have made the submission.
Please, no, the present petitioners are.
The respond number 3 is directed to get the statement of the petitioners recorded before the magistrate in Bangalore rather than in Turvekere, where the alleged complaint has been filed. and take the said statement into consideration for the purpose of investigation in any complaint, if at all filed by the parents of petition number 2. The said statement to be recorded on 6th August 2026.
Please.
The learned AGA is directed to inform respondent number 4, 3 and 4 about the above order and not insist on the petitioners to appear before the respondent number 4. The statement after recordal shall be placed on the file of this, in the present matter. Relist on 17th August.
Please. And delivery.
The respondent shall act on a printout of the uploaded copy of the order without insisting on a certified copy.
My lord, seal number 90, my lord. Yesterday also madam mentioned, my lord. Seal number 90. ಸೋಮವಾರಕ್ಕೆ ಅಂತ ಹೇಳಿದ್ರೆ next week, my lord. ಅದು ಇವತ್ತು ಬಂದ್ಬಿಟ್ಟಿದೆ.
ನಿನ್ನೆ ನೀವೆಲ್ಲ ಪಾಪ ಅವ್ರ ತಲೆ ಮೇಲೆ ಕೂತ್ಕೊಂಡು
ಇಲ್ಲ ನಾನ್ ಕೂತ್ಕೊಂಡಿಲ್ಲ ಸ್ವಾಮಿ.
ಎಲ್ಲರೂ ಹೇಳಿದ್ರಂತೆ ಅವರೆಲ್ಲ ನಾಳೆ ಹಾಕ್ಬಿಟ್ರು.
ಇಲ್ಲ ಸ್ವಾಮಿ. My lord, serial number 90 ಒಂದು next Tuesday ಗೆ ಹಾಕೊಳ್ಳಿ ಸ್ವಾಮಿ. 11th ಗೆ.
Even the court officer has been sitting from morning to here. You don't put that kind of.
I did not, my lord. I did not.
Not you, everybody. All of you know it. We don't need to say that. Dates will be given so that it will reach.
Please.
If you put that kind of pressure, it doesn't work. ಮತ್ತೆ ದಿನ ಬರ್ತಾ ಇರತ್ತೆ ಹೋಗ್ತಾ ಇರತ್ತೆ ಅಷ್ಟೇ.
Your lordship's kind permission. Serial number 29, my lord. I have been requesting for 2 months, my lord, kindly. Your lordship taken one day, government has to file an affidavit. ಅದು ರೆಡಿ ಇದೆ. ತಾವು ದಯವಿಟ್ಟು ಇವತ್ತು ಬರ್ಬೇಕಾಗಿತ್ತು. ನಾಳೆಗೆ ಸೇಮ್ ಲಿಸ್ಟ್ ಅಲ್ಲಿ ಬರ್ಲಿ ಸ್ವಾಮಿ. ಇಲ್ಲ.
We have not been working for the last 2 months.
No. But I have been requesting your lordship, somehow it is not, my lord, kindly.
Not changing the sequence of matters, whatever comes up.
Yes, my lord, let it come tomorrow in the same list, 2:30. Lord, because, my lord, this is, they have obtained an order, my lord, your lordship order only.
ಎಲ್ಲ ಇರೋದು ನಾಳೆ ಬರ್ಬೇಕಾ?
ನಂದು ಒಂದ್ ಹೇಳ್ತಾ ಇದ್ದೀನಿ, ಬೇರೆ ಎಲ್ಲ ಗೊತ್ತಿಲ್ಲ. ಬೇರೆ ಎಲ್ಲ ಬಂದ್ರು ಬರ್ಲಿ ಸ್ವಾಮಿ, ಪರವಾಗಿಲ್ಲ. ಅದೇ 29.
ಇನ್ಸ್ಟ್ರಕ್ಷನ್ಸ್ ಇದೆ, ಅದು ಹೇಳ್ಬಿಡ್ತೀನಿ. ಫಸ್ಟ್ ಲಿಸ್ಟ್ ಎಲ್ಲ 28/8. ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್ ಸೀರಿಯಲ್ ನಂಬರ್ 19 to 30 11/8, 31 to 40 12/8. ಫಾಸ್ಟ್ ಓವರ್ಸ್ ನಾಳೆ.
ಮೇಡಮ್
29 ಮಾತ್ರ.
ಮೇಡಮ್ ಕೋರ್ಟ್ ಆಫೀಸರ್ ಮೇಡಮ್, ನಂದಕ್ಕೆ 10ನೇ ತಾರೀಕು ಕೊಟ್ಟಿದ್ದ, ಅದಾದ್ರೂ ಕೊಡಿ.
ನೀವು ನೆನ್ನೆ ಇವತ್ತಿಗೆ ಕೇಳಲಿಲ್ವಾ?